Court been in our favor since 2010. And there is a stay from this High Court. So
already there is a stay.
yes, my lord.
Then-
It's been admitted.
Then what is the urgency?
My lord, we are not getting the possession of the property despite the order from the trial court.
Told ಹಾಕ್ಸಿ then ನೋಡಿ ನಾಳೆ ನಾಡ್ದು ಹಾಕ್ಸಿ.
So for partition,
Hmm.
suit has been decreed. Final decree proceedings conclude ಆಗೋಗಿದೆ.
Conclude ಆಗೋಗಿದೆ.
ಆಗಿದೆ, but I have filed an appeal challenging the order passed in the final decree proceedings, my lord. Illi this court had ordered emergent notice. No interim order was granted, my lord. May kindly be considered, my lord.
FDP ಆಗೋಗಿದ್ರೆ ಈಗೇನ್ ಮಾಡ್ಬೇಕು?
ಅಲ್ಲ, FTP ಆಗೋಗಿದೆ, but there are contentions that I have taken.
Final decree already ಡ್ರಾ ಆಗಿದೆಯಾ?
Final decree draw ಆಗಿದೆ. But
ಆದ್ಮೇಲೆ
I
ಮತ್ತೆ
wanted to produce a document before the court. There
what
an
is the
appeal
urgency now?
Urgency is that, my lords, the matter is really ತುಂಬಾ ಜನ parties ಇದ್ದಾರೆ. This court had ordered emergent notice and some of the respondents are yet to be served, my lords. In case the process has to be complete, I will take further steps ಅಂತ ಅದಕ್ಕೋಸ್ಕರ.
ನೋಡಿ ತಗೊಳ್ಳಿ ಹಾಕಿ. ಅರ್ಜೆನ್ಸಿ ಏನಿಲ್ಲ, ನೋಡ್ಕೊಂಡು ಹಾಕ್ಸಿ ಯೂಶುವಲ್ ಕೋರ್ಸ್.
ಅದು ಇದಕ್ಕೆ ಬರ್ಬೇಕಾಗುತ್ತೆ ಸ್ವಾಮಿ, orders ಗೆ ಬರ್ಬೇಕು.
ಯೂಶುವಲ್ ಕೋರ್ಸ್ ಅಲ್ಲೇ ಬರುತ್ತೆ ಆರ್ಡರ್ಸ್.
And one more matter, my lords. There's a suit for specific performance. Trial court has decreed the suit. First appellate court has directed refund of the money because the relationship is between the father and the daughter. And that challenged that before this honorable court, my lords. May kindly be listed to.
ಅರ್ಜೆನ್ಸಿ ಏನ್ ಮೇಡಮ್?
Urgency ಏನು ಅಂದ್ರೆ ಪ್ರಾಪರ್ಟಿ ಪೊಸೆಷನ್ ತಗೊಳಕ್ಕೆ ಆಗ್ತಿಲ್ಲ
ಆಯ್ತು, ಕೊಡಿ
ನಾವು.
ಕೊಡಿ ಕೊಡಿ. ಹಾ ಕೊಡ್ರಿ, ಮೆಮೋಸ್ ಇದೆಯಾ? ಅಷ್ಟೇ ಅಲ್ಲ, ಪರವಾಗಿಲ್ಲ, ಇವತ್ತು ಯಾವ್ದು ಮೆಮೋಸ್ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್
Mentioning from
Sorry,
page
sorry,
number 24, 82 and 83.
Lord, 80, my lord. For the serial number 8080. The parted in admission, I believe, my lord, RP Somchakra was required to produce type copy of the documents. Erroneous ಇದೆ, ಮೂರ್ ದಿನ ಟೈಮ್ ಬೇಕಂತವ್ರಿ.
ಅಲ್ಲ, ಅವ್ರು ಹಾಕ್ಬೇಕು, ನೀವ್ ಯಾಕೆ?
ಇಷ್ಟೊತ್ತು ಇದ್ರು, ನನಗೊಂದು ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಡಿ ಅಂತ ಹೇಳ್ಬೇಕು.
ಪಾರ್ಟೆಡ್ ಅಲ್ಲಿ ಏನ್ ಡೇಟ್ ಕೊಡೋದ್ರಿ?
ನೋಟ್ಸ್ ಮೈ ಆನ್ ಮಂಡೇ ಓನ್ಲಿ.
ಬರೋಲ್ಲ, ನಾವೇ ಕಷ್ಟಪಟ್ಕೊಂಡು ಓದ್ಕೋತೀವಿ.
ವೆರಿ ವೆಲ್ ಮೇಡಮ್.
Next matter, my lord, is 81.
81 ಹೇಳಿ.
81 ಸೋಮವಾರಕ್ಕೆ ನಾನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಸೋಮವಾರಕ್ಕೆ
Okay.
if your lordship can give me some information, I have to get it from 48 ಸೋಮವಾರಕ್ಕೆ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರಲ್ಲ.
ಹೌದು, ಅರ್ಧ ಆಯ್ತು. Then I got the information that there is another RSA pending between the brothers and others, and there was earlier suit filed for injunction that was
ಷಣ್ಮುಖ ಇದ್ದಾರಾ? ಅವ್ರಿಗೆ ಇಂಟಿಮೇಟ್
ಅವ್ರಿಗೆ
ಮಾಡಿದ್ರೆ
ಹೇಳಿದ್ದೀನಿ ಫೋನ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ ನಾನು. ಷಣ್ಮುಖ ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೀನಿ.
ಹೇಳ್ಬಿಟ್ಟು ಮಧ್ಯಾಹ್ನ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ಮೇಲೆ ಕೊಡ್ತೀನಿ ಡೇಟ್.
ಅಲ್ಲ, ಹೇಳಿದ್ದೀನಿ ನಾನು. I have already informed. I am moving ಅಂತ ಹೇಳಿದ್ದೀನಿ.
ಆಲ್ರೆಡಿ ಇನ್ಫಾರ್ಮ್ಡ್. ಓಕೆ, ತಗೊಳ್ಳಿ.
ಹೌದು, ಆಲ್ರೆಡಿ ಇನ್ಫಾರ್ಮ್. ನಾನು ಆಗ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ದೀನಿ, ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀನಿ ಅಂತ.
ಅದರ್ ಕನ್ಸೈಡ್ ನೆನ್ಸ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಯಾವ್ದಾರು ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ ಮಾಡಿ.
16/7.
16/7.
16 ಬೇಡ, ನನಗೆ ಇನ್ನೊಂದು ಪಾರ್ಟೆಡ್ ಇದೆ.
ಟ್ಯೂಸ್ಡೇ
ಅಲ್ಲ, ಟ್ಯೂಸ್ಡೇ ಅಲ್ಲ. ಇಫ್ ಇಟ್ ಇಸ್ 18th ಕೊಡ್ಬೋದಾ? 18th.
ಆಯ್ತು, 18th.
84 to 90.
Milord, serial number 88, Milord.
88.
88, respondent number 2 died on 25/3/2024. Take steps, Milord.
Appellant counsel submits that appellant number 2 is no more and hence seeks 2 weeks time to bring the LRs. Hence list this matter on. 29 ಕೊಡಿ, ಅವನ್ ಬ್ರಿಂಗಿಂಗ್ LRs ಇವೆಲ್ಲ ಮಾಡ್ಕೋಬಹುದು. 29/7.
Serial number 87, my lord.
7, my lord.
87. ಹೇಳಿ.
Appear for respondent, my lord. Kindly 1 week time may be granted.
ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ, ಕೊಡೋದಿಲ್ಲ
I
ಡೇಟ್.
am for appellant. It is first time.
ನಾನ್ ಬರ್ಕೊ ಬಂದಿದ್ದೀನಿ. ಫಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲ, ನಾನು ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ಬರ್ಕೊ ಬರ್ತೀನಿ. APT ಅಂದ್ರೆ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಪ್ರೈಸ್ ಟೈಮ್ ಅಂತ, RPT ಅಂದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಪ್ರೈಸ್ ಟೈಮ್ ಅಂತ.
ಇಲ್ಲ.
ಆಯ್ತಾ?
Kindly it not next.
ನೋಡಿ ಬರ್ಕೊ ಬಂದಿದ್ದೀನಿ.
ಇಲ್ಲ, sorry man. Kindly next week.
ಕೊಡೋದಿಲ್ಲ ಡೇಟ್.
ಬಂದಿತ್ತಪ್ಪ ಇದು.
ನಾಲ್ಕಿರೋದ್ನ ವಾಪಸ್ ಕೊಡೋಣ, ಬ್ಯಾಗ್ ಜಾಸ್ತಿ ಇದೆಲ್ಲ. ಆಯ್ತಾಯ್ತು.
serial number 86,
ನಾಟ್ ಜಡ್ಮೆಂಟ್. ಪಾರ್ಟ್ ಹಾರ್ಡ್ ಅಲ್ಲೆಲ್ಲ ನಾಟ್ ಜಡ್ಮೆಂಟ್ ಇರೋದಿನ್ನ 2 ವಾರದಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಪಾರ್ಟ್ ಹಾರ್ಡ್ ಇದೆಯಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಕು.
serial number 86, I am for R2, sir.
ಹೇಳಿ, ಏನಾಗ್ಬೇಕು? 86.
1 week time may be given, my lords.
Serial number 86.
86.
86 number 1 died on 8/7/2024.
86 ಅಲ್ಲೇನ್ರಿ?
86.
ಯಾರೋ ಸುಧೀಂದ್ರ SC ಅಂತಿದೆ.
Respondent number 1 is died, my lord. 8/7/2024, 3 days back.
Appellant counsel submits that R2 is no more. R1 is no more and files memo and hence 2 weeks time granted to bring the LRs. list this matter on 29/7.
91 to 97.
Serial number 93, my lords.
Serial number?
93.
ಹೇಳಿ ಏನಾಗ್ಬೇಕು 93.
2 weeks time ಬೇಕು sir.
No date.
ಅಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಅವರು ಇದು ರಿಟೈರ್ ಆಗ್ತಿರಂತೆ ಅದಕ್ಕೋಸ್ಕರ.
ಅವ್ರು ಕೇಳ್ತಾ ಇಲ್ಲ, ನೀವು
ಅವರೇ
ಕೇಳ್ತಾ ಇರೋದು.
ಇಲ್ಲ ಅವರೇ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ, ರಾತ್ರಿ ಹೇಳಿದ್ದಾರೆ ಅವರು.
ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಇಟ್ ಈಸ್ ಇಂಟರ್ಸೇ ಬಿಟ್ವೀನ್ ದಿ ಅಪಲೆಂಟ್ ಅಂಡ್ ಕೋರ್ಟ್. ನಾನು ಓದ್ಕೊ ಬಂದಿದ್ದೀನಿ, ಅಸಿಸ್ಟ್ ಮಾಡಿ ಕೋರ್ಟ್ಗೆ.
Serial number 92, my lord.
92 ಹೇಳಿ ಏನಾಗಬೇಕು?
One more repeated appeal, my lord, in 1759 of 2018. Common judgment with regard to.
ರೈಸಿಂಗ್ ಕೋರ್ಟ್ ಆಫ್ ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್. ಇವ್ರಿಗೆ ಹೇಳಿದಿರ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸೈಡ್ಗೆ ಟೈಮ್ ತಗೊಳ್ತೀನಿ ಅಂತ ಹೇಳಿ, ಇಂಟಿಮೇಟ್ ಮಾಡಿ, ಐ ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್.
98.
Serial number 94, my lord.
94 ಹೇಳಿ.
Appellant counsel, my lord, is not keeping well. He has undergone some surgery. Refer to
ಯಾರು? ಈ ನಾರಾಯಣ ರೆಡ್ಡಿ. ಹೌದಾ? ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್, ನೀವು ಪ್ರಾಕ್ಸಿ ಅಲ್ಲ. ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ submits that counsel on record for appellant his underwent surgery and seeks time and hence list this matter. ಏನು 26 ಹಾಕ್ಬೋದಾ? 29/7
29.
ಇಲ್ಲ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಆಗಸ್ಟ್. ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಇನ್ ದಿ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಆಗಸ್ಟ್.
98.
98/1 ಅಲ್ಲಿ.
ಹ್ಮ್
98/1 ಅಲ್ಲಿ ಕ್ಲಾಸ್ ಅಪೀಲ್ ಅಲ್ಲಿ. I to file objections. You are not furnished the IA copy. Delay is not 2.5 years.
ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ರೀ? ಬಂದಾಗ ಏನ್ರಿ ಅದ್ ಯಾಕೆ ಟೈಮ್ ಕೇಳ್ತೀರಿ? ಈಗ ಅದರ್ ಸೈಡ್ ಇದಾರ? ಇಲ್ಲಲ್ಲ,
ನಾನು intimate collect
ಅದರ್ ಸೈಡ್ ಇದಾರ ಈಗ.
collect ಮಾಡ್ಕೊಳ್ತೀನಿ.
ನಾವು ಮಾಡ್ಕೊಳ್ಳಿ, ಆಮೇಲೆ ಬಂದಾಗ ಹೇಳಿ. ಈಗ ಏನು ಟೈಮ್ ಅರ್ಜೆಂಟ್ಮೆಂಟ್ ಯಾವ್ದಾರು ಇದ್ರೆ ತಗೊಳ್ಳಿ ಅಂದ್ರೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಈಗ ನಾನು ಕಾಪಿ ಕೊಡ್ಸಕ್ ಆಗ್ತದೆ.
Objection ಹಾಕ್ಬೇಕು ಅದರಲ್ಲಿ.
ಹಾಕಿರಂತ ಆಮೇಲೆ ಹೇಳಿ.
59 to 104.
99, my lord.
ಹೇಳಿ.
Next week it will.
ನೋ ಕೌನ್ಸಿಲ್ ಅಲೌಡ್ ಮಾಡಿಫೈ ಮಾಡಿದಾರೆ ಅಷ್ಟೇನೆ. ನೆಕ್ಸ್ಟ್
Lordship, serial number 104, my lord.
104 ಹೇಳಿ. ಏನ್ ಗೌರ್ಮೆಂಟ್ ಏನ್ ಹೇಳಿ ಅರ್ಜೆಂಟ್ಮೆಂಟ್ ಗೆ?
Counsel on record is not feeling well, my lordship. He is suffering from pneumonia as for the
ಲಾಸ್ಟ್ ಟೈಮ್ ಏನು ಬಸವಣ್ಣ MD ಅವರ?
Yes, my lordship. He is suffering from pneumonia.
ನೀವು ಸೇಮ್ ಆಫೀಸರ್?
Praxi, my lord.
Proxy counsel submits that counsel on record is suffering from pneumonia and hence list this matter in the second week of August.
Serial number 102.
ಹೇಳಿ.
Taken up on Monday, my lords.
No counsel, no date.
105.
ನಾವು ಓದ್ಕೊ ಬರೋದು, ನೀವುಗಳೆಲ್ಲ ಬೆಳಗ್ಗೆ ಬಂದು ಇಲ್ಲಿ ಟೈಮ್ ಕೇಳೋದು.
105 to 111. 112 to 114. 115 to 118.
118, my lord. 2 weeks time granted.
118 ಅದರ್ ಸೈಡ್ ಇದಾರ? ಇಲ್ಲ ಸರುಡ. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ seeks time, list this matter in the second week of August.
119 to 123. Orders matter.
123, my.
123 ಹೇಳಿ ಏನಪ್ಪ?
ನಾನು ಸ್ವಲ್ಪ ಡಾಕ್ಟರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್.
123 ಅದರ್ ಸೈಡ್ ಇದಾರ? ಇಲ್ಲ
ನಾನು ಅಮಿತ್ಗೆ ಹೇಳ್ತೀನಿ.
ಹೇಳಿದಿರಾ?
ಮಂಡಿಗೆ ಹೇಳ್ತೀನಿ.
ಹೇಳಿದಿರಾ?
ಇನ್ನು ಹೇಳಿಲ್ಲ.
ಹೇಳಿ, ಆಮೇಲೆ ನೋಡೋಣ.
My lords, serial number 63, my lords. I'm
63.
withdrawing them.
ಕೊಡಿ, ಮೆಮೊ ಕೊಡಿ ಅವ್ರಿಗೆ.
The matter is settled out of court.
ಇಟ್ಟಿರ್ರಿ, ಮೆಮೊ ಇಟ್ಕೊಡಿ. ಫೋಟೋ ಕೇಳ್ದಾಗ ಕೊಡಿ, ಬಂದಾಗ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬಂದಾಗ ಕೊಡಿ.
Orders matter serial number 1.
The petitioner in this case, my lords.
Just counsel.
My lords, the
Wait,
draft
Mr.
administration bond is already provided, my lords. I have to file the final administration bond a week's time.
Madam, nothing is there in the.
This is the draft administration bond and payment. This is the registered division. Administration bond.
ಹಾಕಿದ್ದಾರೆ. ರಿಜಿಸ್ಟ್ರಾರ್ ಮುಂದೆ ಅದ್ ಇದು ಮಿನಿಸ್ಟೀರಿಯಲ್ ಆಕ್ಟ್ ಏನ್ ಬೇಕು ತಗೊಳ್ಳಿ. The council has furnished the draft administration bond. And hence register is directed to process the same. ಅಷ್ಟೇನಾ?
Serial number 2.
Serial number 2 also I appear for the petitioner, my lords.
Along with the delay
A
application.
day's time to file the inventory and accounts. It is ready, my lords. Tomorrow I'll be filing the same.
Council submits that he is going to file tomorrow and hence 1 week time granted.
Obliged, my lords.
Compliance of office objections in IA 1 of 24 and supplementary affidavit of assets Yes, Lisa Ronald.
It has been filed, my lord.
Some compliance is there. An IA.
Petitioner address does not tally with the petition. Affidavit not forthcoming in IA one for dispensation.
There are office objections, you comply. 1 week time granted to comply with office objections.
Petitioner number 1 address does not tally with the petition.
There are 3 office objections.
I
You
will-
want verify. and
I will do
comply
that, but
Comply it.
1 week's time, my lord.
1 week time granted.
4.
Compliance of office objection raised on wakalat filed by Srimati Ananya. Right on behalf of R3.
It's me, your lordship.
Huh?
I have to identify it. I'll do it right now, your lordship.
Furnishing, the counsel for R3 is directed to comply with office objections. Next, furnishing PF
6 to 9, my lord, they remained ex parte before the trial court.
memo ಆಗ್ತೀರಾ dispense ಮಾಡಕ್ಕೆ? Counsel for the appellant has filed memo to dispense the notice against R 6 to 9. Since they were placed ex parte before the lower court. And hence, notice against them is dispensed at the risk of the appellant.
Your lordship,
Next
file
ಏನಾಗಬೇಕು? Admission ಆಗಿದೆಯಾ ಅಥವಾ ಇಲ್ಲ?
File.
Admission ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ. Post the matter for admission.
Your lordship, file may be given right now. I'll comply. I'll comply it right now.
I have already given madam time. You comply it, that's all.
5.
I appear for
Date in the last week of July.
Lords.
Hello, madam. Last week of July.
Lord, sir.
5.
I appear for appellate law.
Hmm.
Lord, I may be permit
Compliance of office objections scrutiny.
some, the certified copy needs to be filed.
Ah.
I'm ready with certified copy. I may be permitted to,
Receipt filed by counsel for appellant. What is that receipt?
Lord, the
Cost
last.
impose ಆಗಿತ್ತಾ ಏನದು?
ಹೌದು ಸ್ವಾಮಿ, 1,000 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಆಗ್ತಿದೆ. That I complied.
ಕಾಸ್ಟ್ ಹಾಕಿದ್ರು ಕಂಪ್ಲೈ ಮಾಡಲ್ವಾ?
ಅಲ್ಲ ಈಗ
ಮೊದ್ಲೇ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಹಾ.
ರಿಕಾಲಿಂಗ್ ಹಾಕಿದ್ದಾರೆ.
ಹೌದು.
ರಿಕಾಲಿಗೂ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಾ?
ಇತ್ತು ಐ ರಿಮೂವ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಅದ್ರಲ್ಲಿ ಡೇಟ್ ತಪ್ಪಾಗಿತ್ತು. ಐ ಮೆನ್ಷನ್.
ಈಗ ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಅಂತ ಮಾಡಿದೀವ? Time as spread for it is hereby granted to subject to payment of cost of rupees 1,000 payable at registry. 2 weeks time to comply with office objections. So why you have not complied it?
Office objection on the IM, Lord. That is, I complied. Unless in recalling the order, I may not be permitting to.
ಯಾವ್ದು ಪ್ರೀ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇರೋದು ಮೇನ್ ಮೇಲ ಅಥವೇನು?
ಮೇಲ್ ಮೇಲೆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
Pending consideration ಕೊಟ್ಟಿದ್ದೀವಿ. Meanwhile, the learned counsel for the appellant is directed to comply with office objections on IA. One of
ಅದ್ ಮಾಡಿದೀನಿ sir.
2019 as well as on main ಅಂತ ಮಾಡಿದೀವಲ್ಲ?
ಮೇನ್ ಐಎ ಮೇಲೆ ಮಾತ್ರ ಅಂತ ಹೇಳಿದ್ರು. ಹಂಗಾಗಿ ಐಎ ಕಂಪ್ಲೈ ಮಾಡಿದೆ.
ಎರಡು ಆರ್ಡರ್ ಇದೆಯಲ್ರಿ? In the meanwhile,
ಆಯ್ತು ಸ್ವಾಮಿ, ಇವತ್ತೇ ಮಾಡ್ತೀನಿ.
appellant is directed to comply with office objections on
Sir-
IA 1 of 2019 as well as on main appeal ಅಂತ ಬರ್ದಿದೀವಿ.
I'll-
Order is very clear.
ಐ ಡೂ ಇಟ್ ಇವತ್ತೇ ಮಾಡ್ತೀನಿ. ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಒಂದು.
Pass over.
Please.
Serial number 6. Mahesha Rupil.
Notice to R6 and R7.
35ಕ್ಕೆ ಕಟ್ಟಿದೆ ಪ್ರೋಸೆಸ್ ಫೀ.
35ಕ್ಕ
ಹೌದು.
ಹೋಗ್ ಬಂದಿದೆ ನೋಡಿ ಈಗ. ಜುಲೈಲಿ ಇದೀವಿ.
ಫ್ರೆಶ್ ಕಟ್ಟಿ.
ಫ್ರೆಶ್ ಆಗಿ ಕಟ್ಟಬೇಕು.
1 day time.
And council 6 to 1 day time to pay the PF. If PF paid, issue notice to R6 and R7.
7. Vinod Reddy.
R2 second time. Appellant counsel is absent and 2 weeks time, 1 week time granted to pay PF. If PF paid, issue notice to R2. If PF not paid within 1 week, appeal against R2 is dismissed. In non-taking of steps by the counsel for appellant to bring the LRs of deceased R3. ಯಾವಾಗ ಆಗಿರೋದು ನೋಡಿ ಮೇಡಮ್?
6 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ.
ಮಾಡಿಲ್ಲ ಇನ್ನು. ಮಾಡಿಲ್ಲಲ್ಲ? Last time. ಆಯ್ತು. The appellant counsel is absent. However, another 2 weeks time granted to bring the LRs of deceased R3.
8.
I am appearing for
Chetan.
proposed respondent, my lord. I am sorry.
Appearing for-
Copy is wrongly served to some other person. Now I am serving the copy to proper counsel.
Counsel who filed an application for
Impleading.
including the proposed R5 serves copy on the appellant today. Office objections
ಅದೇ ಬೇರೆ ರಾಂಗ್ ಪರ್ಸನ್ ಸರ್ವ್ ಮಾಡಿದೀವಿ ಅಂತ.
ಅದಾದ್ಮೇಲೆ
ಇನ್ನೂ ಇದೆಯಲ್ಲ?
I will verify my.
ಹಾ. ಅವ್ರದ್ದು
A4.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್
A4 ಗೆ
ಅಪಲೆಂಟ್
ultimate-
ಕೌನ್ಸಿಲ್ ಇರ್ಬೇಕು.
ನಮ್ಮ ಐಎನ್ನಲ್ಲಿ ಅದು ಒಂದೇ ಇರೋದು ಅಬ್ಜೆಕ್ಷನ್.
ನಿಮ್ದೇನ್ ಒಂದೇನೆ?
ಒಂದೇ.
And appellant counsel also directed to comply with office objections within 1 week.
Obliged.
List this matter 1 week ಆದ್ಮೇಲೆ ಕೊಡಿ ಮೇಡಮ್.
And objection on IMA overruled, my lord. Objection on IMA be overruled and you complied.
Copy sir.
Copy sir, ಆಯ್ತಲ್ಲ?
ಅದೇ ಕಂಪ್ಲೈಂಟ್ ಅಂತ ಬರ್ಬೇಕು. ಇಲ್ಲ ತಿರ್ಗಾ ಅದನ್ನೇ ಪುಟ್ ಅಪ್ ಮಾಡಿ ಕಳಿಸ್ತಾರೆ.
ಸರ್ವ್ಡ್ ಅಂತ ಆಯ್ತಲ್ಲ, ಮತ್ತೆ ಆಯ್ತು ಅಂದ್ರೆ ಅಲ್ಲಿಗೆ ಅಷ್ಟೇ ಮುಗೀತು.
So 19/7.
19/7.
Obliged. Yes, please.
9.
Before
P. Pramod.
I have taken steps today, my lords. Once again.
Number 10 banks. Name has been changed.
That he is going to pay PF today and hence.
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ.
Counsel submits that he has paid the PF. If PF paid, issue notice to R3.
I'm applying for the
Acceptance of
response to
wakalat paid on behalf of R10. Counsel submission ಏನದಕ್ಕೆ?
The name of the bank has been changed from UTI Bank to Axis Bank. That's what now Axis Bank wakalat has been.
Counsel wakalat is accepted for R10. Next, ಅಷ್ಟೇ ಅಲ್ಲ?
10.
Appellant counsel, government advocate. ಇಲ್ವಾ ಪಾಸ್ ಓವರ್ ಬರ್ತಾರೆ ನೋಡೋದು.
11.
Maltesh.
For the appellant.
I took notice.
Mr. Government Deputy Commissioner. Chamarajanagar.
R1.
Yes, R2.
AGA is directed to take notice. ಹೌದಾ?
Yes.
For R2. Deputy Commissioner
House.
R2. ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ.
R1 ಗೂ ಸರ್ವಾಗಿದೆ, ಅವ್ರಿಗೂ ಅವರೇ ತಗೋತಾರೆ.
ಅವ್ರಿಗೂ ಆಯ್ತು, ಅವ್ರಿಗೆ ಅವರು
ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್ ನೋಟಿಸ್ ಆವಾಗ್ಲೇ ಮಾಡಿಸ್ಕೋಬೋದಿತ್ತಲ್ಲ, ಮತ್ತೆ ಯಾಕೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿಸ್ಕೊಂಡ್ರಿ?
ಸಬ್ಮಿಟೆಡ್ ಬಟ್
AGA is directed to take notice for R1 and R2. ಇಬ್ರೇ ಇರೋದಾ?
ಇಬ್ರೇ.
Post the matter for admission in the last week of July.
Please.
12. SV Prakash.
No, for preparation of paper book. Print list not.
For early hearing, my lord.
19 ಅಲ್ಲೇ ಹಾಕಿದೀವಿ ಮೆಮೊ.
ಏನ್?
ಪೇಪರ್ ಬುಕ್.
ಪ್ರಿಪೇರ್ ಮಾಡಿ ಆವಾಗ ಹಾಕಿದ್ದ?
ಹೌದು.
ಇವಾಗ ಕೊಟ್ಟವ್ರ ಇವ್ರು 5 ವರ್ಷದ ಮೇಲೆ ಹಾಕಿದಾರೆ ಮೇಡಮ್ ಮೆಮೋನ. ಇನ್ ಯಾವಾಗ ಪ್ರಿಪೇರ್ ಆಗೋದು ಯಾವಾಗ ಇದು? ಏನ್ ಪೇಪರ್ ಏನ್ ಮ್ಯಾಟರ್ಸ್ ಏನು?
Partition suit ಸ್ವಾಮಿ, ನಾನು early hearing
Partition suit.
ಹೌದು.
ಅಲ್ಲ ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ಇಂಜಂಕ್ಷನ್ ಅಂತಿದೆ.
Partition ಅದು 1/4 ಶೇರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಂಜಂಕ್ಷನ್ ಅಂಡ್
Injunction and partition.
ಮೂರು ಇದೆ. ಮತ್ತೆ ಬೇಕಾಗ್ಬೋದೇನೋ ಪೇಪರ್ ಬುಕ್ ಬೇಡವಾ?
ಪೇಪರ್ ಬುಕ್ ಬೇಕಾ? ನಾನು early hearing ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ, ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಬೇಕಾಗುತ್ತಾ ಇಲ್ಲ?
ಬೇಕಾಗ್ಬೋದು, ತುಂಬಾ ಜನ ಇದ್ದಾರೆ.
ನೋಡಿ, registry is directed to prepare the paper book and appellant counsel is directed to pay necessary fee within 1 week from today. ಆಯ್ತಾ?
Early hearing application. Early hearing
ಹಾಕಿದ್ದೀರಾ?
ಹೌದು, ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರೆ ಅಂತ.
ಪೇಪರ್ ಬುಕ್ ರೆಡಿ ಆಗ್ಲಿ, ಆಮೇಲೆ ಹಾಕೋಣ.
1 acre 11 ಗುಂಟ ಸೇಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸುಮ್ಮನೆ ಆಲ್ರೆಡಿ. ಇರೋದೇ 1 ಎಕರೆ 35.
ಪೇಪರ್ ಬುಕ್ ಬೇಕು ಅಂತ
ಅಲ್ಲ ನನಗೆ ಇಲ್ಲ, ಇಟ್ ಮೇ ಬಿ ಡಿಸ್ಪೆನ್ಸ್ ವಿತ್ ಇಲ್ಲ, ಮೇ ಬಿ ಡಿಸ್ಪೆನ್ಸ್. ಏನೇನು ಇಲ್ಲ ಪಾಪ ಅವ್ರ ಹತ್ರ.
ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಅದು ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪೀಸ್, ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ಇಲ್ಲಿ ಬಂದಿದೆ. ಪೇಪರ್ ಬುಕ್ ಬೇಕಾಗ
ಆ ರೆಕಾರ್ಡ್ಸ್ ನ ಆಫೀಸ್ನವರು ಅವರೇ ನೋಡ್ಕೊಂಡು ಪೇಪರ್ ಬುಕ್
ಮಾಡ್ತಾರೆ
ಮೇಡಮ್.
ಹೌದೌದು,
ಕ್ಲಿಯರ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದ್ನೆ ನೋಡಿ. ಆಯ್ತು. Heard on IA number 1/24 for early hearing and for the reasons stated in the accompanying application and affidavit, IA is allowed. List the matter after 8 weeks.
ಡೇಟ್ ಅನ್ನು ಫಿಕ್ಸ್
4 weeks.
ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ
4 weeks.
ಆಗಸ್ಟ್ 2nd ವೀಕ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿಲ್ಲ, ನೋಡ್ತೀನಿ.
4 weeks ಮಾಡ್ದೆ, ಅದಕ್ಕೇನೆ
ಡೇಟ್
ರೋಸ್ಟರ್ ಚೇಂಜ್ ಆದ್ರೆ ನಾನು ಬಂದವ್ರಿಗೆ ನಾನು ರೋಸ್ಟರ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಲ್ಲ. ನಾನು ಇರೋವರೆಗೂ ನಾನು ಡೇಟ್ ಕೊಡ್ತೀನಿ. ನಾನು ಆಮೇಲೆ ಮುಂದಿನ ನಾನು ಕೊಡಲ್ಲ. ನೀವು ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. ಆ ಕೋರ್ಟಲ್ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಅವ್ರು ಎಷ್ಟೆಷ್ಟು ತಗೋತಾರ ಗೊತ್ತಿಲ್ಲ. ಮೊದ್ಲೇ ಆಫೀಸ್ನವ್ರು ಕೇಳಿದ್ರೆ 20 ಹಾಕಿ 30 ಹಾಕಿ 40 ಹಾಕಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅಂತ ಜಡ್ಜ್ಗಳ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಮಾಡ್ತಾರೆ ಆಫೀಸ್ನವರು. ಯಾಕೆ ಪೋಸ್ಟ್ ಮಾಡಿಲ್ಲ ಕೇಸ್ ಅಂತ ಕೇಳಿದ್ರು. ಅದು ಅವ್ರವ್ರಿಗೆ ಬಿಟ್ಟಿದ್ದು.
30. Devraj case.
The appellant in this matter.
ಹೇಳ್ರಿ.
I'll take steps insofar as respondent numbers 2 to 5 immediately the next.
2 to 5.
1 week's time.
In
1 week's time I will take.
1 week time granted to pay PF to issue notice to R2 to R5. If PF paid, issue notice to R2 to 5. Non-taking of steps in respect of deceased.
There are 3 persons who have deceased. They are in Kodagu district. My lord, I'll file applications. I have received information about their legal heirs.
ಯಾಕೆ ಹಾಕಿಲ್ಲ ಅಂತ ಕೊಟ್ಟಿದ್ದ ಇವತ್ತು ಲಿಸ್ಟ್ ಮಾಡಿದ್ರೆ. ಯಾವಾಗ ಸತ್ತೋಗಿರೋದವರು?
My lord,
as per order dated 10/6/2019.
my lord, ಅಲ್ಲಿ ನಂಗೆ
2019 ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ ಅವ್ರು ರಿಪೋರ್ಟ್ ಆಗಿರೋದು. Till date you have not taken any steps.
ಪ್ರಾಬ್ಲಮ್ ಇಸ್ my lord, ಅವರು ಕೊಡಗ್ನಲ್ಲಿದ್ದಾರೆ.
Have not taken any steps and
There-
hence appeal
may make-
against R6, R8
may
and
make the
R10
submission,
is
my lord.
abated.
May make the submission.
ಏನ್ ಸಬ್ಮಿಷನ್ 5 ವರ್ಷದ ಮೇಲೆ
ಅಲ್ಲ ಕೊಡಗುನಲ್ಲಿ
ಕೊಡಗುನಲ್ಲಿ ಇದ್ರೆ ಎಲ್ಲಾರು ಇದ್ರೇನು
they have suffered some ಅಲ್ಲಿ because of the landslide.
Whatever it may be.
I think they
ಆಯ್ತು.
have had some problems there.
abated. ಆರ್ಡರ್ ಯಾವಾಗಿಂದ್ರಿ 10/6/2019. Still you are seeking time after 5 years. Already abated. That's all. Next.
In 13.1 my lord.
Sufficient ಅಂತಿದ್ಯಾ ತಗೊಳ್ಳಿ ನೋಡಿ. The respond number 15 has refused and hence held sufficient against R15. ಅದೊಂದು ಇದು ಸೇಮ್ ಆರ್ಡರ್. ಇದು steps to be taken. ಇದು ಆಗಿಂದಲೇನಾ ಮೇಡಮ್? ತಗೊಳ್ಳಿ. The steps not taken and hence appeal against R6, R11, R12, 14 and 16 is abated. Same order. If we have paid, issue notice to R7 to 10 in connected RSA 2153 of 18. Paper book. ಏನ್ ಪೇಪರ್ ಬುಕ್? ಇವತ್ತೇನ್ ಪೇಪರ್ ಬುಕ್ಕಿಗೆ ಏನು ಇದು ಮಾಡಿ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಇದು. Next.
13 ಕರ್ದಿರೋದು.
13 ಕರ್ದಿರೋದು.
14.
Great.
Sachin BS. Filed by council, signature of council not forthcoming in certificate ಅಂತ.
ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
ಸರ್ಟಿಫಿಕೇಟ್ ಎಲ್ಲ ಸೈನ್ ಮಾಡಿಲ್ಲ ಅಂತ. ಕಂಪ್ಲೈ.
ಇವಾಗಲೇ
ಆಫೀಸರ್. ಆಫೀಸರ್ ಮಾಡಿ. RS. ಪೇಪರ್ ಬುಕ್. ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲೇನೆ ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರು ನಿಮ್ಗೆ?
ಕೊಡ್ತೀನಿ ಸರ್.
ಕೊಟ್ಟಿದಾರಾ?
ಇಲ್ಲ ಕೊಡ್ತೀನಿ.
ಯಾವಾಗ?
ಇವಾಗಲೇ ಕೊಡ್ತೀನಿ.
The appellant counsel is directed to furnish paper book to the counsel appearing for the respondent R1 to 6. In the meanwhile, within 1 week, comply with the office objection on paper book.
50.
Varadaraj or Havaldar.
Appellant, I filed a memo, matter settled before the
Bring the
Lokadala.
LRs of deceased appellant on record.
Matter settled before Lokadala.
Close avaka?
Oh.
The counsel for the appellant has filed memo on behalf of the appellant for closure of regular second appeal. On the ground that already matter has been settled before the Lokadala. And hence memo is taken on record and dismissed as not survived for consideration.
60.
I'm appearing for respondent
R2 and R3 as LRs of R1 na?
Lord, some instructions I have to taken. The memo kindly be withdrawn, my lord.
Memo?
May kindly be not pressed, my lord.
Not pressed.
Yes.
The counsel for the appellant submits that memo dated 4/7/24 is not pressed.
I will get instructions, my lord.
Pressed.
I will get instructions, my lord, so far as LRs of deceased respond number 1 is.
2 weeks time to
Please.
make the LRs of R1.
Yes, please. Much obliged.
And hence 2 weeks time granted.
Please.
List this matter on 29/7.
70.
It may be taken on 30th, 29th.
30th.
70. Second part.
Non-filing of an acknowledgement for having paid cost.
Cost paid in the morning.
Filing of memo. in
Memo, my
terms
lord,
of
what
the-
he sought is withdrawal of appeal. For obtaining signatures, we are 2 times you have taken time. Parties are not coming, my lord. That's a
ಯಾಕ್ ಬೇಕು? ಈ ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ರಾ?
ಕಾಸ್ಟ್ ಕಟ್ಟಿದಿರಿ.
Counsel submits that he has paid the cost.
ಅದು ಪಾರ್ಟಿ they want to withdraw the matter. They just ask them to come over and sign the memo. Not coming.
Non-compliance of office objections 5th time.
ಹೌದು, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅದು ಡಿಸ್ಕ್ರಿಪೆನ್ಸಿ ಇಂದ ಡಿಗ್ರಿಲ್ ಇತ್ತು ಅಂತ ಅದನ್ನು ಕೋಪರೇಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಸರಿ, ಏನ್ ಮಾಡಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಲಾ?
1 week last final I will take charge.
ಅಲ್ವಾ?
1 week quotation, otherwise I would not.
The counsel submits that he is going to file a memo for withdrawal.
Withdrawal.
Hence 1 week time granted. List this matter on 19/7.
Please.
A Madhusudan Rao.
R4 Shara has not claimed ಅಂತೇನ ಬಂದಿದೆ?
Deemed service.
R4. Intimation delivered ಅಂತಿಲ್ವಾ? ಆಯ್ತು, ಫ್ರೆಶ್ ಆಗ್ತಾ The council is directed to take fresh steps against R4 within 1 week. If we have paid, issue notice to R4. ಯಾರೊಬ್ರು ಏನು ಮೆಮೋ ರಿಟೈರ್ಮೆಂಟ್ ಹಾಕಿದಾರೆ ನೋಡಿ.
Respond number 4 to 6.
ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇದೆಯಾ ನೋಡಿ. 6 to 8.
Connected message.
ಯಾರು ಸೈನ್ ಮಾಡಿದ್ದಾರೆ? ಪಾರ್ಟಿ ಸೈನ್ ಮಾಡಿದಾರಾ? 6, 7, 8. The council who appears for R 6 to 8 filed memo for retirement, and along with memo, the even parties have also signed and hence permitted to retire. The registry is directed to show the name of the parties R 6 to 8.
Connected matter also, my lord.
Connected allu same alla?
Same.
ಅದರಲ್ಲಿ PF ಕೊಡಿ, ಫ್ರೆಶ್ ಆಗಿ ತಗೊಳ್ಳಿ.
ಕೊಡ್ತೇನೆ.
ಇನ್ನೊಂದು R1 ಗೂ ಏನಿದೆ ನೋಡ್ರಿ, ಇದರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ R1 ಗೂ ಇದೆ.
R1 ಸರ್ವ್ ಆಗಿದೆ ಸರ್. ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ R1 ಸರ್ವ್ ಆಗಿದೆ.
ಸರ್ ಆಗಿದೆ.
ಆಗಿದೆ ಸರ್. ವಿಶ್ವೇಶ್ವರ has filed ವಕಾಲತ್ for respondent.
ಅಪಿಯರ್ ಹಾಕಿದಾರಾ?
ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಸರ್. ವಿಶ್ವೇಶ್ವರ 1 ವಕಾಲತ್ ಹಾಕಿ.
R5 ಅಂತಿದ್ದಾರೆ ಇಲ್ಲಿ. ಸರ್ವ್ ಆಗಿದೆ ಅಷ್ಟೇ. ವೆಂಕಟಮ್ಮ.
Vishweshwaraya is for R5.
ನೋಡಿ ಅವ್ರಿಗೂ ತಗೊಂತಾರೆ.
ತಗೊಳ್ಳಿ. PF paid issue notice to R1 also.
90. KV Narasimhan.
R4 and R5.
Yes, ma'am. Weeks time maybe.
Weeks time to pay PF. If PF paid, issue notice to R4 and R5.
20. SV Prakash.
R1 for second time.
2 weeks time.
Fix. Council 6, 2 weeks time. If PF paid within 2 weeks, issue notice against R1.
21.
Non-compliance of office objection, third time. Council 6 time again, and hence finally 2 weeks time granted. List this matter on 29/7.
22.
Dismissal of appeal for non-compliance of office objections.
Cost was paid for that, but I was unable
Cost?
to. Cost was paid for that. There was delay in paying the cost.
ಎಷ್ಟಿದೆ office objection? ಒಂದು ಮಾಡಿಲ್ವಾ? ನೀವು ಬರೀ ಕಾಸ್ಟ್ ಕಟ್ಟಿದಿರಿ, ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ. Council submits that he has paid the cost but not complied, and again 6 further time, and hence on further cost of ₹500 another 2 weeks time granted. If further cost not paid, it not complied with office objections, appeal is dismissed without reference to the bench.
23.
Acceptance of the cost.
ಬೇರೆ ಕಡೆ ಕಟ್ಟಿದ್ದಾರೆ.
ಹೇಳ್ರಿ ಏನು?
Let's say paid the cost, my lord.
Clerk benevolent fund as directed. ಎಲ್ಲಿ ಕಟ್ಟಿದ್ರಿ ನೀವು? ಯಾರಿಗೆ ಕಟ್ಟಿದ್ರಿ?
Council for appellant has not filed.
Acceptance of receipt for having
No, my
paid
lord,
the
that has been
cost to the
pasted
Karnataka
behind the
Advocates
wakalat.
Clerk's benevolent fund as directed at flag A. Since the council for appellant has not filed the same at filing counter.
ಸರ್ ಅದು ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸರ್, ಅದನ್ನ ಹೇಳಕ್ ಒಂದು ಹೇಳ್ತಾರೆ.
My lord,
ಕಟ್ಟಿದಿರಾ?
ಕಟ್ಟಿದೀವಿ.
ಆಯ್ತು, accepted for having paid the cost. Non filing of main appeal A.
For CD, full cost ಆಯ್ತಿಲ್ಲ, ಅದು ಹಾಕ್ಬೇಕಾಗಿತ್ತು, ಡಿಲೇ ಆಗ್ತಿತ್ತು.
ಮತ್ತು ಮಾಡ್ಲಿಲ್ವಾ? ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಲಿಲ್ವಾ?
No, my lord.
And on further cost of rupees another 2 weeks time granted. If further cost not paid and not complied, appeal is dismissed without reference to the bench. Next.
4. Prakash MH.
Cost paid today inadvertently, the previous cost.
Office objections, sir?
It was clarified, but however, the same is forthcoming.
In a High Court Legal Services Committee as per order dated 22. Katidirega?
I paid today, my lords.
Today?
Today it is paid.
Paid. The council submits that he has paid the cost. Complaints ಎಷ್ಟಿದೆ ಮೇಡಮ್?
Office objection is concerned.
Our office objections ಇದೆ ಅಂತಲ್ಲ.
ಅದರಲ್ಲಿ an application for impleading is filed. So wherein so far as second objection is concerned, Nagesh is why he is not made.
Nagesh different number 4H.
He was not made as
not made party before RA and RSA.
RA ನಲ್ಲಿ ಮಾಡಿರ್ಲಿಲ್ಲ. So ಹಾಗಾಗಿ ಇಲ್ಲಿ ನಾವು
RSA ಮಾಡಿಲ್ಲ, RSA ಮಾಡಿಲ್ಲ.
No, through this impleading application, Lord, he is shown as the proposed respondent number 25 in the impleading application.
Again, impleading application ಹಾಕಿದಿರಾ?
Please. And there is some other disparity wherein some of the respondents before the lower appellate court have died subsequent to judgment. And so far as bringing their legal representatives, Lord, in all this application is filed. What the registry expects that instead of order 1, rule 10, we are supposed to invoke order 22. Might be because the objection is such that prayer is not properly forthcoming.
ಇದೆ ಅಲ್ರಿ, first ಹೇಳಿ typed copy of OS judgment to be filed. File ಮಾಡಿಲ್ಲ. Reading not readable anta ansutte. First office objections. Second one is defendant H avನಿಗೆ ಏನೋ application ಹಾಕಿದಿರಿ ಅಂತಂದ್ರಿ. Bring impleading. ಆಮೇಲೆ IA 2/20 prayer to be stated correctly with respect to LRs of deceased person ಅಂತಿದೆ.
So that's the reason.
Mostly ಅದು office objection.
Please.
ಅದ್ bringing ಅಂತ ಹಾಕ್ಬೇಕಿತ್ತು but impleading ಅಂತ ಹಾಕಿದ್ರಿ.
ಯಾಕೆಂತಂದ್ರೆ if they died during the course of this proceedings, my lord, I can invoke Art 22 because much before filing of this second appeal, they died.
Only you have to seek permission of the court to add them ಅಷ್ಟೇ.
Please.
Bringing ಅಂತ ಬರೋದಿಲ್ಲ. ಆಯ್ತು.
ಅದಕ್ಕೆ impleading
Office objection regarding IA number 2/20 is overruled. ನಾಲ್ಕನೇದು ನಾರಾಯಣಮ್ಮ appellant number 1.
Please.
In RA number 6 in YS but not made as party before.
She also died subsequent to passing of the judgment, and her legal representatives are respond number 1 to 3.
ಅದ್ ಹೇಳ್ಬೇಕಲ್ರಿ ನೀವು. ಆಫೀಸ್ನವ್ರಿಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತದ ಅವರೆಲ್ಲ ಯಾರು ಅಂತ?
The notice made, my lord.
Including application, office objections ಮೇಲ್ ಮಾತ್ರ ಮಾಡಿದ್ದೀನಿ. ಪರ್ಮಿಷನ್ ಕೇಳ್ಬೇಕಿತ್ತು ಅಂತಂದೆ ಅಷ್ಟೇ. ಅದೇನ್ ಬೇಡ ಅವ್ರೆ ನೋಡೋಣ ಆಮೇಲೆ ನೋಡೋಣ. ಯಾವ್ದೋ ವರ್ಡ್ ಏನೋ ಯೂಸ್ ಮಾಡಿದ್ ಏನೋ ಬ್ರಿಂಗಿಂಗ್ ಪರ್ಮಿಷನ್ ದಟ್ ವಿಲ್ ನಾಟ್ ಬಿ ಎ ಮೇನ್ ಇದು. ನಾರಾಯಣಮ್ಮ,
she also died, and her legal representatives.
ಯಾರ್ಯಾರು ಅಂತ ನೀವು ಹೋಗಿ ಕ್ಲಾರಿಫೈ ಮಾಡಿ.
Please, I will make it out. I will make it out.
Clarify regarding office, other office objections on further cost of 500 payable at registry. If further cost not paid and not complied with office objections, appeal is dismissed without reference to the bench. 25, Sheikh Saud. Non-furnishing of PF. Appellant counsel is absent 1 week time granted to pay PF. First time, if PF paid within 1 week, issue notice.
26.
1 of 20.
26.
Non-compliance of office objection. Sixth time.
Other objection all complied. It is put for
Sixth time ಯಾಕೆ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
submission, my lord. Last we kindly see page number 31, my lord.
ಎಷ್ಟಿದೆ office objections?
Only one objection regarding court.
Only one.
With regard to court fee, or should we kindly see?
ಎರಡು ಒಂದು.
For verification
Alladali.
with respect to the possession.
Deficit court fee ಬಗ್ಗೆ ಅಷ್ಟೇ.
Valuation wanted to be stated as per the issue order, accordingly necessary deficit court fee paid.
We kindly see page number 19 of the RE.
19.
Appeal memo 31.
Page, ink page number 31.
31, para number 25. 7th line onwards. This is defendant's appeal, my lord. Plaintiff filed a appeal for, plaintiff filed a suit for mandatory injunction and surrender vacant possession against the defendant. Suit came to be dismissed, challenged that he filed a RA. RA court said you are liable to pay deficit court fee of the trial court as well as appellate court. Rashmi kindly 7th line of the plaintiff ought to have paid the court fee under section 29 of the court fee and suit violation 98 on sum of rupees 3,88,000, but not as valued by the plaintiff under section 26 of the Karnataka Court Fees and Suit Violation Act. As per 1(4) of the Karnataka Court Fee Act, the plaintiff ought to have paid a ad valorem court fee of rupees 20,895. It is seen that plaintiffs have paid only rupees 25 only. Therefore, the plaintiffs are required to pay a deficit court fee of rupees 20,870 before the trial court.
Yes.
Next paragraph. While filing the appeal being aggrieved by the judgment of the trial court, the plaintiffs have to pay the court fee as per Article 49 of the Karnataka Court Fee and Suit Violation Act 1958. Therefore, the plaintiffs have to pay the court fee same as fee that would be payable in trial court on the subject matter.
Yes, counsel, what you have not paid before the trial court, also to pay before the appellate court. There is an order.
Defendant's appeal, my lord. Defendant's appeal. Plaintiffs have paid only 25 rupees. Challenging that, he filed a appeal before the district court.
Who filed?
Plaintiff only, he lost.
Plaintiff only filed an appeal. Yes.
So he has to pay 2 times, 20,870 into 2 times, it will come to 41,740.
Yes.
RA came to be allowed against this.
Against defendants have filed an appeal.
Yes.
Yes.
For that, I have to pay 20,870 only. 20,870 only. In 2 courts, he has not paid any amount.
That's what, now you have paid the 20,000.
Already paid, my lord, already paid, 20,000.
ಮೇಡಮ್ ಅಷ್ಟೇ ಕೊಡ್ಬೇಕು, ಅದ್ ಮತ್ತೆ ಹೆಂಗೇನು 2 ಸಲ ಕೊಡ್ತಾರೆ. What is the office objection? What is the office objection?
Valuation is not correct anta. Plaintiff
ಏನ್
allowed
value ಏನ್
number
ಮಾಡಿದಾರೆ
25.
DCF ಯಾವ್ದು ಅನ್ನೋದು
DCF
ಹೇಳ್ಬೇಕು
ಬರಲ್ಲ.
ಆಫೀಸ್ನವ್ರು, ಬರೀ ಆಗದ್ ಬರ್ದ್ಬಿಟ್ರೆ. DCF ಏನಿದೆ? 49(3) ನಲ್ಲೇ ಮೇಡಮ್ ಲೋಯರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ಕೊಡ್ಬೇಕಿತ್ತು ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ 20,000.
20,870 paid plus
ಡಿಟರ್ಮೈನ್
25.
ಮಾಡಿದ್ದಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 20,000 ಅಂತ. ಅವನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಕಟ್ಟಿಲ್ಲ, ಫಸ್ಟ್ ಅಪ್ಲೇಟ್
Yes,
ಕೋರ್ಟ್
ma'am.
ಅಲ್ಲೂ ಕಟ್ಟಿಲ್ಲ ಅಂತ 2 ಸರಿ 20,000 ಕಟ್ಟು ಅಂತ ಮಾಡಿದ್ದಾರೆ. ನಾವು ಹಿ ಇಸ್ ಅಗ್ರೀಡ್ ಬೈ ದಿ ಆರ್ಡರ್, 20,000 ಕಟ್ಟಿದ್ದಾರೆ, ಮತ್ತೇನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್? ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ, ಬರೀ ಬೆಳಗ್ಗೆ ಇದ್ರೆ ದಿನ ಇದೇ ಕೆಲಸ ಅವ್ರಿಗೆ. 2 ಸರಿ ಕೋರ್ಟ್ ಫೀ ಅವ್ರ ಯಾಕ್ರಿ ಕೊಡ್ತಾರೆ, ಒಂದೇ ಸರಿ ಕೊಡ್ಬೇಕು.
Yes, ma'am.
ಪಾಸ್ವರ್ಡ್
Yes, ma'am.
ಯಾರಲ್ಲಿ ಕೂತ್ಕೊಳ್ಳೋದು ಸ್ಕ್ರೂಟಿನಿಯಲ್ಲಿ ಸ್ವಲ್ಪ ಟ್ರೈನಿಂಗ್ ಕೊಡ್ಬೇಕೇನ?
27 ಚಂದ್ರನಾಥ್ ತರಿಗ
ನಾನ್ ಪೇಮೆಂಟ್ ಆಫ್ ಡೆಫಿಸಿಟ್ ಕೋರ್ಟ್ ಫೀ ಆಸ್ ಪರ್ ಸೆಕ್ಷನ್ 49 ಹಾಕಿದಾರ, ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದಾರ?
ಅಲ್ಲ, ಇಲ್ಲಿ suit for declaration and injunction. 75 rupees was the court fee paid in the trial court. First appellate court decree says that 75 rupees is paid and 3,000 is also calculated. Therefore, my lord directed me to file copy of the appeal memo and also the valuation, the check slip. Both are filed. Kindly see the.
ಹೋದ್ ಸರಿ ಮಾಡಿದೀವಲ್ರಿ, ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪ್ಲೆಂಟ್ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಎ ಮೆಮೋ along with valuation slip filed before the
Yes.
court. But record discloses that court fee of rupees 3,000 is paid in the appellate court and not produce the valuation slip of appellate court. And also
Therefore,
the appeal memo. Hence directed to produce the same before this court ಅಂತಿದೆ.
it was filed on 10/8/2021.
ಈ ಕೋರ್ಟ್ ಮುಂದೆ ಹಾಕಿದೀರಾ?
ಹೌದು.
ಯಾವ್ದು?
10/8 ತಮ್ಮ ಆರ್ಡರ್ ಆದ ಮೇಲೆ
ಈ ಆರ್ಡರ್ ಆಗಿರೋದು 9/8/23 ನಲ್ಲಿ.
ಆಮೇಲೆ ಇದು ಹಾಕಿದೆ.
ಯಾವಾಗ
ನನ್ನ
ಹಾಕಿದ್ರಿ?
ರಿಗಾರ್ಡಿಂಗ್ 10/8 ಅಲ್ಲಿ ಒಂದು ಮೆಮೋ ಹಾಕಿದಿಲ್ಲ.
10/8 ಅಲ್ಲ.
21 ಅಲ್ಲ. 21 ಅಲ್ವಾ?
ಹೌದು. ಇದು ಎಪೀಲ್ ಮೆಮೋ ಮತ್ತು ಚೆಕ್ ಸ್ಲಿಪ್ ಎರಡು ಹಾಕಿದೆ, ಇಲ್ಲಿ ಕಾಪಿ ಇದೆ.
ಯಾವಾಗ ಹಾಕಿರೋದು? 23/8/23 ನಲ್ಲ. ಈ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ
ಅಲ್ಲಿ
ಇದ್ರ ಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರು? ಪುಟ್ ಅಪ್ ಮಾಡಿದಾರ ಮೇಡಮ್ ಆಫೀಸ್ನವರು? ಈ ಮೆಮೋ ಹಾಕಿದ್ರ ಮೇಲೆ ಸ್ಕ್ರೂಟಿನಿ ಮಾಡಿದಾರ ಇವ್ರು ಹಾಕಿರೋದು? ಅದ್ರ ಮೇಲೆ ಏನ್ ಇದು ಮೆಮೋ ಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರು? ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಅಲ್ಲಿ ಹಾಕಿದಾರಲ್ಲ, ಈಗ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಹಾಕಿದಾರಲ್ಲ ಈಗ.
Is reflected same is placed on record. The concept of the appellant is required to prove that CCF.
75 ರೂಪಾಯಿ ಕಟ್ಟಿದ್ದೀರಾ ನೀವು?
ಹೌದು.
DCF ಅಂತಂದ್ರೆ ಎಷ್ಟು ಅಂತ ಹೇಳ್ಬೇಕಲ್ಲ ಮತ್ತೆ ಆಫೀಸ್ನವರು. ಏನ್ ಕಟ್ಬೇಕು? 75 ರೂಪಾಯಿ ಕಟ್ಬೇಕು, ಕಟ್ಟಿದ್ದಾರೆ. ಬಟ್ ರಾಂಗ್ಲಿ ಮೆನ್ಷನ್ಡ್ ಆಸ್ 3,000 ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಕರೆಕ್ಟ್.
3,000 ನಾಟ್ ಕರೆಕ್ಟ್ ಅಷ್ಟೇ, ರಾಂಗ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿರೋದು. ಅದು ಡಿಗ್ರಿನೆಲ್ಲ ಎಲ್ಲೋ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಹೌದು.
ಈಗ ಮಾಡಿದಾರಲ್ಲ ಇವರು, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾರಲ್ಲ, ಅದ್ರ ಮೇಲೆ ಹೇಳ್ಬೇಕಲ್ಲ ಏನು ಅಂತ ನೋಡ್ಬೇಕಲ್ಲ ಸ್ಕ್ರೂಟಿನಿ. ದಿ ರಿಜಿಸ್ಟ್ರಿ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ವೆರಿಫೈ in terms of the memo filed by the council dated 23/8/23 regarding court fee. This matter on 19/7.
28. Mohammed Usman Sheikh.
Appellant by me. 2 weeks time may begin.
2 weeks time and hence 2 weeks time granted finally.
For appellant, 2 weeks time may be granted.
ಏನು ಪೇಮೆಂಟ್ ಮಾಡಕ್ PF ಕೊಡಕ್ಕೆ 2 ವಾರ ಬೇಕಾ?
ಅಲ್ಲ, ಡೆತ್ for the.
ಡೆತ್ ಇದ್ದಾರ. Council seeks 1 week time to pay PF. If PF paid, issue notice to R7 to 10, R12 to 14, and also 2 weeks time granted to bring the LRs of R1. Unclaimed ಏನಾಗಿದೆ ನೋಡಿ ಮೇಡಮ್.
ಇದು intimation deliver ಅಂತ ಇದೆ.
Notice issued against R4 was returned with an endorsement unclaimed and on postal shara there is an endorsement of intimation is delivered and hence held sufficient against R4.
30.
Copies.
Served the copy.
Sir,
Madidira. Counsel for the appellant would submit that he has served the copy on the caveat of counsel. A non-filing of NOC with respect to appellants by counsel SN but antide.
Today I filed.
File madidira. Counsel submits that he also filed NOC vakalatta. And hence registry is directed to delete the name of counsel KS Ramaswamy Iyengar. Correct alla?
31.
Chidananda P. Non-arraying of respond number 1. Gauramma of appellant
Gaurama is
in this appeal along with counsel submission. Helri.
Gaurama is dead and legal is already on record. I'll file the memo along with death certificate in the next week.
Illide memo hakidira.
Next date.
Counsel seeks time to file memo along with death certificate and hence 2 weeks time granted. LRs ಇದಾರೆ ಅಂತ ಅವ್ರು ಹೇಳೋದು ಮೆಮೋ ಹಾಕ್ತಾರಂತ ಹಾಕ್ಲಿ ಬಿಡಿ ಮೆಮೋ ಆಮೇಲೆ ನೋಡಿ ಹಾಕ್ಲಿ ಮೆಮೋ ಹಾಕ್ಲಿ. ಈಗ ಆಲ್ರೆಡಿ LRs ತಂದಿದ್ದೀರಾ?
All the appellants are the LRs of respond number 1, madam.
All the appellants.
Appellants. Our ಅಮ್ಮನೇ ತೀರೋಗಿರೋದು. ಗೌರಮ್ಮ ಬಂದ್ಬಿಟ್ಟು appellants ಅವ್ರ ಅಮ್ಮ.
ಈಗಾಗಲೇ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ ಪರ್ಮಿಷನ್ಗೆ?
No, madam.
ಮತ್ತೆ ಹಾಕ್ಬೇಕಲ್ಲ?
Next date.
ಪರ್ಮಿಷನ್ ಹಾಕ್ತಲ್ಲ ಹೇಗೆ ಮಾಡ್ತೀರಿ? ಲಕ್ಷ್ಮಿ.
All the appellants are the parties before the RM.
LRs ಅಂತ ಡೆಡ್ ಅಂತ ಏನು ತೋರಿಸಿಲ್ಲ. ಡೆಡ್ ಅಂತಾನು ತೋರಿಸಿಲ್ಲ ಅವ್ರು ಯಾರು ಅಂತ ತೋರಿಸಿಲ್ಲ. ಪರ್ಮಿಷನ್ ಕೇಳಬೇಕು. Hence comply with office objections within 2 weeks. Next.
32.
Fourth time GS Prasanna Kumar.
My lord, counsel prays for 2 weeks time.
Fourth time ಅಂದ್ರೆ ಕಾಸ್ಟ್ told. Counsel again 6 time and hence on cost of ₹500 another 2 weeks time granted if cost not paid and not complied appeal is dismissed without reference to the bench. Next 33. Udaya.
ಏನ್ ರಘುಪತಿ?
ಉದಯ ಅಂತ ಯಾರು ಇದಾರಲ್ಲ ಏನ್ ರಘುಪತಿ ತೆಗೆದ್ಬಿಡ್ಬೇಕು. ಉದಯ ಒಕ್ಕಲತ್ ಇದೆಯಲ್ಲ appellant counsel is absent for 2 weeks time granted if cost and on cost of ₹500 another 2 weeks time granted if cost not paid and not complied appeal is dismissed without reference to the bench. Registry is directed to delete the name of counsel TN Raghupati.
34.
Non-filing of an acknowledgement for having copies served to the caveator along with counsel submission. ಹೇಳಿ madam ಏನು?
Counsel submission ಅಲ್ಲಿ there is a prayer. In the prayer there is a prayer in the appeal because the suit is for partition. ಅದು subsequently during the pendency of the suit.
ಸರ್ವಿಸ್ ಯಾಕೆ ಮಾಡಿಲ್ಲ caveator
ಅದನ್ನ ಹಾಕ್ತೀನಿ.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನು?
Within 2 days I'll ಹಾಕ್ತೀನಿ. Regarding caveat copy ಹಾಕ್ತೀನಿ.
ಏನು?
ಅಲ್ಲ
non-stating of valuation para of appeal correctly along with counsel submission. ಏನು?
valuation slip ಹಾಕಿದ್ದೀನಿ and also I have stated at para number 23 with respect to the valuation.
Non-stating of valuation para ಅಂತಿದೆ ಮೇಡಮ್. ಅಪೀಲ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಮಾಡಿದಿರಿ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿಲ್ಲ ಅಂತ.
ಅದ್ ನಾನು ಮಾಡ್ತೀನಿ ಪ್ಲೀಸ್ ಡ್ಯೂರಿಂಗ್ ದಿ ಕೋರ್ಸ್.
Counsel seeks another 2 weeks time. ಎಷ್ಟನೇ ಸರಿ ಲಿಸ್ಟ್ ಆಗಿರೋದು ಮೇಡಮ್ ಇದು?
ಕಂಪ್ಲೈಂಟ್ ಇಲ್ಲ ಫಸ್ಟ್
4 to 6.
4 to 6 is because I have raised a new relief before the appeal court. ಯಾಕಂದ್ರೆ during the pendency of the appeal they have taken the acquisition amount ತಗೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲಿಗೆ 6ನೇ ಸಲ ಕೊಡಿ. Matter listed before the registrar thrice and also listed before this court thrice. And in spite of it, not complied with office objections and hence on cost of ₹1,500 another 2 weeks granted. ಕಾಸ್ಟ್ ಏನು ಹಾಕಿದೆ ಹಿಂದೇನು ಕಟ್ಟಿದ್ದೀರಾ ಹೋಗ್ಲಿ?
ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ದೇನೆ ಅಲ್ಲ ಇದನ್ನೇ
19-1 ಅಲ್ಲಿ ಆಮೇಲೆ
ನಂದು ಅಲ್ಲ ಒಂದೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಂದ್ರೆ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು
ಅವ್ರ ಮುಂದೆ
ಏವಿಯೇಟರ್ ಕಾಪಿ ಕೊಡ್ಬೇಕು. ಬಾಕಿದ್ಕೆ ಸಬ್ಮಿಷನ್ ಬರ್ದಿದ್ದೇನೆ. Relief sought at prayer 1 and 2 was not sought before the trial court and the trial court they have taken the deposited amount. That is the reason I have sought the relief before this court. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ದೇ ಹ್ಯಾವ್ ಡಿಸ್ಪರ್ಸ್ ದಿ ಅಕ್ವಿಸಿಷನ್
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಕ್ ಏನ್ರಿ 6 ಸಲ ಲಿಸ್ಟ್ ಆದ್ರೂನು
ಅಲ್ಲ
ಅದರ್ ಸೈಡ್ಗೆ
ಕೊಟ್ಟಿದ್ದೀವಿ.
ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲೆಲ್ಲ ಮಾಡಿದ್ದೆಲ್ಲ ಮಾಡಕ್
ಅಲ್ಲ ನಾನು ಈಗ ಪರ್ಸನಲ್ ಆಗಿ ಸರ್ವ್ ಮಾಡ್ತೇನೆ.
ಹಾ
ಪರ್ಸನಲ್ ಆಗಿ ಸರ್ವ್ ಮಾಡ್ತೇನೆ.
ವಾಟ್ಸ್ಆಪ್
ಅದನ್ನ.
ರೂಲ್ಸ್ ಆಗಿದೆಯಾ ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಸರ್ವಿಸ್ ಮಾಡಬಹುದು ಅಂತ
ಇಲ್ಲ ಇಲ್ಲ ನಾನು
ಇಟ್ ಇಸ್
ಮಾಡ್ತೇನೆ.
ರೆಕಗ್ನೈಸ್ಡ್
ಇಲ್ಲ ನಾಟ್ ಅಟ್.
ಪ್ಯಾರಾನು ಸರಿಯಾಗಿ ಹೇಳಿಲ್ಲ ತಗೊಳ್ಳಿ ಆನ್ ಫರ್ದರ್ ಕಾಸ್ಟ್ ಆಫ್ rupees 500 2 weeks time granted to comply with office objection if not complied and not paid the further cost appeal is dismissed without reference to the bench.
35.
Non-compliance of office objections 5th time.
Tapu Prakash
Raghu
Babu.
Prakash Tole. Appellant counsel is absent and matter listed for 5th time. No representation and on cost of rupees 1,000 another 2 weeks time granted. If cost not paid, not complied, appeal is dismissed without reference to the bench.
36.
VBS
VB Shivakumar.
5th time.
Some time may be granted because.
Once again.
ತುಂಬಾ ಇದೆ.
Cost ಕಟ್ಟಿದಿರಾ ಈಗ?
ಇಲ್ಲ ಕಟ್ಟಿಲ್ಲ ಅದನ್ನು ಕಟ್ಬಿಟ್ಟು.
ಎರಡೇ ಇದೆ.
ಕಾಸ್ಟ್ ಕಟ್ಟಿ ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ಮೇಲೆ ಮುಂದಿನ ಡೇಟ್ ಕಾಸ್ಟ್ ಕಟ್ಟಿ
ಆಯ್ತು.
ಆಮೇಲೆ ನೋಡೋಣ. ನೆಕ್ಸ್ಟ್ ಸೌರಿ HR
7.
non compliance of office objections 5th time.
Appearing on before appearance.
Non filing of acknowledgement ಹೇಳಿ
Acknowledgement file ಮಾಡಿದ್ದೇನೆ.
ಬರೀ ಕಾಸ್ಟ್ ಕಟ್ಟಿದಿರಿ
ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ದೇನೆ.
ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ.
ರಿಜಿಸ್ಟರ್ ಇದ್ ಮಾಡಿದ್ದೇನೆ ಲಾರ್ಡ್ಶಿಪ್ ಮತ್ತೆ ಸಬ್ಮಿಷನ್.
ಕಂಪ್ಲೈ ಮಾಡಿದಿರಾ ಇಲ್ಲ?
ಕಂಪ್ಲೈ ಅಲ್ಲಿ 3ಕ್ಕೆ ಸಬ್ಮಿಷನ್ ಇದೆ ಲಾರ್ಡ್ಶಿಪ್.
ಏನ್ 3ಕ್ಕೆ ಸಬ್ಮಿಷನ್ ಹೇಳಿ?
Lordship, with regard to office objection second lordship,
ಯಾವ್ದು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ ಸಬ್ಮಿಷನ್?
lordship orally submission.
ಕಾಸ್ಟ್ ಏನೋ 2 ಸರಿ ಹಾಕಿದೆ ಮೇಡಮ್ ಇದು. 2 ಸರಿಲೂ ಕಟ್ಟಿಲ್ವಾ?
ಕಟ್ಟಿ ಆಗಿದೆ lordship.
ಯಾವಾಗ?
ಒಂದು ಇಲ್ಲಿ ಮೊನ್ನೆನೆ ಕಟ್ಟಿದ್ದೇನೆ. ಯಾವಾಗ?
ಎಷ್ಟು ಕಟ್ಟಿದಿರಿ ಹೇಳಿ?
500 lordship.
2 ಸರಿ ಹಾಕಿದೆ 500.
ಎರಡು ಕಟ್ಟಿದಿಲ್ಲ lordship receipt.
24 124 500 ಆಮೇಲೆ
ಅದು ಇಲ್ಲಿದೆ ಸರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೆಮೊ. ಮತ್ತೆ ಇವತ್ತು ಮೊನ್ನೆ ಬಂದಿತ್ತು.
ಮೊನ್ನೆ ಬೇರೆ ಮತ್ತೆ ಹಾಕಿದೀವಿ ಕಾಸ್ಟ್.
500.
ಹಾಗಾದ್ರೆ 2 ಸಲ ಕಾಸ್ಟ್ ಹಾಕಿ ನೀವು ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ನೋ ಡೇಟ್ ಡಿಸ್ಮಿಸ್ ಟುಡೇ ಇಟ್ಸ್.
No lordship. I'll comply today sir lordship.
ಏನ್ ಹೇಳಿ ಏನೋ ಸಬ್ಮಿಷನ್ ಅಂದ್ರಲ್ಲ ಏನದು?
Lordship, with regard to
Submission of the learned counsel in respect of office objection number 1 is accepted ಅಂತ last time ಮಾಡಿದೀನಿ ನಾನು. ಮತ್ತೆ ಬೇರೆದೇನಿದೆ?
2 ಅಲ್ಲಿ ಇದೆ lordship designation of trial court. ಅದು ಆಕ್ಚುಲಿ ಇದ್ರಲ್ಲೇ ಮಿಸ್ಟೇಕ್ ಆರ್ಡರ್ ಅಲ್ಲೇ ಹತಾರ ಮಾಡಿದ್ದಾರೆ lordship. ಪೇಜ್ ನಂಬರ್ 34.
ಏನೇನಿದೆ ನೋಡಿ ಮೇಡಮ್.
RH judgment. ಪೇಜ್ ನಂಬರ್ 34 ಅಲ್ಲಿ ಡೆಸಿಗ್ನೇಷನ್ ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜ್ ಅಂಡ್ CGM
Of RA.
ಏನೇನು?
Designation of the trial court differs with the issued order portion of RA judgment.
Typographical error ಬಿಡಿ. Typographical error is overruled in respect. ಅದ ಮೊದಲೇ ಮಾಡಿದೀವಲ್ಲ
ಮತ್ತೊಂದು
ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ overruled ಮಾಡಿದೀವಲ್ಲ. ನಾನೇ ಮಾಡಿದೀನಲ್ಲ ಒಂದು. ಕೆಳಗಡೆ ಇದೆ ನೋಡಿ ಇಲ್ಲಿ ಒಂದು. ಒಂದು overruled ಮಾಡಿದೀವಲ್ಲ. ಈಗ ಮತ್ತೆ ಬೇರೆದಾ?
ಎರಡನೇದು lordship.
ಈಗ ಒಂದನೇದೇನೀಗ ಪ್ರೇಯರ್ ಆಫ್
Designation.
ಆಯ್ತು ಆಯ್ತು ಅದು ಓವರ್ರೂಲ್ಡ್. ಜಡ್ಜ್ಗಳು ಅಲ್ಲೇನ ಟೈಪ್ ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡೋದು? 1
Pencil marking of RA judgment and decree to.
That I'll remove.
ಪೆನ್ಸಿಲ್ ಮಾರ್ಕಿಂಗ್ ರಿಮೂವ್ ಮಾಡಿಲ್ಲ ಯಾಕೆ? ದೆನ್
4 ಅಲ್ಲಿ lordship.
Different OS not arrayed as party in RA and RSA.
ಡಿಫೆಂಡ್ ನಂಬರ್ 1 ಅನ್ನು ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅಂತಲ್ಲ.
ಅದು OS ಅಲ್ಲಿ ಅವ್ರ ಪಾರ್ಟಿ ಇದ್ರು lordship. ಅವ್ರ ಅಮ್ಮ
OS ಅಲ್ಲಿ ಇದ್ರು ಮೇಡಮ್, RL ಮಾಡಿಲ್ಲ, RSL ಮಾಡಿಲ್ಲ.
ಅವ್ರನ್ನ ಮಾಡ್ಲಿಲ್ಲ.
ಯಾಕೆ ಹೇಳಿ, ಕ್ಲಾರಿಫೈ ಮಾಡಿ ಅಂತ ಕೇಳ್ತಾರೆ. ಏನಕ್ಕೋಸ್ಕರ ಮಾಡಿಲ್ಲ?
ಅವ್ರ ಡೆತ್ ಆಗಿದೆ lordship.
ಡೆತ್ ಆಗಿದೆಯಾ? ಕರೆಕ್ಟಾ?
ಹೌದು lordship.
ತಗೊಳ್ಳಿ.
ಅವ್ರ
ಡಿಫೆಂಡ್ ನಂಬರ್
ಲೀಗಲ್
1
ಹೇರ್ಸ್ ಮತ್ತೆ ಬಂದಿದ್ದಾರೆ. ಅವ್ರ ಲೀಗಲ್ ಹೇರ್ಸ್ ನೆಕ್ಸ್ಟ್ RL ಬಂದಿದ್ದಾರೆ.
ತಂದಿದಾರಂತಲ್ಲ ಮತ್ತೆ ಅವ್ರನ್ನ ಈಗ ಇಲ್ಲೂ ಮಾಡಿರ್ತಾರೆ. RS ನಲ್ಲೂ ಇದಾರೆ ಈಗ LRs
ಇದ್ದಾರೆ lordship.
ಡಿಫೆಂಡ್ ನಂಬರ್ 1 LRs
ಇದ್ದಾರೆ. ಮೋಟೈ ಇದ್ದಾರೆ lordship.
ಡಿಫೆಂಡ್ ನಂಬರ್ 1 ತೆಗೀರಿ ಮೇಡಮ್. ಜವರಮ್ಮ. ಜವರಮ್ಮನ ಮಕ್ಕಳನ್ನ LRs ಮಾಡಿದೀರಾ ಇಲ್ಲಿ ಆರೇನಲ್ಲಿ?
RL ಇದ್ದಾರೆ. ಅದೇ
ಯಾರು ಅವ್ರು ಹೇಳಿ?
ಮೋಟಯ್ಯ ರಾಮಯ್ಯ ಚಲುವಯ್ಯ
ಅವರೆಲ್ಲ LRs?
ಹೌದು lordship. ಜವರಮ್ಮ
ಏನ್ ಮಾಡ್ಬೇಕು? ಅಪೀಲ್ ಹಾಕುವಾಗ ಇಲ್ಲೇ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಬರಿಬೇಕು ಯಾರ್ಯಾರು ಅಂತ. LRs ಅಂತ ಮಾಡಬೇಕು. D1 LRs ಅಂತ ಅಪೀಲ್ ಅಲ್ಲಿ ತೋರ್ಸ್ಬೇಕಿತ್ತು, ನೀವು ತೋರ್ಸಿಲ್ಲ. ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ಇಲ್ಲೂ ಇದಾರೆ ನೋಡಿ ಮೇಡಮ್. The council submission is accepted with regard to the non-arraying of defendant number 1 since D1 is no more and her LRs are already brought on record in appeal in RSA.
ಮತ್ತೆ
RA and RSA.
ಜಿನೋಲಾಜಿಕಲ್ ಟ್ರೀ ಇದೆ ಲಾರ್ಡ್ಶಿಪ್
Delay is to be mentioned ante yavrali delay ge ಏನು ಹಾಕಿದಿರಿ? Remaining office objection is concerned another 2 weeks. Another G3 ಹಾಕಿದಿರಾ? ಎಲ್ಲಿದೆ G3?
ಇದೆ ಲಾರ್ಡ್ಶಿಪ್
ಎಲ್ಲಿದೆ? ನಿಮ್ಮ ಹತ್ರ ಇದೆ?
ಇದೆ.
ಇಲ್ಲ ಹಾಕಿಲ್ಲ.
ಇಲ್ಲಿ
ತಗೊಳ್ಳಿ. On further cost of rupees ಈಗ 500 ಕಟ್ಟಿದಿರಾ?
ಹೌದು
On
ಲಾರ್ಡ್ಶಿಪ್.
further cost of rupees 500 finally 2 weeks time granted if further cost not paid and not complied. Appeal is dismissed with refers to the bench. ಬೇಡ ಹಾಕಿದಾರ ಅದನ್ನ overruled ಅದು. 6 also office objections overruled. 38 notice to R3 Neeraja Karanth. Yes madam ಹೇಳಿ.
Weeks time.
Weeks time granted to pay PF. If PF paid issue notice to R3. ಇನ್ನೊಂದೇನೋ ಇದೆ ಮೇಡಮ್, ಯಾರು someone ಸತ್ತೋಗಿದಾರ? 2 weeks time granted to bring the LRs of R2 and R4. Acceptance of acknowledgement received by other person who is not party. And council is directed to verify whether the person who received the notice on behalf of R6 is an adult member of the family and submit the same in the next date of hearing. Next,
39.
non-compliance of office objections, fixed time.
Amount already paid ಮೇಡ. And office ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ಹಿಂದೆ.
ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಯಾಕೆ ಬರುತ್ತೆ?
Additional
Council submit that he has paid the cost. ಎಲ್ಲಿದೆ ಕಾಸ್ಟ್ receipt ಎಲ್ಲಿದೆ? ಇವಾಗ ಕಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಅವಾಗ ಲಾಂಗ್ ಬ್ಯಾಕ್ ಫೆಬ್ರವರಿಯಲ್ಲೇ ಕಟ್ಟಿರೋದು.
ಫೆಬ್ರವರಿ ಕಟ್ಟಿರಾಕ್ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಬರುತ್ತೆ. ಯಾವಾಗ ಹಾಕಿದಿರೋದು ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ನೀವು? ಕಾಸ್ಟ್ ಹಾಕಿರೋದು ಯಾವಾಗ? ಕಾಸ್ಟ್ 2 ಸರಿ ಹಾಕಿದೆ ಅಂತ.
Only one time lord. Only one time lord they raise question cost my lord. We paid within the time.
ನೀವು ಕಾಸ್ಟ್ ಕಟ್ಟಿರೋದು ಯಾವಾಗ ಹೇಳಿ?
8th of February.
8th of February. ಮತ್ತೆ ನೋಡಿ 22/4 24 ಮತ್ತೆ 500 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಹಾಕಿದ್ದಾರೆ. ಕಾಸ್ಟ್ ಕಟ್ಟಿಲ್ಲ, ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿಲ್ಲ, ಡಿಸ್ಮಿಸ್ಡ್. ಏನ್ ಮಾಡ್ಬೇಕು ಮತ್ತೆ? ಎಷ್ಟು ಸರಿ ಹಾಕದ್ರಿ ಕಾಸ್ಟ್? 1 ಸರಿ 2 ಸರಿ? ಕಟ್ ಬನ್ನಿ ಆಮೇಲೆ ನೋಡಿ. ಕಂಪ್ಲೈಂಟ್ ಮಾಡಲ್ಲ, ಕಾಸ್ಟ್ ಎಷ್ಟು ಇಲ್ಲ. ಇನ್ನೇನು ಮೇಲೆ 500 ರೂಪಾಯಿ ಹಾಕೋಬಹುದು, 5,000 ಹಾಕ್ಬೇಕು. ಆಗ್ಲಾರ ಕಂಪ್ಲೈಂಟ್ ಮಾಡ್ತೀರ ನೋಡೋಣ.
40. Sudeep PC.
ನಾನು arraying of respondent number 1 in RA Bhagyamma to this appeal along with note below. Note below ಹಾಕಿದಿರಾ?
ಬರ್ದಿದ್ದೀನಿ.
Note below is accepted. Post the matter for admission in the last week of July.
41.
Non-compliance of office objection 4th time.
In this case appearing for appellant, my lordship.
ಹೇಳಿ.
Only they have raised office objection regarding the court fee, DCF of court fees, my lordship. In one submission, my lordship, already I paid court fees of rupees 85,000. In page number 56, my lordship.
ಕೊಡ್ರಿ ನೋಡೋಣ.
Copy.
ಒಂದೇನಾ ಆಫೀಸ್ objection?
12 office objections there.
ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ? ಎಷ್ಟು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ದಾರೆ? ಇನ್ನು ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಅಂತ ಮಾಡಿದಾರ ಮೇಡಮ್? ಮಾಡೋದು ಅಂದ್ರೆ ಮತ್ತೆ ಕರೀರಿ, ಜುಡಿಷಿಯಲ್ ಕರೀರಿ. DCF ಅಂದ್ರೆ ಎಷ್ಟೊಂದು ಗೊತ್ತಾಗ್ಬೇಕ್ರಿ. ಫಸ್ಟ್ ದೇ ಶುಡ್ ಅಸರ್ಟೈನ್ ವಾಟ್ ಇಸ್ ದ DCF ಅಂತ. ಎಷ್ಟು ಕಟ್ಟಿದ್ರಿ ನೀವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Trial court ಅಲ್ಲಿ the plaintiff has played the here respondent in plaintiff has played in trial court 85 rupees has been paid, my lordship.
85 rupees.
Yes, my lord. No yes suit. I complete that order. 85 rupees I have paid, my lord.
ಇಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರಿ?
Illu 85 rupees I have paid, my lordship.
DCF ಏನಂತ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದಾರೆ ಮೇಡಮ್? ಅಪೀಲ್ ಅಲ್ಲಿ ಬರೀ 25 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದೀರಿ.
According in the appeal copy, my lord.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 85 ಇದೆ, ಅಪೀಲ್ ಅಲ್ಲಿ ಹೆಂಗ್ರಿ 25 ಆಗುತ್ತೆ?
According to me, my lordship, 35 of Karnataka Court Fees Act, my lordship.
ಕೌನ್ಸಿಲ್ ಫಸ್ಟ್ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 85 ರೂಪಾಯಿ ಕಟ್ಟಿದಿರಿ ಕೋರ್ಟ್ ಫೀ, ಹೌದಾ? ಫಸ್ಟ್ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬರೀ 25 ಕಟ್ಟಿದೆ. ಹೌ ದಿಸ್ ಹ್ಯಾಸ್ ಬಿನ್ ರೆಡ್ಯೂಸ್ಡ್? ಅದಕ್ಕೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್. ಇಲ್ಲಿ ಕಟ್ಟೆ ಅಲ್ವಾ ಇವರು? ಇಲ್ಲೇನು ಕಟ್ಟೆ ಇಲ್ಲ ಅಂತಲ್ಲ ನೀವು? ರಸೀಟ್ ಇಲ್ಲ ಅಂತಲ್ಲ?
Receipt is here, my lordship.
ಎಷ್ಟು ಯಾವಾಗ ಕಟ್ಟಿದಿರಿ?
Lordship on 12/3/2024, my lordship.
12/3?
Yes, my lordship.
ಅಂದ್ರೆ ಅಪೀಲ್ ಹಾಕಿದ್ಮೇಲೆ ಕಟ್ಟಿದಿರಿ, ಮೊದ್ಲು ಕೋರ್ಟ್ ಫೀನೇ ಕಟ್ಲಿಲ್ವಾ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಟ್ಟಿದೀವಿ.
ಇಲ್ಲಿದೆ ಹೇಳ್ರಿ.
ಸ್ವಾಮಿ ಇಲ್ಲಿ ಕಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಯಾವಾಗ?
ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ್ಮೇಲೆ ಕಟ್ಟಿದ್ದು ಸ್ವಾಮಿ. 12/3/2000.
12/3 ನೀವು ಅಪೀಲ್ ಹಾಕಿರೋದು ಫೆಬ್ರವರಿಲಿ.
22ರಲ್ಲಿ ಸ್ವಾಮಿ ಹಾಕಿದ.
12/3/22 ನೇನ್ರಿ ನೀವು ಕಟ್ಟಿರೋದು.
ಹೌದು, ಎಸ್ ಮೈ ಲಾರ್ಡ್.
12/3 ಅದೇ ಅಪೀಲ್ ಹಾಕ್ತಾ
24
ಅಪೀಲ್ 24 ಅಲ್ಲಿ
ಹೌದು.
ರಸೀಟ್ ಹಾಕಿ ಹಾಕರದ್ನ.
ಮೈ ಲಾರ್ಡ್ ಫೈಲ್
ಎಷ್ಟು ಕಟ್ಟಿದ್ರಿ ಈಗ?
85 rupees.
85, but the difference are make good ಮಾಡೋದು.
I will file it.
Appellate court ಅಲ್ಲಿ.
I will complain.
The appellant counsel submits that he has paid the court fee of rupees 85 receipt ಹಾಕಿ.
Yes, my lord.
On
12/3/2024.
12/3/2024.
Yes, my lord.
And then sir directed to produce the receipt and office is directed to verify regarding court fee.
42.
Other office subjects are not complained, madam.
ಯಾವ್ದ್ರಲ್ಲಿ?
Copy, ಅದರಲ್ಲಿ 41 ಅಲ್ಲಿ
ಅದ್ರಲ್ಲಿ
copies
ಇನ್ನೂ ಇದೆಯಾ
also.
madam?
12 objections ಇದೆ. ಕಾಪಿನ ಸರ್ವ್ ಮಾಡಿಲ್ಲ.
ಅದ್ರಲ್ಲಿ ಇದಿದೆ 2 ಅಂತಲ್ಲ.
ನನಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ. Let him serve a copy, madam. It's a concurrent finding.
ಈ court fee ಅದೊಂದೇ.
So 40 year was litigation, madam.
ಈಗ 41 ತಾನೆ. 41 ಅಲ್ಲಿ ಒಂದೇ ಇರೋದು. ಹಾ, ಯು ಪೇ ಕೋರ್ಟ್ ಫೀ, ಡಿಫರೆನ್ಸ್ ಕೋರ್ಟ್ ಫೀ ಪೇ ಮಾಡಿ, ಜೊತೆಗೆ 4th ಟೈಮ್ ಬಂದಿದೆ ಆನ್ ಕಾಸ್ಟ್ ಆಫ್ rupees 500 ಕಂಪ್ಲೈ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಮಾಡಿ ಮೇಡಮ್.
42. KV Narasimhan.
For the appellant,
Occupancy in husband name of appellant number 1 as in cast title of OS and along with note.
my lords, in the judgment of RA, it is wrongly mentioned as Siddhalinga Gowda.
Court below ಹಾಕಿದಾರ? ಆಯ್ತು, accepted. Post the matter for admission. Next.
43.
Not forthcoming presiding officer signature at 3rd page. Operative portion of OS judgment. Officer counsel submission is accepted. Next, ಇನ್ನೊಂದು ಎರಡನೇದೇನ್ರಿ?
Next is with respect to the.
Copy of OS with that of IA. IA not matches with.
Lords, we have given a detailed description that tallies with the RA judgment. RA judgment is at page number 90.
Not tallies ಅಂತ.
ಇಲ್ಲ, OS ಅಲ್ಲಿ tallied ಇಲ್ಲ, but we have given a detailed description in the RA itself. The same is tallying with the IA description. Lordships may kindly see page number 90 of my appeal memorandum.
The same tallies with RA decree.
Yes. It tallies with the RA decree. RA decree, what you have added is that east to west towards southern side 35 feet anta. That is the same description given in the IA. The Lordships may kindly see at page number 90.
Same description.
Same description.
Council submission is accepted in view of correctly mentioning the schedule in RA and also in IA.
Please, Madam, post.
Post the matter for admission.
44.
Non-compliance of office objection second time.
I am appealing for appellant, my lord.
Yes,
My lord,
counsel,
in Respond number 9, 11, 11A and 18 have died during the pendency of regular.
Comply ಮಾಡಕ್ಕೆ ಎಷ್ಟು ದಿವಸ ಬೇಕು ಹೇಳ್ರಿ counsel.
I have complained, my lord. I have complained. I have filed ಎಲ್ಲರ application.
Compliance ಇದೆಯಾ ಮೇಡಮ್ ನೋಡಿ.
ಎಲ್ಲರ
application ಹಾಕಿದೀನಿ ಅಂತಾರೆ compliance ಗೆ.
ಪೆಜಿನೇಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಇದು ಇದನ್ನ ಮಾಡ್ತಾನೆ. ಪೆಜಿನೇಟ್ ಮತ್ತೆ ಡೇಟ್ ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ನೋಡಿ, IS ಹಾಕಿದಿರಿ, ಪೇಜಿನೇಷನ್ ಮಾಡಿಲ್ಲ, ಪೇಜಿನೇಷನ್ ಇದೆ ಅಂತ. 2 weeks time granted. 2 weeks time granted to comply with office objections. ಅದೇನೆ ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಿ 2 ವಾರ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದು.
45.
ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ 3rd time. ಕಾಸ್ಟ್ ಹಾಕಿದಾರ 1,000 ಕಟ್ಟಿದ್ರಾ?
ಕಾಸ್ಟ್ ಪೇಡ್
ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿದ್ರಾ?
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ ಮೇಲೆ.
ಮಾಡಿಲ್ಲ, ಮತ್ತೆ ಫರ್ದರ್ ಕಾಸ್ಟ್ ಆಫ್ rupees 500.
ಆಲ್ರೆಡಿ 1000 is paid. 1000 ಕಾಸ್ಟ್ is paid.
ಏನ್ ಮಾಡೋಣ? ನಾನ್ ಹಾಕಿಲ್ಲ, ನಾನು 1,000 ಹಾಕೋದೇ ಇಲ್ಲ. ಸೆಕೆಂಡ್ ಟೈಮ್ಗೆ 3rd time ನಾನು ಕಾಸ್ಟ್ ಹಾಕೋದಿಲ್ಲ. ಈಗ ಬಟ್ ಬೇರೆಯವ್ರು ಹಾಕಿದಾರೆ, ಕಟ್ಟಿದಿರಿ ಅದನ್ನ ಅಷ್ಟೇ.
Within 2 weeks we will comply.
3rd time ಮೇಡಮ್ ನೋಡಿ.
3rd time ಮೇಲೆ.
ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಾಗ್ಲೇ ಕಾಸ್ಟ್ ಹಾಕಿದಾರ? ಕೊಡಿ ನೋಡಿ, ಹಿಂದಿಂದ ಏನಾಗಿದೆ, ಹಿಂದೆಲ್ಲ ಏನಾಗಿದೆ? ರಿಜಿಸ್ಟ್ರಾರ್ ಮುಂದೆ ಎಷ್ಟು ಸರಿ ಹೋಯ್ತ್ರಿ?
2 times ಮೇಲೆ.
2 times
ಮೇಲೆ.
ಹೋಗ್ಲೇ ಅಲ್ವಾ ನೀವು? ಈ ಕಾಸ್ಟ್ ಕಟ್ಟಿದೀರಾ?
ಪೇಡ್ ಮೇಲೆ.
ಯಾವಾಗ ಮತ್ತೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋದು ನೀವು?
Within 2 weeks.
Submits that he has paid the cost and again 6th time and hence finally 2 weeks time granted to comply with office objection. If office objection is not complied and not complied, appeal is dismissed without reference to the bench.
Much obliged.
46.
Non-compliance
Yeah,
of
for
office
applying.
objection,
This matter, my
fixed
lord,
time.
my lord, this NOC brief, my lord. My lord, in this matter, my lord, the appellant number 2 name wrongly shown in the appeal.
Discrepancy in the name of appellant
Yes.
number 2 stated as Chikkanna
Yes.
in RSA and
Come on, that.
Chikkanna ಅಂತ ಆಗಿದೆಯಾ?
It's a typical error in the appeal order.
ಎಲ್ಲಿ? ಆರ್ಯನಲ್ಲಿ.
ಹೌದು.
Typographical error in mentioning the name of appellant is overruled. ಆಮೇಲೆ ಅದ್ ಬಿಟ್ರೆ ಬೇರೆ ಏನಾರು ಇದೆಯಾ? ಇನ್ನು ಎಷ್ಟಿದೆ ಮೇಡಮ್? ಚಿಕ್ಕಣ್ಣ ಚಿಕ್ಕಮ್ಮ ಅದ್ ಬಿಟ್ರೆ ಇನ್ನು 3 ಇದೆಯಾ?
ಅದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ಮೇಲೆ ಆಫೀಸ್ ಫರ್ದರ್ ರೈಸ್ಡ್ ಎ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಿ.
The type copy of the judgment and the disclosure date of waste to be correctly stated in the agreed para, granting of the parties to be stated specific.
ಇದೆಲ್ಲ ಮೊದ್ಲಿಂದಲೇ ಇದೆಯಾ? ಬಿಗಿನಿಂಗ್ ಇಂದಲೇ ನೋಡಿ. ಹೊಸದಾಗ ಹಾಕಿದಾರ? ಹೊಸ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಳೇದ?
So 2 times in the ಆತರ ಬರ್ತಾ ಇದೆ. 2 times in the ಆತರ ಬರ್ತಾ ಇದೆ.
2 times ಇಂದ.
First ಇರ್ಲಿಲ್ಲ. ಆಮೇಲೆ ತೆಗ್ದಿದ್ದಾರೆ.
Told. Finally, 2 weeks time granted to comply with office objections. If the same is not complied, appeal is dismissed without reference to the bench. Last ಹಾಕಿಲ್ಲ. ಯಾಕಂದ್ರೆ ಆಮೇಲೆ ರೈಸ್ ಮಾಡಿರೋದು.
47. ನಾಗವೇಂದ್ರ HS.
Non-filing of genealogical tree along with council submission. ಹೇಳ್ರಿ ಏನು?
Genealogy above ಅಪ್ಲೈ ಮಾಡಿದೀವಿ, ಇನ್ನೇ ಸಿಕ್ಕಿಲ್ಲ ಮೇಡಮ್.
ಇಲ್ಲ. ಎಷ್ಟನೇ ಸರಿ ನೋಡಿ ಮೇಡಮ್?
ಅರ್ಲಿಯರ್ ಕಾಸ್ಟ್ ಪೇ ಮಾಡಿದ್ವಿ.
rupees ಕಾಸ್ಟ್ ಹಾಕಿದ್ರು. ಫಸ್ಟ್ ಟೈಮ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಾಗ ರಿಜಿಸ್ಟರ್ ಮುಂದೆ 3 times ಹೋಗಿದೆ ಸರ್.
3 times before the registrar. ಕೋರ್ಟ್ ಮುಂದೆ
ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಾಗ 1000 rupees
ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ದಾರೆ.
ಕಾಸ್ಟ್ ಪೇಮೆಂಟ್.
ಆಯ್ತು. Finally, 2 weeks time granted to comply with office objections. If not complied, appeal is dismissed without reference to the bench.
48.
Discrepancy in the name of respond number 5 as in cast title of RA and RS along with council submission. ಹೇಳಿ. ಏನಾಗಿದೆ ಹೇಳಿ?
The same one. Number 5 and appellant number 5 are the same.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5 ಹೆಸರು ಏನೋ ಸರಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಹೇಳ್ರಿ ಅದು ಏನಾಗಿದೆ ಅಂತ.
OS ಅಲ್ಲಿ ಚಂದ್ರಯ್ಯ ಅಂತ ಹಾಕ್ತಿವಿ ನಾವು.
OS ಅಲ್ಲಿ
ಚಂದ್ರಯ್ಯ ಅಂತ. ಚಂದ್ರಯ್ಯ. ಆಮೇಲೆ ಅವರು ಆ ರೆಗ್ಯುಲರ್ ಅಪೀಲ್ ಹಾಕಿದ್ರು RA. ಅದರಲ್ಲಿ ಬಿಂದ್ರಯ್ಯ ಅಂತ ಅವರೇ ಹಾಕೊಂಡ್ರು.
ಅದರಲ್ಲಿ
ಬಿಂದ್ರಯ್ಯ ಅಂತ
ಹಾಕಿದ್ರು.
ಅವರೇ ಪ್ರಿಪೇರ್ ಮಾಡಿ ಸೇಮ್ ಪರ್ಸನ್. ಸೇಮ್ ಪರ್ಸನ್.
ಆಯ್ತು.
ಅದನ್ನ ನಾವು ಚಂದ್ರಯ್ಯ ಬಿಂದ್ರಯ್ಯ.
RSA ನಲ್ಲಿ ಏನ್ ಮಾಡಿದಿರಿ?
ಬಿಂದ್ರಯ್ಯ
ಏನ್ ಮಾಡಿದ್ರ? ಚಂದ್ರಯ್ಯ ಮಾಡಿದ್ರ?
ಚಂದ್ರಯ್ಯ alias ಬಿಂದ್ರಯ್ಯ.
ಈಗ ಮಾಡಿದ್ದಾರೆ. ತಗೊಳ್ಳಿ. The appellant counsel submits that while filing the appeal, the name is mentioned as Bindraya, but in the trial court mentioned as Chandraya, and hence both the names are mentioned in RSA, and hence counsel submission is accepted. Post the matter for admission. Next.
49.
Ravindra VS, non-compliance of office objections.
RA ಒಳಗೆ
Non-arraying of appellant number 2.
appellant number 2, I have made a submission along with my lord. Appellant number 2, that one Vairama is not given a wakalat, hence she has been made as a respondent number 8 in this appeal.
In this appeal. ಆಯ್ತು.
ಅಷ್ಟೇ ಅದೊಂದೇ.
Or plaintiff?
ಅಲ್ಲ, she is appellant.
Plaintiff number 2 in
ಹೌದು. ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನೋಡಿ.
ಅಪಲೆಂಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಬಂದಿದ್ರು ಅವರು.
ಅಪೀಲ್
ಈಗ RSA ನ ಬರಲಿಲ್ಲ.
RS ಒಳಗೆ
ಆಯ್ತು. ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಇಸ್ ಅಕ್ಸೆಪ್ಟೆಡ್. ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್. ಅಲ್ಲದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಾ?
ಅಲ್ಲ, ಮೆಮೋ ಹ್ಯಾಸ್ ಬೀನ್ ಫೈಲ್ಡ್.
ಎರಡಿದೆ. Respondent number 7 and defendant number 3 in the OS not filled party in RA clarified.
ಯಾವುದು?
Respondent number 7 and in RSA and defendant number 3 in OS.
ಅದ್ರ ಬಗ್ಗೆ ಇಲ್ಲಿ ಏನು ಸಬ್ಮಿಷನ್ ಇಲ್ಲ ಏನು?
ಇಲ್ಲ, ಇನ್ಫ್ಯಾಕ್ಟ್ ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಮೈ ಲಾರ್ಡ್ ದಿ ಮೆಮೋ ಇಟ್ ಸೆಲ್ಫ್. ಎಂಟೈರ್ ಮೆಮೋ ಹಾಕಿದೀನಿ. ಸಬ್ಸಿಕ್ವೆಂಟ್ ಅದೇ ಎಲ್ಲ ಹೇಳ್ಬಿಟ್ಟು ಹಾಕಿದೀನಿ. ಲಾರ್ಡ್ ಇದೊಂದು ತೆಗೆದಿದ್ರು ಫರ್ದರ್ ಅಬ್ಜೆಕ್ಷನ್.
ಮೆಮೋ ಹಾಕಿದಾರಲ್ಲ, ಬೇರೆಲ್ಲ ಅಕ್ಸೆಪ್ಟ್ ಆಗಿರ್ಬೇಕು ನೋಡಿ, ಇಲ್ವಾ?
Otherwise I will comply. 2 days ಕೊಟ್ರೆ
ಆಯ್ತು. 2 days time given to comply with if any other office objections.
Please.
Post the matter for admission. Next 50. Awaiting service of notice to R2 to R35. ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿರೋದು ನೋಡಿ ಮೇಡಮ್? 57 ನಾ? List is smarter than 6-8. Await ಅಂತ ಹಾಕ್ಬಿಡಿ. Await. 6-8. ಹೇಳಿ.
ಇದರಲ್ಲಿ ಮೇಡಮ್
ನೀವು R1 ಗೆ.
House R1. Previously, this appellant himself has been filed a suit for a partition. Appellant file ಮಾಡಿದ ಸಂಪಣ್ಣ who is a RSA number 69 ಅಲ್ಲಿ appellant suit for partition file ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. Still for a dragging of matter ಅವ್ರು ಇಲ್ಲಿ ಬಂದು ಇದ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ. ಇನ್ನು partition suit ಇನ್ನು still pending ಇದೆ ಸ್ವಾಮಿ. Only 1/5 share.
ಸರಿ ಈಗ ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ ಇದ್ರಲ್ಲಿ
ಕಾಪೀಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ
ನೋಟಿಸ್ ಜಾರಿ ಆಗ್ಬೇಕಲ್ಲ.
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಹಾಕಿ ಕೊಡಿ ಅದೇನು ಮೆಮೊ ಅಂದ್ರೆ ಅದು ಏನಾಗ್ತದೆ ಸೂಟ್ ಹಾಕೋರೆ ಅಂತನಾ?
ಹೌದೌದು ಮೆಮೊ along with certified copies of the suit. Since year of 2009 they have been filed a partition suit without making a party of this respondent number 1 on 29, 30, 31.
Sorry, the counsel for the R1 has filed memo along with the documents and the same is taken on record.
An interim order may be extended till next stage.
Interim order ಇದೆಯಾ?
ಹೌದು ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಅವರು ಏಲಿಯನೇಟ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ ಪ್ರಾಪರ್ಟಿ.
ನೀವು ಯಾರಿಗಿದ್ರಲ್ಲಿ?
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಸ್ವಾಮಿ.
ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೇಕು ಅಂತ
ಅಲ್ಲ R1 ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾರಾಟ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸ್ಟೇ ತಗೊಂಡು ಮಾರಾಟ ಮಾಡ್ತಾ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದಕ್ಕೆ ಇಂಟ್ರಿ ಮಾಡ್ರೆ.
ಈಗ ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಕೊಟ್ಟಿದೀವ ನಾವು.
ಹೌದು
Connected matter. In the connected matters, he is appearing.
ಯಾವ್ದ್ರಲ್ಲಿ?
50.1, he is appearing for the respondent.
Not to alienate. Next date of ಆಯ್ತು. Entry order
Connected.
granted in favor of the respondent is extended till next date of hearing.
The connected matter.
Connected ಅಲ್ಲ?
Oh, please.
RSA 69 ಅಲ್ಲ?
Please.
ಇಲ್ಲ ಎರಡರಲ್ಲೂ ಕೊಟ್ಟಿದೀವಿ.
ಹೌದು.
Both the appeals ಅಂತ ಮಾಡಿದೆ.
Sorry.
Both the appellants are directed not to alienate the property till next date ಅಂತಿತ್ತು. ಅದನ್ನೇ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದೀವಿ ಅಷ್ಟೇ. Next 51. Non-arraying of different number 11A. Annarakanda Kamava of
She's
trial
dead,
court.
my lord. She is dead, my lord, and her LRs are already on record.
ಯಾರು ಅದನ್ನ ಹೇಳ್ಬೇಕಲ್ಲ ನೀವು?
ನಾನು ಹೇಳಿದೀನಿ, ಸಬ್ಮಿಷನ್ ಬರ್ಕೊಟ್ಟು.
ಹೇಳಿದಿರಾ? ಎಲ್ಲಿ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇನೆ ಅವರು LRs are ಫಸ್ಟ್ ಅಪೀಲ್ ಅಲ್ಲೇನೆ LRs are on.
ಈಗ ಆಲ್ರೆಡಿ ಇದಾರೆ LRs.
Yes, yes.
The council submits that already LRs are already on record of Srimati Annarakanda Kamava, who has been arrayed as different number 11A, and hence council submission is accepted. Next, third time B.B. Sitaramaya.
There is delay, my lord, in this 130 days.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಇದರಲ್ಲಿ 51 ಅಲ್ಲಿ.
ಡಿಲೇನಾ?
Delay ಇದೆ.
But the admission ಬರ್ಬೇಕು ಅದ್ ಬರ್ಲಿ ನೋಡ ನಾವೇನ್ ನೋಡ. Post the matter for admission. Next.
At page number 57, my lord, this is with respect to court fee. At page number 57, my lord. My lord, before the trial court fee of rupees 225 file ಕೊಡಿ.
225 paid.
Paid. RN ಅಲ್ಲಿ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಅಲ್ಲಿ 200 ಅಂತ ಹೇಳ್ತಾರೆ. ಯಾಕೆ ಡಿಫರೆನ್ಸ್ ಆಯ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. ನಮ್ ಸಬ್ಮಿಷನ್ RN ಅಲ್ಲಿ ಹೇಳಿರೋ ಸರಿ.
ಆರ್ಯ ಹಾಕಿದ್ದಾರು?
ನಾವೇ ಹಾಕಿದ್ದು.
ನೀವೇ ಹಾಕಿದ್ದು?
ಹೌದು, ನಾವ್ ಹೇಳಿರೋ ಸರಿ ಇದೆ. ಆದ್ರೂ ಟು ಅವಾಯ್ಡ್ ದಿ ಕನ್ಫ್ಯೂಷನ್ ಇನ್ ದಿ ಕೋರ್ಟ್ ಫೀ ವಿ ವಿಲ್ ಪೇ 25 rupees in the RA and also this court.
ಇಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಿ?
200 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದೀವಿ, ಈಗ 50 ರೂಪಾಯಿ ಕಟ್ಟಿದ್ದೀವಿ.
ಈಗ ಅಡಿಷನಲ್ ಕೊಟ್ರ?
50 ರೂಪಾಯಿ ಕಟ್ಟಿದ್ದೀವಿ. ಹಂಗಾಗಿ ಒಂದು ಮತ್ತೆ ಟು ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ಕೋರ್ಟ್ ಫೀ ಅಂಡ್.
ಈಗ ಯಾವಾಗ ಕಟ್ಟಿದಿರಿ ಹಿಂದೆ?
ಅದು ಮುಂಚೆನೆ ಕಟ್ಟಿದ್ದು, ರೆಸಿಪ್ಟ್ ಇಲ್ಲ, ಇವತ್ತು ಇನ್ನೊಂದ್ಸಲಿ ಕಟ್ಟಿದೀನಿ, ಮಿಸ್ ಆಗಿತ್ತು.
The counsel for the appellant submits that he has paid the deficit court fee of 50 rupees, including of the deficit of RA court. And hence registry is directed to
verify,
and if it is in order, post the matter.
ಇನ್ನೂ ಒಂದಿದೆ
admission.
ಇನ್ನೂ
ಒಂದೇನಿದೆ?
ರಿಗಾರ್ಡಿಂಗ್ ನೇಮ್ ಆಫ್ R5 ಅಟ್ ಪೇಜ್ ನಂಬರ್ ಅಲ್ಲ, ವಿಲೇಜ್ ನೇಮ್ ಆಫ್ R5.
Village name of R5.
ಅಟ್ ಪೇಜ್ ನಂಬರ್ 26 ಪಮ್ಮೇನಹಳ್ಳಿ ಅನ್ನೋದು MMA ಬಿಟ್ಬಿಟ್ಟು PAMA ಮಾಡವ್ರೆ. ಅದು ಸ್ಪೆಲ್ಲಿಂಗ್ ಮಿಸ್ಟೇಕ್ ಅಷ್ಟೇ. ಇಟ್ ಮೇ ಬಿ
ಕರೆಕ್ಟ್ ಮಾಡಿರಾ?
ನಾವು ಅಪೀಲ್ ಕರೆಕ್ಟ್ ಮಾಡಿದೀವಿ.
ಆಯ್ತು. R5 in the
ವಿಲೇಜ್ ನೇಮ್ ಆಫ್ R5.
The village name of R5 is wrongly typed in the ಯಾವ್ದ್ರಲ್ಲಿ?
ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಂಡ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
Appellate court judgment.
ಹೌದು.
And rightly mentioned in the appellate court.
In this
the other office objection is also overruled.
Yes. ಈ ಉಳಿದವೆಲ್ಲ ಕಂಪ್ಲೈ ಆಗಿದೆ.
In this RS ಏನ್ಬಿಡಿ.
ಹೌದು, ಉಳಿದವೆಲ್ಲ ಕಂಪ್ಲೈ ಆಗಿದೆ.
ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ post the matter for admission.
53.
Bhargav. Third time.
Your lordships, all objections has been complied with.
ಕಳೆದಕ್ಕೆ ಅಡ್ಮಿಷನ್ ಒಂದು ಡೇಟ್ ಯಾವ್ದಾದ್ರು?
ಡೇಟ್ ನಾನ್ ಕೊಡಲ್ಲ. ನಾನೆಲ್ಲ ಅಪ್ ಟು ಇನ್ನು another 2 weeks ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಅದ್ರೊಳಗೆ ಒಂದು ಡೇಟ್ ಯಾವ್ದಾದ್ರು?
ಆಯ್ತು. ಲಾಸ್ಟ್ ವೀಕ್ ಆಫ್ ಜುಲೈ ಅಂತ ಹಾಕ್ಬಿಡಿ.
Lordship, all office objections have been complied with.
ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಹಾಕ್ತಾರ್ರಿ?
ಇಲ್ಲ, ಒಂದು clarification.
ಎರಡಿದೆ ಅಂತ ನೋಡಿ.
Clarification.
Plaintiff.
Plaintiff,
two death.
second plaintiff died during the pendency of RA, your lordships.
RA.
And he was, his legal
Whether
representative.
his LRs are brought on record.
They were on
in the
record.
appeal itself.
In the appeal itself, yes.
Appeal itself ಅಂದ್ರೆ ಮತ್ತೆ ಇಲ್ಲಿ date of death ಬೇಕು madam.
Page 13, your lordships.
ಅಲ್ಲೇ ಈಗ LRs ತಂದಿದ್ರೆ appeal ಅಲ್ಲಿ. Then why they are
The only issue is that the plaintiff, second plaintiff Krishna's name was not reflected in RA judgment.
plaintiff number 2 ನ ಸತ್ತೋಗಿದ್ದಾರೆ
ಅವ್ರು ಸತ್ತೋಗಿದ್ದಾರೆ, ಅವ್ರ ಎಲ್ಲಾರ್ಸ್ ಎಲ್ಲ ಬಂದಿದ್ದಾರೆ,
LRs
ಎಲ್ಲ ಬಂದಿದ್ದಾರೆ in RA judgment ಒಂದು.
ಇದಾರೆ. ಈಗ ಹಾಕ್ಬೇಕು ಇವ್ರಿಗೆ ಡೆತ್ ಡೇಟ್. ಡೆತ್ ಅಂತಂದ್ರೆ ಸೇಮ್ ಇದನ್ನ ತೋರ್ಸಿರ್ತಾರೆ ಮೇಡಮ್ ಹಿಂದೆ. ಆಲ್ರೆಡಿ ದೇ ಆರ್ ಬ್ರಾಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ಇನ್ ಅಪೀಲ್ ಅಲ್ವಾ. ನೋಡಿ ದ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರಿಗಾರ್ಡಿಂಗ್ ನಾಟ್ ಫರ್ನಿಶಿಂಗ್ ಆಫ್ ಡೇಟ್ ಆಫ್ ಡೆತ್ is overruled since the LRs were already brought on record before the appellate court itself. ಆಮೇಲೆ ಮತ್ತೆ ಅದೇನೆ. Other office objection is also overruled. Post the matter for admission.
Your lordships, there is urgency in this matter.
Registrar judicial ಕರೀರಿ ಅದು ಯಾರನ್ನ ಹಾಕಿದಾರ ಸ್ಕ್ರೂಟಿನಿಗೆ.
I request your lordships to have this matter tomorrow, your lordships.
ಏನ್ tomorrow?
Urgency ಇದೆ.
ಏನ್ ಅರ್ಜೆನ್ಸಿ 23 ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ನಿಮಗೆ.
Suit is with respect to permanent injunction.
Matter in the end of July.
Your lordships kindly have it.
No,
Monday.
For compliance you have taken 1.5 years. ಮತ್ತೆ ಈಗ ಅರ್ಜೆನ್ಸಿ.
ಇಲ್ಲ ಇವಾಗ ತೊಂದರೆ ಕೊಡ್ತೀರಾ ಅದಕ್ಕೆ.
ಏನ್ ಮಾಡಕ್ಕಲ್ಲ.
Monday
complied with when the appeal was filed.
At least next week, your lordship.
Next week ಎಲ್ಲ ತುಂಬಾ ಇದೆ ಹಾಕ್ಬಿಟ್ಟಿದೀವಿ ನಾವು. ನೀವೇ ನೋಡ್ತಾ ಇದ್ದೀವಿ ದಿನ 130 ಮ್ಯಾಟರ್ಸ್ ಬರ್ತಾ ಇದೆ.
A date may
ರೀಚ್ ಆಗಲ್ಲ, ಮತ್ತೆ ರೀಚ್ ಆಗಲ್ಲ.
Any date, at least a date may be fixed, your lordship.
July end of July. Next ಗಂಗಾಧರಪ್ಪ ಎವಿ ನೆನ್ನೆ ಎಲ್ಲ ರೀಚ್ ಆಗಿಲ್ಲ ಇವನ್ ಅಡ್ಮಿಷನ್. ಹಿಂಗಾದ್ರೆ ಇನ್ನೇನಾಗ್ತದೆ.
Defendants are the family members. Suit is decreed.
Non-arraying of defendant number 4 as
Fourth
respondents in this
defendant is
appeal
the
along
wife
with
of third defendant. Fourth defendant is the wife of third defendant. That suit is decreed. Appeal is filed by the.
I3 defend number 4.
Now I have filed the application IA number 2 of 24 and 3 of 24 for impleading the fourth defendant as one of the appellant. That application may be allowed, my lord. And the fourth defendant may be permitted to challenge the decrees of the courts below.
Alari non-arraying of defend number 4 as respondent in this appeal.
On the last
counsel submission ಅಂತಿದೆ. ನೀವು defend number 4 ನ ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅಂತ
ಮಾಡಿದೆ. ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀನಿ.
ಯಾವಾಗ?
IA number 2 of 24 and 3 of 24.
ಏನಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಿರಿ? ಅವ್ರು
For
ಸತ್ತೋಗಿದ್ದಾರೆ.
impleading the fourth defendant.
ಈಗ ಇಂಪ್ಲೀಡ್ ಮಾಡಕ್ ಹಾಕಿದಿರಾ?
ಹೌದು, as the third appellant. IA number 2 is for impleading.
ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರೆ, ಬಿಟ್ಟೋಗಿತ್ತು. ಆಯ್ತು.
ಅದರಲ್ಲಿ ಅಪೀಲ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿರ್ಲಿಲ್ಲ. By oversight, my lord.
Council submits that now an application is filed to bring the defend number 4 on record as per IA number 2 of 24 and 3 of 24.
As that is permission to file appeal by the fourth defendant because she was not made as party in the appellate court.
Appellant ಮಾಡಿದಿರಾ?
Appellant ಮಾಡಿರೋದು. Third appellant. ಹೌದು. Those applications may be allowed, my lord.
Hence put up those 2 applications.
It has already been put up ಆಗಿದೆ. Wakalat is also filed, my lord.
Permission ಬೇರೆ impleading ಬೇರೆ ಇದೆಯಾ?
Permission to challenge the decrees of the courts below.
Heard the IA number 2 of 24 and 3 of 24 and it is submitted that inadvertently the defend number 4 has not made as party and now seeks the permission of this court to file appeal on behalf of defend number 4 also. Correct?
Yes.
Correct alla?
ಹೌದು.
And for the reasons stated in the accompanying application of affidavit, both the AS are allowed.
Matter may be posted for admission tomorrow.
Carry out amendment.
Please, I will carry out.
Amended appeal memo within 2 weeks. List this matter for
May
admission
one submission.
the end of July.
That suit for recovery of possession has been decreed. Now, my lord, in the execution proceedings, delivery warrant has been issued.
Amend ಮಾಡಿ.
ಅಲ್ಲ ಈಗಲೇ ಮಾಡ್ತೀನಿ. It may be taken up tomorrow, my lord.
Tomorrow ಇಲ್ಲ 2 ವಾರ.
Lord, you last may kindly see the order sheet of the execution court, my lord.
End of July ಅಷ್ಟೇ.
Lord, date may kindly be. Date may be fixed, my lord.
End of July ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
Any date, my lord. Before 1st of August, my lord. because the trial court.
ನೋಡ್ರಿ ಲಾಸ್ಟ್ ವೀಕ್ ನಾನ್ ಕುತ್ಕೊಳ್ಳಲ್ಲ, ರೋಸ್ಟರ್ ಚೇಂಜ್ ಆಗ್ತದೆ, ಅದಕ್ಕೆ ಎಂಡ್ ಆಫ್ ಜುಲೈ ಅಂತ ಕೊಟ್ಟಿದ್ದೀನಿ, ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಅರ್ಜೆಂಟ್ ಅವತ್ತು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್
55 ಭಾರ್ಗವ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಎರಡನೇ ಸತಿ ಬರ್ತಾ ಇರೋದು.
ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಸೆಕೆಂಡ್ ಟೈಮ್
We have paid the DCF.
Second time.
Yes, your lordship.
ಹಾ
DCF we have paid and
DCF ಕೊಟ್ಟಿಲ್ಲ.
we have paid your lordship.
ಯಾವಾಗ?
250 extra, that day itself we have.
ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಿ ಮೇಡಮ್? ರಸೀಟ್ ಹಾಕಿದೀರಾ?
We paid on
ಅದೊಂದೇ ಮೇಡಮ್?
10/6 your lordship.
ಸರ್ ಇನ್ನ ಒಂದು proof of court fee paid before
25th March itself we have paid one, your lordships. Later on DCF.
Council submits that the deficit court fee is paid in the month of March
March as well as in the DCF later on 6th your lordships.
and 6th of June,
6 of June.
10/6 of June, and hence directed to produce the receipt along with memo,
Lordships, another one is in
Along-
RA we have paid.
along with memo, and also submit regarding deficit court fee not paid in respect of RA. Deficit court fee of
Deficit
ಅಲ್ಲ ಸರ್ ಅಲ್ಲಿ
Deficit
court fee ಕೊಡ್ಬೇಕು ಅಲ್ಲಿ before.
here your lordships.
and also directed to comply with regarding
Your lordships,
of payment of court fee in RA court within
RA we have
within-
paid your lordship. It may
within 2
be-
weeks. ರೀ ಅಲ್ಲಿ ಕೊಟ್ರಿ ಅವ್ರ ಆಫೀಸ್ನವ್ರು ವೆರಿ ಮಾಡೋದ್ ಬೇಡವಾ, ಚೆಕ್ ಮಾಡೋದ್ ಬೇಡವಾ ನೀವು? ನಾನ್ ವೆರಿಫೈ ಮಾಡ್ಲಾ?
But valuation.
You file it in the office.
Is your lordships.
ಹಾ
But the valuation slip is not there, your lordship. That is the reason if.
won't explain in the scrutiny branch.
56
Hmm.
HP ಇಲ್ಲ ಅದ.
Non filing of necessary application to
number.
RA different number 1, 2, 7 to 12.
These persons are the defendants in the trial court, my lord.
Huh?
By oversight, these persons are not been party made before the first appellate court.
ಹಾ
Now we have made a party before this, sir.
ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡ್ದಲ್ಲ ಇಲ್ಲಂಗ್ ಪಟ್ಟಿ ಮಾಡ್ತೀರಿ?
ಅಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ. These
ಟ್ರಯಲ್
persons-
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದಾರೆ ರೀ.
ಇದಾರೆ.
ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪೀಲ್ ಹಾಕಿದ್ದಾರು,
ನಾವೇ ಹಾಕಿದ್ವಿ.
ನೀವೇ ಹಾಕಿದ್ರಿ.
By
ನೀವು
oversight
ಅಲ್ಲಿ ಬಿಟ್ಬಿಟ್ಟು
article.
ಇಲ್ಲಂಗ್ RSL ಕೇಳ್ತೀರಿ? How you can array them? They are not parties to the first appellate court.
The suit for partition.
ಮತ್ತೆ their right has been defeated in filing an appeal. How you can make them as party? ಇಲ್ಲೂ ಬಿಡ್ಬೇಕಾಗುತ್ತೆ ಅಷ್ಟೇ. Their rights has not been adjudicated in the appellate court.
Please.
ನೋಡಿ ಏನ್ ಮಾಡ್ತೀರಿ ನೋಡಿ.
ಅಲ್ಲ, I am for
ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ
caveator,
ಪಾರ್ಟಿ
madam.
ಮಾಡಕ್ಕಾಗಲ್ಲ.
I am for the caveator.
We have to-
ನೀವು
Caveator.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಾರಿಲ್ಲ?
ಇಲ್ಲ,
Appellant counsel is directed to serve a copy on the caveator counsel.
ಮಾಡಿದ್ವಿ.
ಯಾವಾಗ?
ಇಲ್ಲ.
ಆಲ್ರೆಡಿ ಅಪ್ಲಾನ್ಮೆಂಟ್ ಹಾಕಿದ್ವಿ.
ನೋಡ್ರಿ, ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಸರಿ, ಅವ್ರು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀನಿ ಅಂತಾರೆ.
ನಿಮ್ ಕುಲಿಗೆ ಮಾಡಿದೀನಿ ಸರ್.
ಯಾವಾಗ ಹಾಕಿದ್ರೆ ಅಕ್ಲಾನ್ಮೆಂಟ್? ಎಲ್ಲಿದೆ
ಇಲ್ಲ.
ಅಕ್ಲಾನ್ಮೆಂಟ್ ಹಾಕಿದೀರಾ? ಎಲ್ಲಿದೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ಕೆ? ಕೇವಿಯೇಟರ್ ಇದಾರೆ. ಹಾ
ಕುಲಿಗೆ ಸರ್ ಮಾಡಿದ್ವಿ.
ಮಾಡಿದ್ ಎಲ್ಲಿದೆ? ನಿಮ್ಮ ಹತ್ರ ಇರ್ಬೇಕಲ್ಲ ಅಕ್ಲಾನ್ಮೆಂಟ್. ಹೋಗ್ಲಿ, ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ಕೋರ್ಟ್ಗೆ ಹಾಕಿದೀರಾ? ಎರಡರಲ್ಲಿ ಬೇಗ ಹೇಳ್ಬೇಕು. ಇಲ್ಲ, ಕೋರ್ಟಲ್ಲಿ ಹಾಕಿಲ್ಲ. ಆಯ್ತು, ಒಂದು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ.
ಆಯ್ತು.
The council is directed to serve a copy on the caveator counsel forthwith and comply with office objections. ನೋಡಿ, ಡಿಲೀಟ್ ಮಾಡ್ಕೋತೀರಾ ಏನ್ ನೋಡಿ?
ಆಯ್ತು.
They are not parties in the appeal. Next, interlocutory application.
57
For the petitioner, my lord.
Yes, counsel, ಹೇಳಿ.
My lord, in this case, I have filed the inventory and final accounts within the thing. There was a delay, my lord, due to the COVID time and subsequently.
ಕೋವಿಡ್ ಆದ್ಮೇಲೆ ಏನ್ ಮಾಡಿರಿ?
ಅದಾದ್ಮೇಲೆ BBMP ಅವರು they took some time to transfer the properties.
Acceptance of inventory by counsel for petitioner, accounts for CD. ಎಲ್ಲದಕ್ಕೂ CD ನಾ ತಗೊಳ್ಳಿ. Heard on IA 1 of 24 and there is a delay in filing the inventory and also IA number 2 of 24 for CD in filing accounts and also filed inventory as well as accounts and
Yes.
both the IAs are allowed on cost of rupees 1,000 each and delay is condoned and the inventory and accounts are accepted. Cost ಕಟ್ಟಿ 1,000 ಡೆಲೇಗೆ.
Right. Actually, it's not our fault, my lord. It was the BBMP's fault. We tried our best to get it transferred, but they would not, madam. They would not understand.
Provide 2018.
ಹೌದಲ್ಲ, 18 ಅಂದ್ರೆ ನಮ್ಗೆ ಕೊಟ್ಟಿದ್ 19 ಅಲ್ಲಿ. See, I got the order from November 19. 2 years went in COVID because the BBMP also didn't function.
ಆಯ್ತು,
Only in 22, my lord, I have started process in March 22 and then ultimately I managed to succeed now. So I should be the sufferer, my lord.
BBMP ಇದೇನು?
ಅದು ಖಾತೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಅವರು, ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ ಅವ್ರಿಗೆ. They would not understand.
ಹೋಗ್ಲಿ, ಯಾವಾಗ ಮಾಡಿದ್ ಖಾತಾ?
They just transferred. The moment they transferred the
ಯಾವಾಗ
ಖಾತೆ
ಹೇಳಿ?
file.
ಯಾವಾಗ ಹೇಳಿ?
Somewhere in 2023, my lord.
23.
20.
ಅದೇ ಯಾವಾಗ ಅಂದೆ?
Exact. Be November or October, my lord. I can't exactly.
Reduced to 500 each. Okay. Instead of 1000. Next.
Much obliged.
Junath G. Kandekar.
For appellant, my lord. The
Date of death are not mentioned.
it is only on 12/6/2024 after receipt of notice only. Jayakirti ಅಂತ ಹಾಕಿದ್ರೆ ಕಾಪಿನೂ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ.
ಹಾಕಿದ್ದಾರೆ.
ಜಯಕೀರ್ತಿ ಅಂತ.
Third on IA number 1 of 24 and 2 of 24 and 3 and of 24. And there was a delay in filing the LR application and all abatement is also prayed to set aside the abatement and also bringing LRs and for the reasons stated in the accompanying application and approve it and also represents the R2 LRs are represented through counsel and not filed any objection statement and hence IAs are allowed. Delay is condoned, abatement is set aside, permitted to bring the LRs on record. Appellant counsel is directed to amend the cast title within and file amended cast title within 2 weeks. Madi. Next 59. Recalling order dated 35/23. Syed Abdul Sabur ಹೇಳ್ರಿ ಏನು?
recalling of this IN.
ಏನದು ಆರ್ಡರ್ 35/23 ಅಲ್ಲಿ?
ಹೌದು.
2018 ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ?
ಹೌದು ಸರ್.
5 ವರ್ಷದ ಮೇಲೆ.
ಹೌದು. ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಏನು 5 ವರ್ಷದ ಮೇಲೆ?
ಅವಾಗ ಹಾಕಿದ್ದೆ ಸಮ್.
ಏನ್?
recalling ಅದು 20th.
ಅವಾಗ್ಲೇ ಹಾಕ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದ 5 ವರ್ಷದ ಮೇಲೆ ಹೌದಾ?
2020.
Why you have not complied for 5 years?
Why I have filed on 2020, my lord. Recalling application.
ಏನ್? ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದು ಯಾವಾಗ್ರಿ? ಒಂದೇ ಸರಿ ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಾಗ್ಲೇ ರಿಕಾಲ್ ಆಗಿದೆ ಮಣ್ಣು ಡಿಸ್ಮಿಸ್. ಅಪೀಲ್ shall be listed for dismissal. ಆಗಿಲ್ವಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದು ಯಾವ ವರ್ಷದಲ್ಲಿ?
2019.
19 ಅಲ್ಲ. ಮತ್ತೆ ಇಲ್ಲೇ 35/23 ಅಂತ ತೋರಿಸ್ತಾರೆ. ರಿಕಾಲಿಂಗ್ ಆರ್ಡರ್ ಡೇಟೆಡ್ 35/23.
ಹೌದು. Recall order.
ಮತ್ತೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಡಿಸ್ಮಿಸ್ ಆಗಿರ್ಬೇಕು ನೋಡ್ರಿ. ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಅಂತ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ, ರಿಕಾಲ್ ಮಾಡಿ ಅಂತ
ಮಾಡಿದ್ರು,
ಆದ್ರೂ ಮಾಡ್ಲಿಲ್ಲ. ಆಮೇಲೆ ಮತ್ತೆ ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಕೂಡ ಅಪೀಲ್ ಇಸ್ ಲಿಸ್ಟೆಡ್ ಟುಡೇ ಸೋ ಫಾರ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆರ್ ನಾಟ್ ಕಂಪ್ಲೈಡ್ ವಿತ್ ಇಟ್ ಅಪಿಯರ್ಸ್ ದ ಅಪಲೆಂಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಕೌನ್ಸಿಲ್ ಅಂಡ್ ರೆಕಾರ್ಡ್ ಕಂಪ್ಲೈ ವಿತ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್. ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ನೀವು ಡಿಸ್ಮಿಸಲ್ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಮತ್ತೆ ಡಿಸ್ಮಿಸ್ ಅಲ್ಲ, ರಿಕಾಲ್
ಆಗಿ
ನೋಡಿ. Heard the appellant counsel on IA 1 of 23 and the application is filed for recalling the order dated 35/23 and this court having perused the records taken note of that appeal was listed before the court on 27/11/2019 and court had dismissed the appeal for non-prosecution and application is also filed to condone the delay and for recalling the order. However, this court has granted time on 28/6/22 pending consideration of IA number 1 of 20 and 2 of 20. And in spite of time was given, not complied within 1 week. And also office objections are not complied. Even if opportunity is given to pending consideration also. And hence dismissed the application. And hence I do not find any ground to recall the order again. And appeal was dismissed in 2019 itself. And when sufficient opportunity is given, even prior to the pendency of the appeal, not complied. Even after the dismissal also, time was given to comply with office objections and the same also not complied. And hence no grounds are made out to recall the order dated 35/23. And hence IA is rejected. Rangaram.
Respondent.
CD of 370 days in filing the appeal.
We have taken possession of the suit federal property by filing execution petition. Suit for ejectment.
Already possession was taken.
Also,
Appellant counsel is absent and there was a delay of 317 days and counsel for the respondent submits that already possession was taken in the execution petition and appeal becomes infructuous.
Please.
And in view of the submission, one more opportunity is given to the appellant counsel to make submission regarding the submission of respondent. This matter on 19/7.
61.
Shankar S. Bhatt.
Recalling.
ಕೊಡಿ. Appellant counsel is absent, though IA filed for recalling the order dated 24/2/22, and also there was a delay of 355 days in filing the appeal.
19, sir.
And appeal
In fact,
in Rangaram, ಅವ್ರೇನ್ ಪೊಸಿಷನ್ ಎಲ್ಲ ತಗೊಂಡವ್ರಂತಲ್ರಿ?
Could not able to get the
ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ 19/7 ವೆರಿಫೈ ಮಾಡಿ ಹೇಳಿ. ಆಯ್ತು. And having perused the order sheet, appeal was listed on 4/10/2018 for compliance of office objections. And at the request of the council, 1 week time was granted to comply. And thereafter also not complied. And when the matter listed before the court on 25/10/2019, conditional order was passed granting 3 weeks time. And if not complied, list the matter for dismissal. And once again on 25/10/21, even up to 2 years also, the matter was listed, finally 2 weeks time granted, and the same was not complied. And again listed on 24/2/22. Made it clear that if the office objections are not complied with, appeal shall stand automatically dismissed for non-prosecution without reference to the bench. And having taken note of sufficient opportunities given, same has not been complied, and hence not made out any ground to condone the delay and recall the order, and hence IAs are rejected.
62.
I appear for the
Recalling application, ಹೇಳಿ ಏನು?
8/11/2019, my lord. And the conditional order was passed, my lord.
ಆಯ್ತು.
That day,
Comply ಮಾಡಿದ್ರಾ?
that day, my
ಮಾಡ್ಲಿಲ್ಲ.
lord, since the list was not marked, my lord,
ಹಾ?
no. ಬಂದಿರೋದು ನಮ್ಗೆ ಗೊತ್ತಿರ್ಲಿಲ್ಲ.
List ಬಂದಿರ್ಲಿಲ್ಲ.
Yes, my lord. Thereafter, my lord, on 15/11/21, the matter was
Pending
posted.
consideration on cost of rupees 1,000. 2 weeks time granted to comply with office objections. List this matter on other date ಕೊಡಿ madam. 29/7. Cost ಕಟ್ಟಿ comply ಮಾಡಿ.
63, my lord, I appear for appellant. For this matter was
Recalling the
dismissed
order dated
of the
16/21 ಕೊಡಿ. ಪ್ರಸನ್ನ ಶೆಟ್ಟಿ.
In the meanwhile, Lord, after filing recalling,
ಇದೇನಾ ಬಿಟ್ರೆ ಅಲ್ಲ?
ಇದರಲ್ಲಿ after filing recalling application, matter is settled between the parties, partition suit. Matter
ಏನ್ ವಿಡ್ರಾ
settled.
ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು.
ಆಯ್ತು ಕೊಡಿ. ಆಲ್ರೆಡಿ ಡಿಸ್ಮಿಸ್ಡ್. ಈಗ ಐಎ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಕೋಬೇಕು ಅಷ್ಟ ಅವ್ರಿಗೆ. ಐಎ ಡಿಸ್ಮಿಸ್.
Recall ಮಾಡಿ.
ರಿಕಾಲ್ ಮಾಡಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಕ್ ಬರಲ್ಲ.
Please.
ಈಗೇನು ಐಎನೇ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಲ್ವಾ?
Settle ಆಗಿದೆ, settle
ಮತ್ತೆ ಅದನ್ನ ರಿಕಾಲ್ ಮಾಡು ತಗೊಳ್ಳಿ.
Settle ಆಗಿ file ತಗೊಂಡು ಹೋಗಿ.
ಫೈಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್ ಮೆಮೋ.
ಹೇಳಿ, recall.
Recalling of, recalling.
ರಿಕಾಲ್ ಬರೀರಿ.
I filed application for recalling ಅಂತ ಹೇಳಿ.
Recalling dismissal ಈಗ ಹೌದಲ್ಲ?
ಹೌದು.
The council submits that matter has been settled and praise this court to dismiss the application in view of settlement, not surveys for consideration. Hence IA is rejected. That's all.
Please.
IA is dismissed as not pressed ಅಂತ.
Please, please.
ಅದ್ರಲ್ಲಿ ನಾಟ್ ಪ್ರೆಸ್ಟ್ ಅಂತ ಬರ್ಕೊಟ್ಬಿಡಿ ಮೆಮೋನ.
Please.
ಮೆಮೋನಲ್ಲಿ. ನೆಕ್ಸ್ಟ್
64.
ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್.
Appellants in this matter.
ಹೇಳ್ರಿ. 2,374 days in filing the appeal.
Sart accommodation may be granted, my lord.
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳಿದ್ರಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಹೌದಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್. ಇದ್ರಲ್ಲಿ ಏನಾಗಿ ಅವ್ರು ತಹಸೀಲ್ದಾರ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀವಿ. ತಹಸೀಲ್ದಾರ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀವಿ ಸ್ವಾಮಿ. ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ ಇನ್ಕನ್ವಿನಿಟಿ.
ಯಾರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇ.
ಮಂಡೇ
ಕೊಡಿ ಫೈಲ್ ಕೊಡಿ.
ಮಂಡೇ ಮೇಲೆ.
ಮಂಡೇ ಅಲ್ಲ ಲಾಸ್ಟ್ ವೀಕ್ ನೀವೇ ಕೇಳಿದ್ರಿ ನಾನು ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೆ ಹೌದಾ?
Yes, ma'am.
ಲರ್ನೆಡ್ AG 6 ಟೈಮ್ 4/7
As per my request only, this some court granted the time.
ಹೌದು ಈಗಲೂ ಮತ್ತೆ ಟೈಮ್ ಕೊಡ್ಬೇಕು.
ಮಂಡೇ.
ತಹಸೀಲ್ದಾರ್ಗೂ ಅದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ. ಏನ್ ರೀಸನ್ಸ್ ಕೊಟ್ಟಿದ್ರಿ ಹೇಳಿ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ.
ಇವ್ರು ಬರ್ತಾರೆ ಸರ್. ನಮ್ಮ ಅಡಿಷನಲ್ ಏಜ್ ಅವ್ರು ಬರ್ತಾರೆ.
2,374 days ಇದೆ. ರೀಸನ್ ಏನು?
ನಮ್ಮ ಅಡಿಷನಲ್ ಏಜ್ ಅವ್ರು ಬರ್ತಾರೆ.
ಸರ್ಕಾರ ಅಂದ ತಕ್ಷಣ ಏನ್ ಕಣ್ಮುಚ್ಕೊಂಡು ಕಂಡೌನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಹೇಳಿ
ನಾಟ್ ಸೀಕಿಂಗ್ ಸಚ್ ಬೆನಿಫಿಟ್ ಅಂತ
ಹೇಳಿ ರೀಸನ್ ಏನು? ವೇರ್ ಇಸ್ ಯುವರ್ CD ಅಪ್ಲಿಕೇಶನ್?
ದೇರ್ ಸಮ್ ಅಡಿಷನಲ್ ಏಜ್ ಅವ್ರು ಬರ್ತಾರೆ. ಅಡಿಷನಲ್ ಏಜ್ ಅವ್ರು ಬರ್ತಾರೆ.
ಯಾರು ಬಂದ್ರು ಅಷ್ಟೇ, AG ಬಂದ್ರು ಅಷ್ಟೇ. ರೀಸನ್ಸ್ ಏನ್ ಹೇಳಿ. ನೀವ್ ಹೇಳಿದ್ರು ಅಷ್ಟೇ, AG ಹೇಳಿದ್ರು ಅಷ್ಟೇ. ಕಾನೂನು ಏನ್ ಚೇಂಜ್ ಆಗುತ್ತಾ? ಇಲ್ಲ.
ಆಫ್ಟರ್
ನಿಮ್ಮ IA ಎಲ್ಲಿದೆ? ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇಗೆ
So delay, the reasons are assigned at page number 56, my lord.
CD,
Passing the
two
judgment.
thousand 374 days. ಏನಾಗಿದೆ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಸು?
ಏನಾಗಿದೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಶ್ಯೂಸ್ ನ ಸೊ ಇಂಪ್ರಾಪರ್ ಫ್ರೇಮ್ ಮಾಡಿದ್ದಾರೆ, ಆಮೇಲೆ ಅಡಿಷನಲ್ ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಮಾಡಿದ್ದಾರೆ. ಸೂಟ್ ಫಾರ್ ಡಿಕ್ಲರೇಷನ್ ಇನ್ ಫ್ಯಾಕ್ಟ್ my lord. So
Of the plaintiff is hereby decreed.
decreed. The permanent injunction.
Appellate court ಅಲ್ಲಿ ಏನಾಯ್ತು?
Well, permanent injunction has been granted and directed the state to deliver the
ಡಿಕ್ಲರೇಷನ್
possession.
ಏನ್ ಕೊಟ್ಟಿಲ್ಲಲ್ಲ?
ಕೊಟ್ಟಿದ್ದಾರೆ sir.
ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿದ್ದಾರೆ. The operative portion is
Absolute
made at,
owner, absolute title owner.
possession and suitable property. The dependents are hereby permanently restrained from interfering with the plaintiff's possession of the suit property. The dependents are directed.
Appeal ಅಲ್ಲಿ ಏನಾಯ್ತ್ರಿ?
ಅಪೀಲ್ ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಸ್ವಾಧೀನ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತೇಳಿ ವಿತೌಟ್ ದಿ ಕೈನು
Part by time may be dismissed as it has become infructuous. ಅಲ್ಲೂ ಕೂಡ ಡಿಲೇನಾ?
ಇಲ್ಲ ಡಿಲೇ ಏನಿಲ್ಲ, ಅದರಲ್ಲಿ ಓನ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಸ್ವಾಧೀನ ತಗೊಂಡಿದ್ದಾರೆ ಅನ್ನೋ ಕಾರಣಕ್ಕೇನೆ ವಿತೌಟ್ ಅಸೈನಿಂಗ್ ಎನಿ ರೀಸನ್ಸ್ ಅಂಡ್ ವಿತೌಟ್ ಗೋಯಿಂಗ್ ಟು ದಿ ಮೆರಿಟ್ಸ್ ಆಫ್ ದಿ ಕೇಸ್ ಸ್ಟ್ರೈಟ್ ಅವೇ ಡಿಸ್ಮಿಸ್ಡ್ ದಿ ಅಪೀಲ್. ಒಂದು 2 ಪೇಜ್ ಆರ್ಡರ್ ಇದೆ ಸ್ವಾಮಿ. ಪೇಜ್ ನಂಬರ್ 27, ಪೇಜ್ ನಂಬರ್ 27 my lord.
ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನಾಗಿತ್ತು? ಪೊಸೆಷನ್ ಕೊಡ್ಬೇಕು ಅಂತ ಆರ್ಡರ್ ಆಗಿತ್ತ?
ಹೌದು ಸ್ವಾಮಿ, ಸ್ವಾಧೀನ ಕೊಡ್ಬೇಕು ಅಂತ ಆಗಿದೆ.
Hereby permanently restrained from interfering with the plaintiff's possession of the suitable property.
ಪರ್ಮನೆಂಟ್ ಇಂಜೆಕ್ಷನ್ ಕೊಡ್ತಾರೆ ಒಂದ್ ಕಡೆ.
Dependents are directed to put the plaintiff in possession. ಅಲ್ಲ ರೀ, ಮತ್ತೆ ಪರ್ಮನೆಂಟ್ ಇಂಜೆಕ್ಷನ್ ಹೆಂಗ್ ಕೊಡ್ತಾರ?
ಅದು
ಪೊಸೆಷನ್ ಕೊಡ್ಬೇಕು ಅಂದ್ಮೇಲೆ?
Yes, this is the gross error committed by the trial court my lord. Without appreciating this aspect, the lower appellate court also confirmed the same.
ಆಯ್ತು, ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿದ್ದು ಯಾವಾಗ?
571 my lord. 71
2007
12 my lord.
12.
Yes my lord.
12
The RA number was also not assigned.
2007 ರೀ. ಸೂಟ್ 2007 ಈ ಆರ್ಡರ್ ಆಗಿದ್ದು. ನೀವು ಅಪೀಲ್ ಹಾಕಿರೋದು ಯಾವಾಗ?
RA filed
2009.
71 2009 my lord.
ಜೂನ್ 2007 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರೋದು. ಡಿಲೇ ಇದೆ, ಅವ್ರ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಂಡ್ರು, ಪೊಸಿಷನ್ ತಗೊಂಡ್ರು. ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಅಲ್ಲಿವರೆಗೂ? You have also assisted them to take the possession. ನೋಡಿ, ನಿಮ್ಮವರೆಲ್ಲ ಸೇರ್ಕೊಂಡಿರ್ಬೇಕು ಅವ್ರ ಜೊತೆಗೆ.
ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ಅಸರ್ಟೈನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದೀನಿ ಸ್ವಾಮಿ. ಅದಕ್ಕೂ ಅಸರ್ಟೈನ್ ತಹಸೀಲ್ದಾರ್ಗೆ ಅಸರ್ಟೈನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದೀನಿ. ಕೈಂಡ್ಲಿ ಯಾವ ದಿಸ್ ಮ್ಯಾಟರ್.
ಅಪೀಲ್ ಹಾಕುವಾಗ್ಲೂ ಡಿಲೇ ಇತ್ತು ಅನ್ಸುತ್ತೆ.
ಇಲ್ಲ, ಅಪೀಲ್ ಹಾಕೋಕೆ ಇನ್ ಟೈಮ್ ಆಗ್ತದೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಸ್ಟೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಮತ್ತೆ ವಿತೌಟ್ ಏನು RA ನಂಬರ್ ಕೂಡ ಕೊಟ್ಟಿಲ್ಲ ಇದಕ್ಕೆ. RA ನಂಬರ್ನು ಕೂಡ ಅಸೈನ್ ಮಾಡಿಲ್ಲ.
ಯಾಕೆ ಅನ್ನಂಬರ್ಡ್?
ಅನ್ನಂಬರ್ಡ್ ಅಂತಾನೆ ಇದೆ ಸ್ವಾಮಿ. ಸೊ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ನಡೆದಿದೆ. ಮತ್ತೆ ದಿ ಅಪಲೇಟ್ ದಿ ಟ್ರಯಲ್ ದಿ ಲೋಯರ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಇಸ್ ಆಲ್ಸೋ ನಾಟ್ ಅಸೈನ್ಡ್ ಎನಿ.
537 ಡೇಸ್ ಇದೆ ರೀ ನೋಡ್ರಿ ಅಪೀಲ್ ಅಲ್ಲಿ. ಓಡಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ನಾವೇ ನೋಡ್ಬೇಕೆಲ್ಲ. ಇದೆ ನೋಡಿ ಪೇಜ್ ನಂಬರ್ 16 and 17 ಅಲ್ಲಿ ಇಂಕ್ ಪೇಜ್. There was a delay of 537 days. That's why the stay was not given. ನಿಮ್ಮವರೇ ಸೇರ್ಕೊಂಡಿರ್ತಾರೆ ನೋಡಿ ಅಲ್ಲಿ ಪೊಸಿಷನ್ ಕೊಡ್ಸಕ್ಕೆ. ಏನ್ ಮಾಡ್ಬೇಕು?
ಸರ್ಟೈನ್ ಮಾಡ್ತೀವಿ.
ಏನ್ ಟೈಟ್ಲ್ ಏನು?
ಸೊ ಇವರು ಏನ್ ಮಾಡಿದಾರೆ, ಇವರು ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ನೇ ಕ್ರಿಯೇಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ, ಫೋರ್ಜರಿ ಮಾಡ್ಕೊಂಡು. ಇದರ ಕನೆಕ್ಟಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಒಂದು 6-7 ಮ್ಯಾಟರ್ ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಸ್ವಾಮಿ. ಅದೆಲ್ಲ ಟ್ರೇಸ್ ಔಟ್ ಮಾಡ್ತೇನೆ ಪೋಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ತಮ್ಮ ಮುಂದೆ. ಇವರು ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ನೇ ಫೋರ್ಜರಿ ಮಾಡ್ಕೊಂಡು ದೇ ಆರ್ ಟ್ರೈಂಗ್.
Dated 21/11/1982 issued by the second defendant under the reference number so and so.
At the first instance my lord, the trial court has framed the issue number 1. Subsequently recast. ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ, ಸ್ವಾಧೀನ ಕೊಡಕ್ಕೆ
proves the truth, genuineness and validity of certificate of grant dated ಮಾಡಿದಾರಲ್ಲ ಮತ್ತೆ.
ಅಡಿಷನಲ್ ಇಶ್ಯೂಸ್ ರೀಕಾಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ.
ಆಯ್ತು.
So it is itself goes to show that my lord, as on the date of the suit they are not at possession of the property. But in spite of that, the trial court has granted the relief of possession without seeking the relief of possession.
Suit for ಏನು? ಬರೀ only declaration and possession.
ಡಿಕ್ಲರೇಷನ್ ಕೇಳ್ತಾರೆ, ಪೊಸಿಷನ್ ಕೇಳಿಲ್ಲ ಸ್ವಾಮಿ ಅವರು.
Declaration and possession ಇದೆಯಲ್ಲ, ಅದೇನೋ ಕರೆಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. And injunction.
ಇಂಜಂಕ್ಷನ್ ಗೆ ಟೈಟಲ್ ಕೇಳಿದ್ದಾರೆ, ಪೊಸಿಷನ್ ಕೇಳಿಲ್ಲ ಸ್ವಾಮಿ. ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ ದಟ್, ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ has granted the relief of possession.
ನೋಡಿ ಅದು actually ascertain ಮಾಡಿ.
Please ma'am.
Why people have cooperated with the plaintiff. ಗ್ರಾಂಟ್ ಆದ್ಮೇಲೆ ಗ್ರಾಂಟ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಪ್ರಾಪರ್ಟಿ ಪೊಸಿಷನ್ ಕೊಟ್ಟಿರ್ತಾರಲ್ವಾ. Then how a court can pass an order of the trial court both permanently restraining in possession and ordering for possession, trial court. Some mischief ಏನೋ ಇದ್ದಂಗಿದೆ, ಅದಕ್ಕೆ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಅಸರ್ಟೈನ್ ಮಾಡಿ ನೋಡೋಣ. ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಯಾವಾಗ?
2 weeks ಬಿಟ್ಟು.
2 ಅಂದ್ರೆ 29/7. This matter on 29/7.
65.
29/7 ಬರಲ್ಲ ಮೇಡಮ್, ಬೇರೆ ದಿವಸ ಬರುತ್ತೆ. ಇವತ್ತಿಗೆ 15 ದಿವಸ ಅಂದ್ರೆ
ಇದರಲ್ಲಿ ರಜಾ ಕೊಟ್ಟಿರೋದ್ರಿಂದ ಒಂದು ದಿನ ಕುತ್ಕೊಂಡು ಹೋಗ್ತೀವಿ.
ಟೆಸ್ಟ್ ಡೇಟ್ 11ರಿಂದ 26 ಆಯ್ತು. 29/7.
For the appellant.
RSA.
My lord, for respondent number 11 to 15, we have not been served the copies of the IAs, my lord.
You are appearing for whom?
Respondent number 11 to 15. my lord.
11 to 15.
Yes.
Copies ಕೊಡಿ ಮೇಡಮ್.
Today.
16 to 18.
Huh?
I appear for the R9 16.
I think bringing LRs ಯಾರು?
Bringing LRs of respondent
Appellant,
number 10, 24 and 25, my lords.
R25 ಸತ್ತೋಗಿದ್ದಾರೆ. ಹಾ, ಇದು R25 ಗಾ? R25. ಹಾ. ಹ್ಮ್. 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 ಅದಕ್ಕೇನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಮಾಡವ್ರ? ಮಾಡಿದಾರ? ಮೇಡಮ್, ಈಗ ಬ್ರಿಂಗಿಂಗ್ LRs ಅಂತಂದ್ರೆ R1, R10, 24, 25 ಸಪರೇಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಲ್ಲ ನೀವು?
That's why I filed my lords IA number 2, 3 and 4 of 24, my lords.
IA 2, 3 and 4 is to in respect of 25.
Separate application.
ಅದು only for 25 ಆಯ್ತು.
ಇಲ್ಲ my lords, R10 ಗೆ separate ಹಾಕಿದ್ದೀನಿ. IA number 2 of 24 ಹಾಕಿದ್ದೀನಿ.
A ನಂಬರ್ ಅದು R10
R10 ಗೆ ಸ್ವಾಮಿ.
ಆಯ್ತು.
IA number 3 ಬಂದ್ಬಿಟ್ಟು 24 ಗೆ respondent
ಆಯ್ತು.
number 24 ಗೆ ಹಾಕಿದ್ದೀನಿ.
ಹಾ.
IA number
10, 24, 25 ಆಯ್ತು.
One already.
24, 20 R1 ಗೆ?
R1 ಗೆ our LRs are already on record. ಅದಕ್ಕೆ amended appeal ತಾವೇ ಲಾಸ್ಟ್ ಡೇಟ್ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ.
ಮೆಮೊ ಹಾಕಿದಿರದಕ್ಕೆ ಮೆಮೊ ಡೇಟೆಡ್ 8/7/24 ಅಂತೇನೋ ಇದೆ.
That has been allowed by this honorable court, my lords, and amended appeal.
ಒಂದ್ ಇನ್ನೊಂದ್ ಹಾಕಿದಿರ್ರಿ R17.
R17, my lords, is dead and his sister is already on record and.
R1 ಈಗ ಆಲ್ರೆಡಿ ಪರ್ಮಿಷನ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ ಸ್ವಾಮಿ.
ಆದ್ರೆ ಮತ್ತೆ ಬರಲ್ಲ ಅಲ್ಲ. ಈಗ ಇದಕ್ಕೆ issue notice against the LRs of R10 as per IA number 2 of 24. Issue notice against LRs of R24 as per IA number 3 of 24. Issue notice against LRs of R25 as per IA number 4 of 24. ಆಯ್ತಾ? ಈ ಮೆಮೊ ಏನ್ ಕೊಡ್ರಿ ಮೇಡಮ್? ಅದು 8/7/24.
ಅದು R17 is also dead, your honors, and
LRs ಇದಾರ ಅವ್ರಿಗೆ?
only his sister is already on record as R16 and is not married and no children, your honors. R16.
ಈಗ R17 ಯಾರು LR ಮೇಡಮ್?
R16 his sister is on record.
ಹಾಕಿದಿರಿ ಈಗ ಮೆಮೊನಲ್ಲಿ?
ಮೆಮೊನ ಹಾಕಿದ್ದೀನಿ.
ನೋಡಿ, the council submits that R16. ಅದನ್ನ ನೀವೇನ್ ನೋಡಿದ್ರೇನ್ರಿ? ಮೆಮೊ ಕಾಪೀಸ್ ಕೊಟ್ಟಾರ ನಿಮ್ಗೆ?
ಏನು ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಅದರ್ ಸೈಡ್ ಕಾಪಿ ಕೊಡ್ರಿ ಮೇಡಮ್, ಏನೇನ್ ಹಾಕಿದಿರ ಅದನ್ನ? ಈಗ IA ಕಾಪೀಸ್ ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ.
ಈ IA ಕಾಪೀಸ್
ಅಲ್ಲ, I'll serve the copies. On the last 2 dates, no one, none appeared, my
notice
lords.
and appellant counsel is ಕೊಡ್ರಿ ಅದೇನ್ ಮೆಮೊ? The counsel for the appellant is directed to serve the copy of IA 2 of 24, 3 of 24, 4 of 24 and also the memo dated 8/7/24 on the other side. On the other side and forthwith, and counsel for the respondents who are already record also submit with regarding these IAs also and also the memo in the next date of hearing. List this matter on 30th of July. ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದ್ನಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್ LRsಗೆ. LRsಗೂ ಹೋಗುತ್ತೆ, ಅವ್ರ ಕಾಪೀಸ್ ಕೊಡಿ ಅವ್ರಿಗೆ ಇಬ್ರಿಗೂ. ಯಾರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅವ್ರಿಗೆ?
Grateful.
IA 1 of 24 ಬರೋದಿಲ್ಲ. IA 1 of 24 does not survey for consideration in view of separate applications are filed. Sampath.
Madam, there's one problem has happened. I just kept the file here, but someone is by mistake took the file ittid there. Someone by mistake ನನ್ನ ಫೈಲ್ ತಗೊಂಡ್ ಹೋಗಿದ್ದಾರೆ and I'm not having the file. ಇವಾಗ
recalling ಅಲ್ವೇ?
recalling ಇದೆ ಸ್ವಾಮಿ. ಸೊ ಅದರಲ್ಲಿ recalling is only one objection ಮಾಡೋದು, additional court fees ಕೊಡ್ಬೇಕು ಅಂತ because of some.
ಮೇಲೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಲ್ಲ. ಈಗ ಹೇಳಿ ಯಾವಾಗಿಂದ ನೀವು ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಯ್ತು? 19.
ಇಲ್ಲ ಅಂದ್ರೆ 24/2/2020 ಅಷ್ಟ್ರೊಳಗೆ ಕಂಪ್ಲೀಟ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ.
22nd November 2019. Appeals will be listed for dismissal.
ಅದಾದ್ಮೇಲೆ ಅದೆಲ್ಲ ಕ್ಯೂರ್ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ. ಒಂದೇ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನ
ಮತ್ತೆ 17/22.
ಕ್ಯೂರ್ ಮಾಡಿ ಒಂದೇ ಅಬ್ಜೆಕ್ಷನ್ ಉಳಿದಿತ್ತು ಸ್ವಾಮಿ. ಅದೇನಂದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಡಿಷನಲ್ ಶೆಡ್ಯೂಲ್ ಹಾಕಿದಕ್ಕೆ ಅಡಿಷನಲ್ ಕೋರ್ಟ್ ಫೀಸ್ ಕೊಡ್ಬೇಕು ಅಂತ ಆಫೀಸರ್.
It may be counsel matter was listed for dismissal twice.
ಇಲ್ಲ ಅದೆಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡಿದೀವಿ
ಏನ್ ಕಂಪ್ಲೇಂಟ್
ಇದು
ಮಾಡಿದ್ರೆ?
ಅದೆಲ್ಲ ಕ್ಯೂರ್ ಮಾಡ್ತಾ ಬಂದು ಒಂದೇ ಅಬ್ಜೆಕ್ಷನ್ ಉಳ್ಕೊಂಡಿದೆ ಸ್ವಾಮಿ.
ಯಾವ್ದು ಅದು ಒಂದು ಉಳಿದಿರೋ?
ಅಡಿಷನಲ್ ಕೋರ್ಟ್ ಫೀಸ್ ಕೊಡ್ಬೇಕು ಅಂತ.
ಅದು ಯಾವಾಗ ಉಳಿದಿದ್ದು?
ದಟ್ಸ್ ಓನ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್.
Last time dismissal also 24/2 ನಲ್ಲಿ as a last chance 2 weeks time is finally granted to comply with office objections.
ಸೊ ಅದೇ ಕೋರ್ಟ್ ಫೀಸ್
Clear that
ಕೊಡ್ಬೇಕು.
if the office objections are not complied with, this appeal shall stand dismissed automatically for non-prosecution. ಎಷ್ಟಿದೆ ನೋಡಿ ಮೇಡಮ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಕ್ಯೂರ್ ಮಾಡಿ ಓನ್ಲಿ ಕೋರ್ಟ್ ಫೀನಾ?
ಕೋರ್ಟ್ ಫೀಸ್ ಅದ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ ಕೋರ್ಟ್ ಫೀಸ್ ಕೊಡ್ಬೇಕದು 1 ಲಕ್ಷ ಮೇಲಾಗುತ್ತೆ. ದಿ ಪಾಪುಲೆಂಟ್ ಈಸ್ ಸಫರ್ಡ್ ಫ್ರಮ್ ಎ ಕ್ಯಾನ್ಸರ್ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ.
ಅಪೀಲ್ ಹಾಕಿದ್ರಿ?
ಇಲ್ಲ ಅಂದ್ರೆ ಅದಾದ್ಮೇಲೆ
18 ಇಂದ ಯಾಕೆ ಇಟ್ಕೊಂಡಿದ್ರಿ?
ಇಲ್ಲ ಅದಾದ್ಮೇಲೆ ಕ್ಯೂರ್ ಮಾಡ್ತಾ ಬಂದ್ವಿ ಸ್ವಾಮಿ. ಅದಕ್ಕೆ ಸ್ವಲ್ಪ
ಕೋರ್ಟ್ ಫೀಸ್ ಸಂಬಂಧಪಟ್ಟಂತೆ
ಆ ಕೋರ್ಟ್ ಫೀಸ್ ಕೊಡಕ್ಕೆ ಸ್ವಲ್ಪ ಕಷ್ಟ ಆಗಿದೆ. ಈಸ್ ಅಂಡರ್ಗೋನ್ ಕ್ಯಾನ್ಸರ್.
ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು? ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಕೊಡ್ಲಾ ಅಥವಾ ಏನ್ ಮಾಡ್ಬೇಕು?
ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಅವ್ರದ್ದು ಕೋರ್ಟ್ ಫೀಸ್ ಕಟ್ಬಿಟ್ಟು ಅದೊಂದೇ ಅಬ್ಜೆಕ್ಷನ್.
Sorry, on cost of rupees 1,000, pending consideration of the IA, 2 weeks time granted to comply with office objection.
Please oblige.
If list this matter on 26/7.
Please oblige.
67.
Hearing for appellant, Chief may kindly grant 2 weeks time to comply office objections pending consideration. Recalling.
Recall ಗುನ್ನು office objections ಅದನ್ನು ಮಾಡಲ್ವಾ ಕಂಪ್ಲೈ?
Recall clear is. Comply and main
ಎಷ್ಟು ಸರಿ ಬಂದಿದೆ ನೋಡಿ ಮೇಡಮ್?
3 times. 3 times.
ಯಾವಾಗ? ಮೊದ್ಲಲ್ಲ ಈಗ ಈ ಐ ಹಾಕಿದ್ಮೇಲೆ.
ಹಾಕಿದ್ಮೇಲೆ ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಲಾರ್ಡ್ಶಿಪ್ ಗ್ರಾಂಟೆಡ್ ವೀಕ್ಸ್ ಟೈಮ್ ಟು ಕಂಪ್ಲೈ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್.
ನಾನೇ ಕೊಟ್ಟಿದ್ದೀನಿ. ಹಾ ಕೊಡಿ ಕೊಡಿ. ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟ್ ಗ್ರಾಂಟೆಡ್ ಟೈಮ್.
ಅಲ್ಲ ಟೈಮ್ ಗ್ರಾಂಟ್ ಆಗಿರೋದು ಐಎ ಮೇಲೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇತ್ತು.
Comply the office objections not complied.
ಐಎ ನಲ್ಲಿ ಡಿಲೇ ಡೇಸ್ ನಾಟ್
4/7/24 and once again 6 time and on cost of rupees 1,000 another 2 weeks time granted to comply with office objections on IA. List this matter. ಈಗ ಇರೋದು ಮೇನ್ ಅದು ಐಎಂ ಮೇನ್ ಮೇಲೆ ಕೊಟ್ಟಿದ್ದೀನ. ಹೌದು ಅದ್ ಮಾಡಿಲ್ಲ ಅಲ್ಲ ಅದನ್ನ
ಮಾಡಿದೀನಿ.
IML ಮಾಡಿದಾರ ಮೇಡಮ್?
IML ಮಾಡಿದೀನಿ ಸರ್.
ಯಾವಾಗ?
ಡೇ ಬಿಫೋರ್ ಎಸ್ಟರ್ಡೇ ಐ ಕಂಪ್ಲೈಡ್. ಅಲ್ಲಿ ಡಿಲೇ ಡೇಸ್ ಬರ್ದಿರ್ಲಿಲ್ಲ. ಐ ಕಂಪ್ಲೈಡ್ ದಟ್.
ಈಗ ಹಾಗಾದ್ರೆ ಮೇನ್ ಮೇಲೆ ಆಯ್ತು. ಮೇನ್ ಮೇಲೆ 2 weeks time grant pending consideration of IA.
Please.
1/22. 2 weeks time granted on cost of rupees 1,000 payable at registry. List this matter on 25/7. ಇವತ್ತಿಗೆ 2 ವಾರ ಅಲ್ಲ?
68. K. Krishnamurthy.
Appellant, my lords. I filed an application, my lord,
Give to
seeking
appeal
brief.
as appellant number 2 to 6 in the above appeal. ಹೇಳಿ ಏನು?
Please, my lords, 8 to 6 are the legal heirs of respondent number 4 in the first appeal, my lords. He died during the pendency of the first appeal. Hence, I have filed an application seeking leave to contest the matter, my lords.
Now appeal is by the appellant number 1 ಯಾರು?
She is the respondent, my lords. She is the respondent number 3. It's a defendant's appeal, my lords. Defendant number 4 died. Respondent number 4 died.
ಈಗ they are the LRs of defendant.
Please, my lords. Respondent number 4 in the RA.
4 in the RA.
Please, my lords.
ಈಗ ಅಪೀಲ್ ಹಾಕಿರೋದು ಅವರ LRs ಏನೆ?
Please, my lords. Appellant number 2 to 6.
Heard on IA number 1/21 and leave is sought on the ground that respondent number 4 passed away after the judgment.
ಇಲ್ಲ, prior to judgment, my lords.
ಮತ್ತೆ ಅವಾಗ ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ ಅಲ್ಲಿ?
ಇಲ್ಲ, he was the respondent, my lords. He was not, LRs were not brought on record. He died on 11/12/2017. And the judgment was passed on 14/9/2018. That's.
And they were not brought on record as LRs before the first appellate court and being agreed by the judgment of the first appellate court, the present appeal is filed and hence the appellant number 2 to 6 are necessary parties and hence pray the court to grant leave. And in view of submission that they have not been arraigned as LRs of respondent number 4 before the appellate court, right to sue survives and hence leave is granted to pursue this appeal. Next,
Admission post.
post the matter for admission.
A request for a date, my lord.
In the month of fourth, fourth week of July.
Please,
The matter,
oblige.
fourth week of July. RSA 446.
Nagraj RC.
ಏನು ಪೋಸ್ಟ್ ಆಗಿದೆ ಮೇಡಮ್ ಅದು IA ಲಿಸ್ಟ್ ಒಳಗೆ
ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು.
ಹಾ?
ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು, ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ.
ಏನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ?
Recall the order.
ಈಗ IAS ಇದೆಯಾ? ಮತ್ತೆ IAS ತೋರ್ಸೇ ಇಲ್ಲ.
The first time ಬಂದಿತ್ತು. First time it was listed for
ಏನ್ ಫಸ್ಟ್
non-compliance.
ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಾಗ್ಲೇ ಡಿಸ್ಮಿಸ್ ಆಯ್ತಾ?
ಹೌದು. During corona time ಅಲ್ಲಿ 21/9.
ಸುಮ್ನೆ ಏನೇನೋ ಮಾತಾಡ್ಬೇಡಿ ನೀವು. ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ. First time matter was listed before the 5/2/2020 before the registrar. You are absent. And then matter listed before the court 21/9/21.
ಅವಾಗ
ಅವತ್ತೇ ಮಾಡ್ಬಿಟ್ರ?
ಅವತ್ತೇ ಮಾಡಿ.
ಅದೇ ಆರ್ಡರ್ ಇಲ್ಲಿ ಟೈಪ್ ಆಗಿದೆ ಅಷ್ಟೇ. ತಗೊಳ್ಳಿ, heard the appellant counsel and for the reasons stated in the accompanying application and affidavit. Same other order, madam, 21st of September. ಆಯ್ತು. Allowed, restored. Compliance ಇದೆಯಾ? Compliance ಇದೆಯಾ? ಕಂಪ್ಲೈ ಮಾಡಿ.
ಮಾಡ್ತೀವಿ.
And directed to comply within 2 weeks.
ಮಾಡ್ತೀವಿ.
And thereafter list the matter for admission. Next.
70.
I appear for appellant.
Ma'am, it's ಹೇಳ್ರಿ ಏನ್?
Preemptory order was came to be passed to lordship for non-payment of full court fee, my lord. So for the purpose of
Only
avoiding delay, my lord, we have paid the
Only on payment of.
only a payment of court fee, that we have paid it subsequently. By that time, the preemptory order came into operation, your lord.
ಕೊಡಿ. ಆರ್ಡರ್ ಶೀಟ್ ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್ ನನ್ನ ಕಡೆ.
I have explained in my para 4 of my affidavit.
ಈಗಲೇ ಏನ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಾ?
We have paid the 35,780 court fee.
No representation for the appellant. 4 weeks time granted to
Yes.
comply with office objections on
Yes.
4/4/2019.
I was not noticed the listing of the case on that day, your lordship. Though I attended the case.
Time ಏನಾಯ್ತು?
Yeah.
ಅವತ್ತೇ ಸ್ಟ್ಯಾಂಡ್ ಡಿಸ್ಮಿಸ್
ಅವತ್ತೇ.
without reference to the
ಹೌದು.
bench.
ಹೌದು.
Third, heard the appellant counsel and also on perusal of records. When the matter listed for second time before the court on that day itself, order has been passed granting 3 weeks time. If not complied, shall stand dismissed. And for the reasons stated in the accompanying application and affidavit. And office objection is also with regard to the non-payment of court fee na.
Full
ನೋಡಿ
court.
ನೋಡಿ.
200
Again.
rupees ಕೊಟ್ಟು ಹಾಕಿದ್ವಿ ನಾವು. Because
Part by time ಅಂದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ ನೀವು. ಹಾ.
Delay days to be paid.
ಅಂದ್ರೆ ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಏನು? ಹಾ. Not court fee.
court fee and delay application. Court fee also.
ಇಲ್ವಲ್ರಿ, court fee then office objections ಇಲ್ಲ.
Court fee no 8
Appeal
tenal.
barred by time, delay IA to be filed with full cost title. Actual number of delay days to be filed in ಅಂತ ಇದೆ. ನೀವು ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ.
Delay.
ಕೋರ್ಟ್ ಫೀ ಬಗ್ಗೆ ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಲ್ವಲ್ಲ? ತಗೊಳ್ಳಿ ಮೇಡಮ್, ಅಲ್ಲಿ ಬೇಡ. ಹಾ?
I will do it.
ಹೇಳಿದ್ನಲ್ಲ ಕೋರ್ಟ್ ಫೀ ಅಂತ. And the office objection, only one office objection is that the appeal is barred by time, delay application has to be filed. And hence the dismissal order is recalled.
Like, I will file my lord.
Within 2 weeks, comply with office objection.
Yes, sir.
And thereafter only list the matter for
Please, sir.
admission.
Please.
71.
Or otherwise the Indian case ಹಾಕಿ, or otherwise appellant will not endure the benefit of this order ಅಂತ ಎರಡರಲ್ಲೂ ಹಾಕಿ.
Only
71.
6 days
71.
for delay, my lord.
ಶಂಕರೇಗೌಡ MB.
6 days for delay for
Other
filing.
side ಇದಾರ? ಇಲ್ಲ, heard on IA number 1 of 2019 and there is a delay of only 6 days. And respondent also represented through counsel. ಇದ್ರಲ್ಲಿ ಬೇರೆ respondents ಇಲ್ವಾ?
ಇದಾರೆ sir.
R4 ಮಾತ್ರ ಕಿವೇಟಾರು.
ಹೌದು sir.
ಮತ್ತೆ ಅವ್ರ ಮೇಲೆ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ?
Notice ಹೋಗ್ಬೇಕು.
Issue ಇಲ್ಲ,
notice.
ಏನು ಆರ್ಡರ್ ಇಲ್ಲ ಮೇಡಮ್. Issue notice on IA 1 of 19 against other LRs. Sorry, other respondents on main also.
72.
Setting aside the appointment against R7 and treat R9, R11, 13 as LRs of already on record. ಈಗ ಅಬೇಟ್ ಆಗಿತ್ತಾ?
ಹಾ ಸ್ವಾಮಿ, ಆಲ್ರೆಡಿ ಆನ್ ರೆಕಾರ್ಡ್ ಆಗಿದೆ.
Appellant counsel has filed an application to set aside the abatement against R7. And also in the IA it is stated that R9, R11 and R11 to 13 are the LRs of R7. Who are already on record and involve the reasons mentioned in the application of it. IA is allowed and abatement is set aside.
I'm not pressing the delay, man. I'm not pressing the delay, my lord.
ಇಲ್ಲಿ ಡಿಲೇ ಏನಿದೆ
ಇಲ್ಲ.
ಡಿಲೇ ಏನಿಲ್ವಲ್ಲ
Okay, 1 of 20.
ಕಾಸ್ಟ್ ಏನೋ ಒಂದು ಇದೆ ಹಾಕಿದ್ರೆ
ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ.
ಆಮೇಲೆ ಮತ್ತಿನ
I have
ನಾಟ್
paid.
ಪ್ರೆಸ್ಸಿಂಗ್ ದ ಐಎನಾ
One time ಆಗಿರೋದು.
ಆಯ್ತು A 1 of 24 is not pressed and the same is dismissed as not pressed.
I'm permitted to amend the cost title now itself.
ಏನ್ ಅಮೆಂಡ್ ಆಗ್ಬೇಕಿನ್ನ
ಅದು ರೌಂಡ್ ಆಫ್ ಮಾಡ್ತೇವೆ ಸರ್.
ಆಯ್ತಾ ನೋಡಿ permitted to amend the cost title in view of allowing of A number 1 of 23.
73.
Harish Bandari bringing LRs of deceased appellant Mailappa Gowda. Heard on A number 3 of 22 and for the reason stated in the accompanying application and affidavit, IA is allowed. Permitted to amend the cost title and file cost title, amended cost title within 2 weeks.
Notice.
Huh?
Delay then.
ಯಾವ್ದು?
Delay.
First you have to convince regarding delay of 682 days, then only notice. 682 ದಿವಸ delay ಇದೆ. Post the matter for admission along with IA 1 of 24.
74. Therefore, opponent. Partitions.
Filing the above appeal, delay. ಬಾಕಿದೆಲ್ಲ AS ಏನೋ ಇದೆಯಲ್ಲ ಮೇಡಮ್?
Appellant number 1 ಸತ್ತೋಗಿದೆ. Appellant number 8.
ಅಪಲೆಂಟ್ ನಂಬರ್ 1 ಸತ್ತೋಗಿದ್ದಾರೆ.
Appellant number 1 and appellant number 8.
ಎಲ್ಲ ಅಪಲೆಂಟ್ಸ್ ಏನಾ?
ಇಲ್ಲ ಸರ್.
Third one?
Respondent number 5 ಅವರು.
First
ಇನ್ನು
heard.
ಆರ್ಗೆ.
Heard on IA number 1 of 21 and there is a delay of 1 of 24 madam, 24 and there is a delay of 1381 days in filing the application and also sought for setting aside the abatement and bringing the LRs of appellant number 1 on record and for the reasons stated in the accompanying application and affidavit. IA is allowed and abatement is set aside and delay is condoned and permitted to bring the LRs on record. Next.
So respondent number
ಅದಿರ್ಲಿ
5
ಇರ್ಲಿ ಮೇಡಮ್ ಸ್ವಲ್ಪ heard on IA number 2/24 and there is a delay of 193 days in filing the application and also prayer is sought for setting aside the abatement and also seeking permission to bring the LRs of appellant number 8 on record and for the reasons stated in the accompanying application and affidavit, delay is condoned, abatement is set aside and allowed to bring the LRs on record of appellant number 8. And hence appellant counsel is directed to amend the cost title in terms of A number 1 of 24 and 2 of 24 within 2 weeks and file amended cost title. ಇದಕ್ಕೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ? ಮೂರನೇದಕ್ಕೆ A number 3 of 24 ಗೆ.
ಅವ್ರ ಆರ್ಯಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 5 ಆಗಿರೋದು ಸರ್ ಅದು. ಇಲ್ಲಿ ಅವ್ರನ್ನ ತಗೊಂಡ್ಬಂದಿಲ್ಲ.
ಅವ್ರು ನೀನ್ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಾ?
ಆರ್ಯನಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಡೆತ್ ಆಗಿದ್ರು ಮೇಲೆ 3 ಜನ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅವ್ರನ್ನ ಇಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿ ಎಲ್ಲಾರ್ಸ್ನ ರೆಕಾರ್ಡ್ ತರ್ತಾ ಇದ್ರು.
ಸತ್ತೋಗಿದೆ ಯಾವಾಗ ಮೇಡಮ್?
ಆರ್ಯನಲ್ಲಿ ಅದು
ಆರ್ಯನಲ್ಲಿ ಗೊತ್ತಾಯ್ತು ಯಾವಾಗ? ಆಫ್ಟರ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ ಬಿಫೋರ್ ಜಡ್ಜ್ಮೆಂಟ್? ಬಿಫೋರ್ ಜಡ್ಜ್ಮೆಂಟ್. ಮತ್ತೆ ಅವ್ರನ್ನ ಈಗ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾದ್ರೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ? ಮಾಡಿದ್ದಾರೆ ಬಟ್ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ? ಅವ್ರನ್ನ ಕೇಳ್ಬೇಕಲ್ಲ? ಪರ್ಮಿಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ ನೀವು. ಪರ್ಮಿಷನ್ ಬದಲು ಬ್ರಿಂಗ್ ಅಂತ ಮಾಡಿ ಪರ್ಮಿಷನ್ ಏನಲ್ಲಿ ಪ್ರೇಯರ್ ಏನ್ ಮೇಡಮ್ ಬ್ರಾಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ಬಟ್ ಅಲೋ ಆಗಿಲ್ವಲ್ಲ? ಪ್ರೇಯರ್ ಏನ್ ಕೇಳ್ತಾರೆ? ಬ್ರಿಂಗ್ ದಿ LRs ಅಥವಾ ಏನು? ಕೊಡಿ ಅಯ್ಯ ಕೊಡಿ. ನೈನ್ಟೀನಲ್ಲೇ ಸತ್ತೋಗಿದ್ದಾನಲ್ರಿ ಅವನು? In filing the application may be condoned the abatement of set aside permitted to bring the legal representatives of respondent number 5. Notice ಹೋಗ್ಬೇಕು ಇದ್ರ ಮೇಲೆ. Issue notice on A number 3 of 24 against the LRs of R5 who have been arraigned in this appeal as ಏನಂತ ಮಾಡವ್ರೆ? ಎಷ್ಟನೇವ್ರು ಅಂತ ಮಾಡವ್ರೆ?
4 and 5 ಅಂತ.
4 and 5
4 and 5.
4 and 5 and also issue notice on A number 1 of 21 against the respondents and also on main. Kodi ella PF kodi. Next,
75, Jaikar Shetty.
47 days delay.
Okay, sir.
Notice on IA, 1 of 23 and also on main.
76.
Last time.
Call the order dated 10/6/24. ಏನಾಯ್ತು madam dismissal ಯಾಕೆ?
ಲಾಸ್ಟ್ ಟೈಮ್ ಅದು ರಿಜಿಸ್ಟರ್ ಜನರಲ್ ಇಲ್ಲಿ ಕಟ್ಟಿದ್ರು ಸರ್, ಅದು ಆಕ್ಚುಲಿ ಆರ್ಡರ್ ಬಂದು ಕರ್ನಾಟಕ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟೀಸ್ ಅಲ್ಲಿ ಕಟ್ಟಬೇಕಾಯ್ತು. ಸೊ ಅದನ್ನ ಇಲ್ಲಿ ಕಟ್ಟಿದ್ರು. ಇವಾಗ ಲಾಸ್ಟ್ ವೀಕ್ ಇಟ್ ಹಸ್ ಬಿನ್ ಪೇಡ್ ಅಂಡ್ ಇಟ್ ಹಸ್ ಬಿನ್ ಸಬ್ಮಿಟೆಡ್ ಮೇಲೆ.
ಡಿಸ್ಮಿಸ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ಎಷ್ಟು ಸರಿ ಲಿಸ್ಟ್ ಆಗಿತ್ತು ಮೇಡಮ್?
That it has been paid in the register general in the high court ಇದರಲ್ಲಿ ಪೇ ಮಾಡಿದ್ರು.
You are not answering to my question. How many time matter was listed before the court? Registrar ಮುಂದೆ ಒಂದ್ ಸಲ, ಎರಡ್ ಸಲ, ಮೂರ್ ಸಲ, ಕೋರ್ಟ್ ಮುಂದೆ 5/1/24 ಲಿ ಅವತ್ತೆ ಕಾಸ್ಟ್ ಹಾಕಿ despite the matter has been moved urgent at the cost of ₹500. ನೀವೇ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದಿರಿ, ಬಂದಿಲ್ಲ ಕೋರ್ಟ್ಗೆ. ನನ್ನ ಅಪಿಯರ್ಸ್
ಅಡ್ವೊಕೇಟ್ ನೇಮ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಅದು
ಆಯ್ತು. ಮತ್ತೊಂದ್ಸರಿ ಬಂತು ಮತ್ತೆ ಕೋರ್ಟ್ ಮುಂದೆ 22 ಒಂದ್ರಲ್ಲಿ ಅವತ್ತು ಕೂಡ ಲಿಸ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ 2 weeks. ಅಲ್ಟಿಮೇಟ್ ಆಗಿ ಮೂರನೇ ಸರಿ ಬಂದಾಗ ಡಿಸ್ಮಿಸಲ್ ಆಗಿದೆ. ಒಟ್ಟಿಗೆ 6 ಸಲ ಬಂದಿದೆ. ರಿಜಿಸ್ಟ್ರಾರ್ ಮುಂದೆ 3 ಸಲ, ಕೋರ್ಟ್ ಮುಂದೆ 3 ಸಲ. ಕಾಸ್ಟ್ ಕಟ್ಟಿಲ್ಲ.
ಫಸ್ಟ್ ಕಟ್ಟಿದೆ.
ಯಾವಾಗ? ಡಿಸ್ಮಿಸಲ್ ಆದ್ಮೇಲೆ
ಅದು ರಿಜಿಸ್ಟರ್ ಕೋರ್ಟ್ ಜನರಲ್ ಆಫೀಸರ್ ಅಲ್ಲಿ ಕಟ್ಟಿದ್ದು ಮೇಲಾಡ್. ಆದ್ರೆ ಕರ್ನಾಟಕ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿ ಅಲ್ಲಿ ಕಟ್ಟಬೇಕಾಯಿತು. ಅದಕ್ಕೆ ಈಗ ಅಲ್ಲೇ ಕಟ್ಟಿ ಅದನ್ನ ರಿಸಿಪ್ಟ್
ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಅಥಾರಿಟಿ ಅಂತಿದೆ. ಎಲ್ಲಿ ಕಟ್ಟಿದ್ದೀರಿ?
ಇಲ್ಲಿ ರಿಜಿಸ್ಟರ್
ಹೋಗ್ಲಿ, ಸ್ಟೇಟಿಗೆ ಯಾರು ಕಟ್ಟಿದ್ದೀರಾ? ಎಲ್ಲಿದೆ ರಸೀಟ್?
It has been attached to Milad.
Submits that already paid the cost but not produced the receipt for having paid the cost. Directed to produce the receipt for acknowledgement for having paid the cost. ಹೇಳಿದ್ದಾರೆ. Last time ನಾನೇ ಮಾಡಿದ್ದೀನಲ್ಲ ಆರ್ಡರ್. ಹಾಕಿದ್ದಾರೆ ಈಗ. Told the council submits that cost has been the council produced the receipt for having paid the cost, and hence another 2 weeks time granted to pending consideration of IA to comply the office objections.
ಇದರಲ್ಲಿ FDP ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಇದರ ಆರ್ಯ ಮೇಲೆ
ಯಾವಾಗ ಕಂಪ್ಲೈ ಮಾಡ್ತೀರಿ ಹೇಳಿ? 2 ವಾರ ಕೊಟ್ಟಿದ್ದೀನಿ. 1 ವಾರದಲ್ಲಿ ಮಾಡ್ತೀರಾ? 1 week time granted to comply.
2 days Milad. 2 days because I have to file an IA for a stay application Milad.
List this matter on 20th. Working ಇಲ್ಲ 19th. 19/7.
77, BS Nagraj.
Bringing LRs of R2A.
For the respondents 1 to 3.
Notice ಹೋಯ್ತಾ?
Notice. No, ಇಲ್ಲ
ಹೋಗಿಲ್ಲ. Issue notice on IA number 3 of 24 against the LRs of R2. ಮತ್ತೇನ್ ಮೇಡಮ್ ಇದು? Not pressing of IA ನಾ? IA 1 of 24 and 2 of 24 are not pressed in view of councils. ಏನ ಮೆಮೊ ಹಾಕೋರು ಮೇಡಮ್?
ಇಲ್ಲ ಸರ್, ಹಂಗೆ ಇದನ್ನ ಬರ್ಕೊಡ್ಬೇಕಾ?
In view of the council submission. ಆಮೇಲೆ ಅಷ್ಟೇನಾ?
Objections to IA.
I'm filing
of objections to IA.
I'll file my objections today in the registry.
Council appearing to the respondent would submit that he is going to file objections to IA number 3 of 24 today in the office.
Yes.
Right. Next,
78,
CD of 1 day na. Delay of 1 day is condoned. ಏನ್ ಹೇಳಿ matter ಏನ್ ಹೇಳಿ? Suppose the matter for admission in the end of the month. ಹೇಳಿ ಏನು?
Appellant number 15, my lord. 15th appellant. He died, my lord, on 23.
15th appellant.
Yes.
ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ appellant? ನೋಡಿಲ್ಲ. ಆಯ್ತು. Appellant counsel submits that 15th appellant is no more and hence 2 weeks time granted to bring the LRs of 15th appellant. Yes, 79.
79,
260 days in filing.
Please.
Issue notice on IA 1 of 23 and also on main.
Please.
Next,
partner in admission 80,
ಸೋಮಶೇಖರಯ್ಯ.
ಅಪ್ಲೈಂಟ್ ಮೇಲೆ ಕೈಂಡ್ಲಿ ಪಾಸ್ವರ್ಡ್ ಮೇಲೆ 230 ತಪ್ಪಿನ ಕೊಡಲ್ಲ ಒಂದೇ
Pass over. ಆಯ್ತು.
230.
Don't fix the time to the court. 2:30 ಅಂತ ಪಾಸ್ ಓವರ್ ಕೇಳಿದಿರಿ, ಪಾಸ್ ಓವರ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
81 urgent, admission matter 82, Sir NG.
For the appellant,
Sir,
only pass over this matter. Scene is coming.
ಪಾಸ್ ಓವರ್ ಎಲ್ಲ ರೀಚ್ ಆಗೋದಿಲ್ರಿ 130 ಮ್ಯಾಟರ್ಸ್ ಇದೆ. ಯಾಕೆ ಐ ಡೋಂಟ್ ನೋ ವೈ ಯು ಆರ್ ಟೇಕಿಂಗ್ ಫಾರ್ ಪಾಸ್ ಓವರ್. ಆಯ್ತು 83 KS ಹರೀಶ್
ಸೀನಿಯರ್
ಎಲ್ಲ ಪಾಸ್ ಓವರ್ 2 ಗಂಟೆ ಬರೀ ರಿಪೇರಿ ಕೆಲಸ ಬೆಳಗಡೆಯಿಂದ 10:30 12:00ವರೆಗೆ. ಇನ್ ಮತ್ತೆಲ್ಲ ಪಾಸ್ ಓವರ್. ಯಾವ್ದು ಕೇಸ್ ನಡೆಸ್ಬಿಡಿ. ಹಾ ನೆಕ್ಸ್ಟ್ 84
ವಿಜಯಶೇಖರ್ ಗೌಡ.
For the appellant's statement. My lord, it is the dependent's appeal.
partly decreed, gift deed not binding on plaintiff. Confirm. ಹೇಳಿ.
This case, my lord, during lifetime of T. Ramaya, my lord, who filed a suit for relief of declaration, seeking declaration and permanent injunction against the true owner and possessioner, his own brother, they were dependent, my lord. My lord, he sought prayer before the Honorable Trial Court in OS number 550/1998, based on illusionary cause of action, and filed the time bar suit to challenge his own gift deed executed by him in favor of his brother Jayappa. My lord, on 23/1982, my lord, he himself has executed the registered gift deed, and by receiving 1,000 rupees from his brother, then my lord, he slept over the matter. When my lord, I about to change the khata in my name in the year 1994-95, I approached the Tahsildar for change of RTC and mutation in my name. Then my lord, he did not do so. Therefore, I went in before the Tahsildar has passed the order by accepting the my lord, my gift deed. Then my against which order, my lord, the plaintiff went in before AC. Then my lord, AC has passed an order. Since there is a civil dispute, parties to approach the Honorable Civil Court.
Yes.
In the 1998. Then my lord, he filed a suit for the declaration, declaring that the gift deed dated 23/83 is not binding and null and void. Then my lord, I have appeared before the Honorable Trial Court and filed detailed written statement. And my lord, primarily issues. Your Lordship may kindly see the trial court primarily issues. Whether the plaintiff proves that he is the absolute owner in possession of the suitable property as alleged. Whether the plaintiff further proves that the dependent has got executed registered gift deed dated 23/82 by playing fraud and misrepresentation under the circumstances pleaded in para 8 of the plaint. And the same is null and void and not binding on the plaintiff as alleged. Then my lord, issue number 3, my lord, whether the plaintiff proves that in alternative, he has perfected his title by of adverse possession as alleged. Whether the plaintiff further proves that dependent has illegally interfered with his possession as alleged. Whether the dependent proves that the plaintiff has sold the suit property, dependents have sold, dependent proves the plaintiff has sold the suit properties by of gift to avoid the fragmentation of land act under the circumstances pleaded in para 7 of the written statement. Then, my lord, whether the plaintiff is entitled for the relief, so and so. Additional issues, my lord. Whether the LRs of dependent one proves that their themselves and their deceased father Jayappa has valid marketable title over the suitable property to sell the same to dependent number 2 under the registered sale deed dated 7/11/2007 through sale agreement dated 6/12/2006. Holder K.A. Ramanjanappa. Then, my lord, the plaintiff dies. His LRs have been brought on record. My lord, one Shivana has been examined as a.
Regarding fraud is concerned, what is the finding of the trial court?
No finding has been given, my lord. No finding has been given regarding fraud and coercion. My lord, can you see the trial court order, para number 21, please, my lord. Regarding a limitation. The learned judge very erroneously come to conclusion that
from the date of knowledge, that is the date of knowledge of Ramaya as on when the RRT proceedings come up before the Tahsildar in the 96. And when Assistant Commissioner directed the parties to go and approach the civil court, from there, my lord, the trial court taken this one. In spite of, my lord, I referred the landmark rulings regarding section, Article 59. Your Lordship may kindly
Why you have not examined any of the attesting witness of the gift deed?
my lord, by that time, my lord, first dependent was died. During pendency of this first dependent died, his LRs have been brought on record.
Maybe. Attesting witnesses also died?
Maybe, my lord.
No,
Because he's the oldest
not maybe,
document.
maybe Allah. Really, why you have
Definitely.
not examined the attesting witnesses to prove that the gift deed is a valid gift?
That is the reason, my lord, why you
The reason only trial court comes to go to paragraph number 32. The very execution of the gift deed is under challenging, despite no attesting witnesses to the said deed of gift are examined by the defendant. The mandatory requirement of examining an attesting witness under section 68 of the Evidence Act is only in respect of a will, not in respect of the gift deed if the execution of the gift deed is not specifically denied. In that case, there is no obligation on the part of the propounder of the deed of gift to prove the execution by examining an attesting witness like that of deed of will. In the present suit, it is specifically pleaded regarding the fraud and misrepresentation regarding the execution of deed of gift. Therefore, the proviso to section 68 of Evidence Act does not become operative and functional to exhibit P1. Therefore, exhibit P1 is the gift deed has to be proved in terms of section 68 of the Evidence Act. None of the attesting witnesses have been examined by the defendants, nor the donee is stepped into the witness box, nor his legal representatives. Under such circumstances, the plaintiff has proved the gift. The deed dated 23/1982 was executed by flaying, fraud and misrepresentation. Under circumstances, gift deed of exhibit invoice document. However, admittedly, the social property is an ancestral property of deceased plaintiff. Hence, plaintiff number 1A to 1F and the defendant number 1A to E being the joint family members become the joint owners of the social property. Though the plaintiff has alternatively sought for the relief of declaration of title by adverse person, it does not serve for consideration. Moreover, he has not adduced evidence in this regard. However, the plaintiffs have proved that they are the joint owners of the social property and it is for their ancestral joint family property. Therefore, the question of granting title by adverse person does not arise. However, no injunction can be granted so and so, so and so, so and so.
My lord, execution of the will, gift deed has been admitted by the PW1 in his cross-examination. But
Even admitted that when the ancestral property, whether the plaintiff can execute the gift deed.
Definitely not, my lord.
But then.
Co-partner cannot execute the gift deed,
then-
but my lord, that has
That
been
is the
happened.
reason given by the trial court.
After 35 years, my lord, he before the Honorable Civil Court, seeking cancellation of the gift deed. My lord, can you see section 90 of the World Evidence Act? A document which is older than 30 years. It is genuine
Even if
document.
it is 50 years also, when he is not having any right in respect of the property to execute the gift deed exclusively, how can he execute it?
He executed,
Main
my lord,
contention
instead
is
of,
that the very
instead of
same
selling the
gift deed
property,
is obtained by fraudulently.
instead of selling the property under sale deed, my lord, because of the Fragmentation Act was
Reasoning of the first appellate court.
first appellate court sailed with the trial court judgment, my lord. Nothing has been discussed except appreciating the findings of the trial court, my lord. There are 21 minutes. Each page 45. As far as limitation point is concerned, till year 1996, RRT proceedings are going on before the Revenue Authority, and this has been clearly observed by the trial court in para 20 of its judgment. In this regard, trial court believed contentions of exhibit P20 and P21, and in para 35, where under it has observed that the limitation starts from the date of knowledge of alleged gift deed, and with reference to Article 59 of Limitation Act. The trial court has rightly observed that plaintiff has instituted suit in the 1998, that is, within 3 years from the date of knowledge. So this observation and finding does not require interference, as it is based on sound principle of law. Madam, can you see the person who filed the suit, he had personal knowledge as on 1982 itself.
ಏನಿದೆ ಪರ್ಸನಲ್ ನಾಲೆಡ್ಜ್ ಅನ್ನೋದು
He himself executed the document, madam.
ಎಕ್ಸಿಕ್ಯೂಟ್ ಇದ್ದ ಮಾಡಿದ್ದಾಯ್ತ್ರಿ ಅದ್ ಬೈ ಪ್ಲೇಯಿಂಗ್ ಫ್ರಾಡ್ ಅಂತ ಇದೆ. ದಟ್ ಈಸ್ ದೇರ್ ಕೇಸ್. ಅವನಿಗೆ ನಾಲೆಡ್ಜ್ ಅಲ್ಲಿ ಇತ್ತು ಅಂತ ತೋರ್ಸಕ್ ಏನ್ ಮೆಟೀರಿಯಲ್ ನೀವು ಪ್ಲೇಸ್
The
ಮಾಡಿದಿರಿ?
execution of the instrument itself is knowledge, madam.
That's all your argument?
What says 1995, 1 SCC, page 198.
Counsel, that's all your argument?
Then, my lord, he himself, my lord, in order to grab the property of his brother, he has received the consideration of 1,000 rupees under the gift deed. Therefore, my lord, the Jayappa had valid title and thereby he sold 30 kuntas in favor of second respondent.
When he himself is not having any title, if he sells the property to someone else, how it will confirm the title in favor of the subsequent purchaser?
Because my lord, he obtained RTC's mutation, etc. after 1996. And even till now, my lord, the RTCs are standing in the name of Jayappa. And land has been converted from agricultural, non-agricultural.
This matter is listed for admission and I heard the counsel for the appellant. His second appeal is filed against the concurrent finding of the trial court and also the first appellate court. The factual matters of case of the original plaintiff before the trial court in OS number 550 of 1998 that he is the absolute owner in peaceful possession and enjoyment of the land bearing survey number 1/1 measuring 34 kuntas situated at Kadiganhalli village, Jala Hobli, Bangalore, North Taluk, which is more fully described in the schedule. He was cultivating the scheduled property as a tenant and his father, late Tirumalappa, obtained occupancy rights. Since then, the suit scheduled property is in the possession and enjoyment of the plaintiff. Ever since the plaintiff is in possession and enjoyment of the property, he is paying the tax in respect of the suit scheduled property. And also he had constructed a house in the suit scheduled property and obtained electricity connection. He dug a borewell on the northern side of the suit scheduled property and he grow 3 coconut trees. The plaintiff is cultivating the suit scheduled property with his children. The defendant, who is the younger brother of the plaintiff residing separately, first off, he had worldly knowledge having political affiliation, who used to induce the plaintiff to do necessary things for the development of his land. And he has induced the plaintiff, and he being the scheduled caste community, the plaintiff will get free borewell from the government and asked the plaintiff to execute some papers to enable him to get sanction of borewell in the scheduled property. In order to get the Kata and Pani into his name, the defendant filed a false application before the Tahsildar, claiming that he has purchased the suit scheduled land under sale deed dated 23/1982. In the written statement in RRT disputes number 8/9495 before the Tahsildar, Bangalore North Taluk, within bracket additional and 10/4/1996. The defendant disclosed that he acquired the property through gift deed dated 23/1982. They are alleged to have been executed by the plaintiff in favor of the defendant. The Tahsildar, without going to the merits of the case, passed an order allowing the application to change the Kata and Pani in his name. The plaintiff referred an appeal before the Assistant Commissioner, which is pending before the
He disposed of money.
and the same has been stayed on pleadings.
Yes.
The plaintiff at no point of time has executed any registered gift deed in favor of the defendant. And the same is created and fabricated and the gift deed is also never acted upon. The plaintiff is in possession and enjoyment of the social property and there was no need to execute the gift deed. The same has been obtained by playing fraud. In pursuance of the suit summons, defendant number 1 appeared and filed the written statement denying the averments made in the plaint. And also specific contention was taken that gift deed was executed and he was put in possession in respect of the suitable property to the extent of 34 guntas. When the defendant demanded to execute the sale deed, the plaintiff executed gift deed since there was a bar to register the fragments of lands, which is less than an acre. To avoid the same, plaintiff willfully and without there being any force or fraud executed the gift deed. And they said gift deed is valid gift deed. And revenue entries are also changed in his favor and he has been in possession of the suitable property. But only the plaintiff is in permissive possession of 1 guntas of land wherein he has constructed a house. The defendant has dug a borewell by spending huge money and not the plaintiff. And defendant is in possession of the property. During the pendency of the suit, both the plaintiff and defendant are reported to be dead and hence the LRs are also brought on record. The trial court, having considered the pleadings of the parties, allowed the parties to lead evidence and answered the issue number 1 as affirmative. That property belongs to the plaintiff and also answered the issue number 2 as negative, that the gift deed has been obtained by flying fraud and misrepresentation as pleaded in paragraph number 8 of the plaint.
On submission, my lord.
And
But before passing judgment, my lord,
decreed this.
D1A died in the 2014. Her
Declared the suit.
no amendment
Come
has
to the
been.
conclusion that the gift deed is null and void, not binding on the plaintiffs. Now, here,
Before my lord, is judgment, first judgment has been passed on 6/8/16, my lord. But D1A, my lord, Narayanamma died in the year 2014. Their own case plaintiffs have not filed the LR application or memo to substantiate. Then, my lord, in era 36, my lord.
already LRs were already on record alwa.
No.
Matten LR application haku. 1B, 1C, 1D are the LRs.
ಹೌದು ಸರ್
ಮತ್ತೆ LR application ಹಾಕ್ತಾರೆ.
36 para 36 ನಲ್ಲಿ trial court said the evidence on record reveals that the plaintiffs and defendants are co-owners of the suitable property. Therefore, injunction cannot be granted against co-owner. The sale deed dated 7/11/2007 executed with defendant number 1 in favor of defendant number 2 is it by law
of lispendence.
Hence, same is not binding on the plaintiff. The evidence on record reveals that suitable property, ancestral property of the plaintiffs. For the above reasons, the plaintiffs are partly entitled for the decree.
That's why partly granted relief. Not binding on the plaintiffs.
Once the honorable trial court comes to conclusion it is ancestral property, my lord. Then we have also vehemently contended that if this honorable court comes to conclusion that if it is an ancestral property, giant family property, the defendants are entitled for half share in the property.
Being aggrieved by the judgment and decree of the trial court, and appeal is filed in RA number 15045 of 2016. And the appellate court, having considered the grounds urged in the appeal memo, and also the both oral and documentary evidence available on record, framed the point for consideration. Whether the plaintiff proves his title and possession of the suitable property, whether the defendant proves that plaintiff sold suitable property by way of gift deed to avoid fragmentation, bar, whether the judgment and decree requires interference. The first appellate court, having reassessed the material available on record, answered the issue number 1 as affirmative in coming to the conclusion that the plaintiff proves his title and possession and contention of the defendant that gift deed was executed in lieu of sale deed has not been accepted in lieu of the bar under the Fragmentation Act. And answered the same as negative and confirmed the judgment of the trial court. Being agreed by the said judgment and decree of trial court as well as the first appellate court present second appeal is filed before this court. The main contention urged by the counsel before this court is that both the courts have committed an error in coming to the conclusion that the gift deed is obtained fraudulently. And counsel also vehemently contend that the appellants have been totally deprived and deceived, and as well as the second respondent herein was is bona fide purchaser who purchased the suit property from this appellants under a sale deed dated 7/11/2007, and she was not given an opportunity to contest the matter on merits, since he was already purchased the property, and the reasoning given by the trial court that the sale deed is hit by principles of respondents is erroneous, and hence court has to frame substantive question of law. The counsel also vehemently contend that both the courts below have lost sight in not making any inquiry on the point of limitation. And even though the original plaintiff being executor of the gift deed dated 23/1982 without applying its mind comes to the conclusion that suit is within time by taking into note of the knowledge pleaded by the plaintiff about the gift deed, and hence it requires interference. Having heard the appellant counsel and also on perusal of the material, and particularly in the plaint, the original plaintiff has pleaded that gift deed is obtained by playing fraud, and only signatures are taken.
He was the panchayat member, Taluk Panchayat member.
Think that he would get the benefit. And also specific reading is made in the plaint that by playing fraud and misrepresentation, gift deed is obtained. The trial court also having considered the pleadings which have been made in the plaint and also taking into note of the fact that both the plaintiff as well as the first defendant passed away during the pendency of the suit, and the LRs are brought on record, particularly in respect of the in paragraph number 18 made an observation that one of the plaintiff has been examined as PW, LR of the plaintiff has been examined as PW1, and whereas the LRs of defendant has not entered into witness box. On the contrary, PA holder is examined as DW1. And also trial court taking into note of material available on record comes to the conclusion that DW1 is son-in-law of the late defendant. And according to DW1, in the year 1993, he married daughter of late defendant Jayappa. He has clearly deposed that he doesn't know what are all the transactions were entered into and made between plaintiff and defendant. But only he contend that there is a recital about the receipt of sum of ₹1,000 by plaintiff Sri Ramaya from the defendant Sri Jayappa. But on going through the contents of exhibit P1, nowhere find such details. Even trial court also having considered the material comes to the conclusion that None of the attesting witnesses have also been examined to prove that gift deed is voluntarily executed by the executant of the gift deed. And trial court also taking into note of with regard to the defense which has been raised, limitation is concerned in paragraph number 21, discuss the same. In coming to the conclusion that plaintiff has continued his possession and even house has been constructed in the very same property. And when the possession is continued with the plaintiff, and if really he had executed the gift deed, possession would have been delivered to him, except getting changed the documents of revenue records, nothing is placed on record that the defendant is in possession, and apart from that, the property is also granted in favor of the father of the plaintiff, since father of the plaintiff, first plaintiff only, father of the original plaintiff only under cultivation of the property. And also the trial court taken note of that the executant is not having any exclusive right to execute the gift deed in respect of the ancestral property. And first appellate court also having taken note of both oral and documentary evidence of on record, and particularly the children of defendant number 1 have not stepped into the witness box and only examined the son-in-law, and he was not having any personal knowledge, and also taken note of the fact that he was married in the year 1993, but alleged alleged gift deed is dated 23/1982. And even attesting witnesses have not been examined. Even the first appellate court also in detail discussed the material available on record in coming to the conclusion that by playing fraud and misrepresentation, only document of exhibit gift deed came into existence. And also comes to the conclusion that defendants also failed to establish that exhibit P1 is acted upon, and original defendant came in possession of social property by virtue of the alleged gift deed dated 23/1982, and the same has been discussed in paragraph number 20 of the judgment. On the other hand, contrary, the plaintiffs have produced the election card as per exhibit P10 and electricity bill and receipts as per exhibit P11 to 15, and certificate issued by KEB as per exhibit P16 and 17, and survey map as per exhibit P18, including Akar Band register extract as per exhibit P19. Having considered all these documents, comes to the conclusion that plaintiff has established that plaintiffs are in possession and enjoyment of the disputed property. And even with regard to the possession is also concerned, definite finding is given that possession is continued. And when such being the case, when the defendant pleads that there was a gift deed and he has not established the possession, as well as the circumstances under which the exhibit gift deed came into existence, and the same also has not been proved by examining any of the attesting witnesses. And hence both the courts having considered oral and documentary evidence available on record, given fact finding that the defendants have failed to prove that the document is a voluntary document, and on the other hand, plaintiffs have proved that the exhibit gift deed came into existence by playing fraud and misrepresentation. And when such fact finding is given by both the courts, the very contention of the counsel appearing for the appellant that both the courts have misread and not applied the mind in passing the order cannot be accepted, and hence I do not find any ground to admit and frame any substantive question of law. In view of the discussions made up, I pass the following order. Second appeal is dismissed.
One submission. Trial court held the suit property in person is ancestral property. In case the gift deed go, then what happens to the suit property?
Then you can file a suit for partition if you are entitled for a share for
The trial
partition.
court did not given any finding, not the first appellate court. Therefore, I request this honorable court to give the
You can seek for relief, that's all.
liberty.
If the property is an ancestral property, you can seek for
Your
appropriate.
lordship may
relief.
kindly make a note of this. give liberty, my lord.
Why court, this court has to give liberty counsel, that is, that is.
Para number
If
36,
if you
my lord, can you see?
intend to file a suit for partition, you can file at any time.
La, para 36, my lord, can you see? 36 of the trial court.
Why court has to grant
Because trial court has not
liberty?
granted injunction to the plaintiff because it's a co-partial property. When there is co-owner and a co-partial property, no injunction can be granted. That is the law. Therefore, my lord, the lordship of the trial court or first appellate court.
Trial court ಏನ್ ಮಾಡಿದಾರೆ relief declaration ಮಾಡಿದಾರೆ, gift deed is fraudulent ಅಂತ
liberty
ಮಾಡಿದಾರೆ.
petition.
No other relief is granted. You seek for relief if anything, if your client is entitled,
Because
that's
after
all.
long passage of time, no, my lord, can you see? Without the liberty, my lord, I cannot.
Liberty
Because
ಪ್ರಶ್ನೆ ಬರೋದೇ ಇಲ್ಲ.
they are very-
If you want to file a suit for partition, that's all, claiming that property is an ancestral property. That's all.
Ancestral property ಬಗ್ಗೆ ಪೈಂಡಿಂಗ್ ಬರಲಿಲ್ಲ ಸರ್, ಅದಕ್ಕೆ ಒಂದು ಪೈಂಡಿಂಗ್ ಕೊಟ್ಬಿಡಿ ಸರ್ ದಯಮಾಡಿ.
ಅಷ್ಟೇ ರೀ ಮಾಡಿರೋದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ತಾವು ಒಂದು ಪೈಂಡಿಂಗ್ ಕೊಡಿ ಸರ್.
Gift deed is null and void and not binding on the plaintiff. That is the only relief.
ಒಂದು
Not-
ಪೈಂಡಿಂಗ್
No other relief is sought.
ಬಗ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ.
ನಾನೇನ್ ಕೊಡಕ ಪೆಂಡಿಂಗ್?
ಆನ್ಸೆಸ್ಟ್ರಲ್
ನೋ ಕೌನ್ಸಿಲ್. ನಾನ್ ಇಲ್ಲಿ ಕೊಟ್ರೆ ನೀವೇನ್ ಮಾಡ್ತೀರಿ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಅಲ್ಲಿ?
ಅದು ಹಾಕೊಳ್ತೀವಿ.
ಅಲ್ಲಿ ಹಾಕೊಳ್ಳಿ ಅಷ್ಟೇ ನೀವು, ಅಷ್ಟೇ. ದಟ್ಸ್ ಆಲ್. ಲಿಬರ್ಟಿ ಪ್ರಶ್ನೆ ಬೇಕಾ ಇಲ್ಲ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಹಾಕೋದಾದ್ರೆ. No liberty is required also.
ಬೇಕಾಗುತ್ತೆ ಸರ್ ಅದಕ್ಕೆ.
Next, 85.
Prasad BS.
ಇಲ್ವಾ ಪ್ರಸಾದ್? ಡಿಲೇ ಇದಲ್ವಾ?
Oh, sir.
Issue notice on A1 of 18. But also on main against the respondents. 86 ಸುಧೀಂದ್ರ ಎಸ್ ಇವ್ರೇನ ಟೈಮ್ ಕೇಳಿದ್ರಲ್ಲ ಬೆಳಗ್ಗೆ?
Adjourn ಆಗಿದೆ. 87 ಮುರಳಿಯನ್ ವರಪ್ರಸಾದ್ ಕೆ.
ಮುರಳಿ ವರಪ್ರಸಾದ್.
Plaintiff's second appeal. Suit for declaration and injunction. Both the courts held against the plaintiff. But plaintiff, case of the plaintiff is that suitable properties belongs to their father, one Gundappa. He, after his death, they are in possession and enjoyment. Defendants are trying to, hence, they filed the suit for declaration injunction. My lord, case of the defendant is that, my lord. My lord, he purchased the property from one Ajappa, who is the brother of one Gundappa. That is father, husband of first plaintiff and father of plaintiff number 2 and 3. From the date of sale, they are in possession and enjoyment of the social property and press dismissal. My lord, both the courts, my lord, disbelieved the documents of the plaintiff on the ground that, my lord, based on the exhibit D10, that is endorsement given by the Tahsildar, stating that there was no records available in respect of issuance of Saguvel chit in favor of father of plaintiff. And my lord, disbelieved exhibit D15, P15, that is Darkast register. On the ground that, my lord, there was no pleadings. And my lord, there was no supportive evidence to substantiate the source of the title of the Gundappa, that is plaintiff. My lord, my specific case is that, my lord, suture property standing in the name of my father from the year 1965 to 1992. My lord, first time, my lord, after death of my father, Kata was transferred in the name of first plaintiff, on the base of Pavitavars. My lord, first time defendant transferred Kata in the year 1997 in the name of his father, who is not alive as on the date of the Kata. And subsequently, he transferred in the name of defendant. And he claiming the property on the base of police sale. My lord, his evidence, my lord, in the cross examination, he says that, my lord, he purchased the property from.
It is filed for the relief of declaration and injunction.
Please, my lord.
To declare that you are the owner.
Please, my lord.
What is the material you have placed before the trial court?
My lord, I produced, my lord, RTC from the year 1965 to 1992 and mutation registers and patta book and exhibit D15.
Mutation based on what?
My lord, exhibit D15, my lord, is the Darkast register. My lord, court disbelieved that, my lord, in the exhibit D15, extent was not properly mentioned. It says block number 7 and 3. They says, my court, both the court says that Malada, whether it is 3 acres or 3 guntas, it was not mentioned. And to prove the boundaries, I have not produced any document. Malad, when Malad in the cross-examination, he himself says that,
According to you, it is a grant.
please Malad,
ಹೌದಾ?
please Malad.
Grant order ಎಲ್ಲಿದೆ?
Exhibit P15 Malad. Grant order ಅಲ್ಲ, grant, ದರ್ಖಾಸ್ತ್ register.
ದರ್ಖಾಸ್ತ್ ರಿಜಿಸ್ಟರ್ ಆಯ್ತ್ರಿ,
Please,
ಗ್ರಾಂಟ್
madam.
ಬೇಕಲ್ಲ, ದರ್ಖಾಸ್ತ್ ಕೊಟ್ರದಕ್ಕೆ ನಿಮಗೆ.
Grant certificate produce ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೆ?
ದರ್ಖಾಸ್ತ್ register produce ಮಾಡಿದೀನಿ.
ಹ್ಮ್.
They admitted that along with Gundappa, several persons were granted. Malad, he himself in the chief examination, defendant himself says that Malad, father of plaintiff was granted in somewhere in the survey number 46. Malad, survey number 46 totally measuring 200 acres. He himself admitted that Malad, survey number 46 is a Goma land.
ಆಯ್ತು, ಈ ಶೆಡ್ಯೂಲ್ ನಿಮ್ಗೆ ಅಲಾಟ್ ಆಯ್ತು ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನಿದೆ ದಾಖಲೆ?
ಅದು ಅದರಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಇಲ್ಲ ಸ್ವಾಮಿ, ಎಕ್ಸ್ಟೆಂಟ್ ಇದೆ,
ಮತ್ತೆ?
ಸರ್ವೆ ನಂಬರ್ ಇದೆ, ಎಕ್ಸ್ಟೆಂಟ್ ಇದೆ, ಬಟ್ ಬೌಂಡ್ರೀಸ್ ಇಲ್ಲ. ಮಲಡ
ಎಕ್ಸ್ಟೆಂಟ್ ಎಷ್ಟಿದೆ?
extent 3 acres is.
ಹ್ಮ್.
Malad, my specific submission, Malad,
Hmm.
he claiming right under my uncle Hajjappa. Malad, they have not produced any document to show that Hajjappa have a right in survey number 46. Malad, in his cross-examination, he admits that he purchased the property from Hajjappa Gundappa. Malad, Gundappa is my father. There were no material or document produced to show that Gundappa was executed sale deed in favor of defendant's father. Malad, Ajappa is no way concerned. He himself admit that Malad, survey number 46 is a Goma land. If it is Goma land, there should be a document in favor of Ajappa to show that land was granted and subsequently Ajappa was sold in favor of the defendant. Malad, there was no material to show that Ajappa was granted in the survey number 46. They themselves says in the chief examination itself, survey number 46 is a Goma land. There were several persons was allotted, granted, and there is remains 94 acre of land in survey number 46. Plaintiff can claim in that land, Malad, if that is so, Malad, without there being any document to source of title showing that Ajappa having right in survey number 46. They claiming.
Why you are arguing about the case of defendant? First you argue your case.
Please, Malad, to prove my case, Malad.
In a case of declaration, it's your bounden duty to prove your title, not the weakness of the defendant.
Please, Malad. Malad, I produce, Malad.
You are claiming that you are the absolute owner.
Please, Malad.
What are the documents you have placed?
Malad, I produced, Malad, RTC, mutation and patta book and
Same
Darkhast register, Malad.
Convey title to you.
Courts, Malad, disbelieved, Malad, I have not examined any revenue officer to prove the exhibit P15. Malad, the court, the way in which they have considered exhibit P15, Malad. Para 36, Malad, page 35, ink page 35, Malad. Appellate court, trial court not at all considered exhibit P15. Malad, however, Malad, appellate court considered and says, Malad, page, ink page 35 and para 36. PW in his cross-examination at page number 4, last paragraph has admitted that exhibit P15 is relating to the house and the vacant site. He has admitted that exhibit P15, the measurement is not mentioned and only block number is mentioned. He has stated that the said land is Goma land. When the learned counsel for the defendant suggests to PW that said survey number 46 consists of 200 acres of Goma land, and for that PW has stated that 3 acres of land in survey number 46 belongs to them. He has stated that he does not know that Tahsildar Bangarpet issued the endorsement of stating that no land was granted in the name of A.K. Gundappa. Malad, he says, Malad, records were not available in respect of grant certificate. Hence, by considering the said answer PWN, this court is of the opinion that exhibit P15 is relating to the house and vacant site. Hence, the said document does not come to the aid of the plaintiff to establish their case. My lord, in the cross examination, my lord, PW.
Further observation, then the evidence of PW2 also does not come to the aid of the plaintiff to establish their title, possession and enjoyment of the suit scheduled property.
My lord, in DW1, my lord, in his Malada, his chief Malada, he says Malada, the total extent of land in survey number 46 is Goma land measuring 186 acres, 11 guntas, out of which 92 acres, 10 guntas has been allotted to different persons, which includes the suit scheduled property, and now the remaining property 94 acres, 1 guntas in said survey number, which is remains as Goma land. The plaintiffs are herein claiming the defendant's property instead of claiming remaining property and where it comes. There is dispute regarding identification of the plaintiff's property. Malad, this is the chief Malad. Malad, in cross examination, ದಾವಾ ಸೊತ್ತು ನಮ್ಮ ತಂದೆಗೆ ಸೇರಿರುವ ಸೊತ್ತಾಗಿರುತ್ತದೆ. ಅಜ್ಜಪ್ಪ ಗುಂಡಪ್ಪ ರವರಿಂದ ನನ್ನ ತಂದೆಗೆ ದಾವಾ ಸೊತ್ತು ಬಂದಿರುತ್ತದೆ. ಮಲಡ್ ಅಜ್ಜಪ್ಪ ಇಸ್ ಮೈ ಅಂಕಲ್, ಗುಂಡಪ್ಪ ಇಸ್ ಮೈ ಫಾದರ್ ಬಂದಿರುತ್ತದೆ. ಸದರಿ ಅಜ್ಜಪ್ಪ ಗುಂಡಪ್ಪರವರಿಗೆ ದಾವಾ ಸೊತ್ತು ಹೇಗೆ ಬಂತು ಗೊತ್ತಿಲ್ಲ. ನಮ್ಮ ತಂದೆ ಅಜ್ಜಪ್ಪ ಗುಂಡಪ್ಪರವರಿಂದ 25/10/1961 ಇಸ್ವಿಯಲ್ಲಿ ದಾವಾ ಸೊತ್ತು ಕೊಂಡುಕೊಂಡಿರುತ್ತಾರೆ.
Counsel, I am repeatedly telling you,
Please.
when you have approached the court for the seeking the relief of declaration, you have to establish your right. Whether his title is correct or not.
He also now filed Malad a suit for declaration against me and other.
ಮೇಲಾಡಿ ಇದು 1960 ನಮ್ಮ 65 ನಮ್ಗೆ ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ. ಅವಾಗ್ಲಿಂದ ನಾವು ಅಲ್ಲೇ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದೀವಿ. ಮತ್ತೆ ತಹಶೀಲ್ದಾರ್ ಅವರು ಬಂದು ಅಪೀಲ್ ಪೇಜ್ ನಂಬರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 23 ಮೇಲಾಡಿ ಅವ್ರನ್ನ ಕೋರ್ಟ್ the Tashildar Bangarpet named Vijay was examined before the trial court as DW3 who deposed before court that he produced the mutation book with respect to MR number 2 1996-97 to show that the Kata was affected in the name of Gantlappa in the father of defendant. In respect of suit survey number 46, the said mutation register book was marked exhibit D23 and the relevant entry MR number 296-97 was marked exhibit D23A. The certified copy of the said mutation registered book was marked exhibit D23B. It got marked to the mutation registered book MR number 298-99. Show that that mutation was entered in the name of defendant as per exhibit D24. The relevant portion MR number 298-99 was marked exhibit D24A there. D24A and the certified copy of said mutation register was marked exhibit D24B. ಅವರು ತಹಶೀಲ್ದಾರೇ ಬಂದು ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದು ಯಾಕೆಂತಂದ್ರೆ ಅದು ಪ್ರಾಪರ್ಟಿ ನಮ್ದೇನೆ, ಅದು ಮ್ಯೂಟೇಶನ್ ನಮ್ ನೇಮಲ್ಲಿ ಐತೆ ಅಂತ ಅವರೇ ಕರ್ಕೊಂಡ್ ಬಂದು ಎಕ್ಸಿಬಿಟ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ ಸರ್. ಓನರ್ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಯಾವುದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅವರು.
The basis of sale deed they first time entered in the RTC in the year 1997. Malad, that MRs was produced by the Tashildar on the summons.
This matter is listed for admission and I heard the counsel for the appellant and also the counsel for the respondent.
Kind submission.
The present appeal is filed.
But they have already filed one more suit for declaration against me, Malada. Malada, records were called for Malada.
Last suit all file ಮಾಡ್ಕೊಳ್ತಾರೆ. ಇದಕ್ಕೆ ಹೇಳಿ, ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಏನೋ
Malada. Malada, they have also claiming on the base of the RTC entries, on the base of RTC entry.
Fight it out in declaration suit filed by them.
No, Malada, that RTC entries was challenged by me. AC and DC was held.
ಆಯ್ತ್ರಿ, ಅದನ್ನ ನೀವು contest ಮಾಡಿ ಹಿಂದೆ. Why you have to keep this matter pending? The second appeal is filed against the concurrent finding of dismissal of suit and also confirming the same by the first appellate court. The factual matters of case of the plaintiff before the trial court that they are the absolute owner and they are in possession and enjoyment of the suit property and defendant is interfering and trying to cause loss and damage to the social property. And also it is their case that the property belongs to the husband and father of the plaintiffs, and they succeeded to the said scheduled property. The revenue entries are also mitigated after the death of A.K. Gundappa. Defendants are not having any title or interest over the social property. In pursuance of the suit summons, defendant appeared and filed the written statement contending that the boundary mentioned in the suit schedule is not correct. Suit schedule property originally belongs to one Ajappa, the brother of the Gundappa. The said Ajappa had alienated the social property in favor of defendant's father Gantalappa by way of registered sale deed dated 25/10/1961 and delivered the physical possession of the suit property to the father of the defendant, and since from the date of sale, defendants are in possession of the social property. And after the death of Gantalappa, the documents pertaining to social property also transferred in the name of the defendant, and defendants are in possession. That in view of the defense of the defendant, the trial court also framed the issue whether the defendant proves that social property, whether the suit is filed by the plaintiff or declaration is barred by limitation. The trial court, having considered both oral and documentary evidence, comes to the conclusion that plaintiffs have not established the title to declare them as owner of the social property, and also they are not in possession of the social property, and also failed to prove the interference. On the other hand, the trial court comes to the conclusion that the defendants have established that suit is barred by limitation since the sale deed is of the year 1961 and suit is filed in the year 2007, and the same is barred by limitation. And hence, the plaintiffs are not entitled for any relief and dismiss the suit. Being agreed by the said judgment and decree, an appeal is filed before the appellate court in RA number 76 of 2015. The first appellate court, also having considered the grounds urged in the appeal memo and also having perused the material, framed the point for consideration whether the material on record prove that plaintiffs are absolute owners, and whether the judgment of the trial court is capricious, perverse, and whether it requires interference. The first appellate court, also having reassessed the material level and record and extracted section 101 to 103 of the Indian Evidence Act, and burden lies on the plaintiff to establish before the court that they are the absolute owners. And in order to prove that they are the owners, except relying upon the oral evidence and documentary evidence, exhibit P1 to 16, not placed any document. And also taken note of, on the other hand, the defendants have produced the document, particularly registered sale deed dated 25/10/1961. The first appellate court, also having reassessed the material on record, particularly MR number 4 of 96/97, to show that Kata of the social property was changed in the name of the plaintiff number 1 and plaintiff number 2 on Pavati Warsaw basis. And also taken note of the document which has been relied upon by exhibit P15, file pertaining to register of Darkhast for vacant sites for building, etc. And admittedly, the social property is the Gomal land of 3 acres in survey number 46, but the said document is relating to vacant sites for building. And hence, taking into note of exhibit P15 also, since the council relying upon only the exhibit P15 and having reassessed the material on record, particularly taking note of admission on the part of PW1, which has been discussed in paragraph number 35 of the judgment and also discussed in paragraph number 36, the document which have been relied upon by the plaintiff and comes to the conclusion that plaintiffs have not established the title over the suit settled property and confirm the judgment of the trial court and dismiss the appeal. Being agreed by the said concurrent finding, present appeal is filed. And the main contention of the counsel appearing for the appellant also that though the defendants rely upon document of sale deed of the year 1961, that is 25/10/1961, no title in respect of the vendor Ajappa was having title in respect of the suit settled property. And also counsel would vehemently contend that when the dispute arises between the parties, matters are also taken before the revenue authorities. And particularly the counsel would vehemently contend that both the courts disbelieved the exhibit P15 on the basis of exhibit D10 endorsement issued by the Tahsildar, stating that there was no records available in the office to issue copy of the Sagwali chit issued in the name of the plaintiff's father. It is contended that in the cross-examination of DW3, Tahsildar Kama admitted the fact that exhibit P15 was issued from Tahsildar office, and he never stated that there was no grant made in favor of the plaintiff's father and not denied exhibit P15. And exhibit P15 has not been considered by both the courts, and hence court has to frame substantive question of law that even in the existence of exhibit P15 Darkhast entry register, both the courts have committed an error and non-relying upon exhibit P15 is perverse finding by both the trial court and appellate court. And hence it requires interference and admit and frame substantive question of law. On the other hand, counsel appearing for the respondent would vehemently contend that when the suit is filed for the relief of declaration and injunction, and plaintiff has to establish his title, and burden is also on him to prove his title. And in order to prove the title, nothing is placed on record except the producing RTC, exhibit P2 to 7, and also exhibit P8 and 9 and exhibit P15. And no document of grant records are also produced before the court. And admittedly, the property was Gomad land. And on the other hand, defendant also produced the document before the court that property was purchased in the year 1961 by the defendant father in terms of exhibit D11, and mutation also discloses in terms of the sale deed came into existence in terms of exhibit D12 and D13, and also produced RTC exhibit D14 to 21, and also produced copy of order passed in RA 57 of 2011, dated 7/9/2011, passed by the DC court, and also contend that the plaintiff has to prove his title, and in the absence of any title, he cannot depend on the weakness of the defendant, and hence it doesn't require any interference. Having heard the appellant counsel and also the counsel appearing for the appellant, and suit is also filed for the relief of permanent injunction and declaration and injunction in respect of scheduled property measuring 3 acres of land is concerned. Particularly in lands bearing survey number 46. Admittedly, survey number 46 is Gomad land is not in dispute, and only the appellant counsel relies upon the exhibit P15, contending that the same is the Darkhast register. And when the extent is not mentioned, and also when the title with regard to the granting of land in favor of the father of the plaintiff, also no material is placed before the court.
The extent was mentioned, but that was not believed by the court. This is
And
the
in
grant.
order to prove the title is concerned, when the property is admittedly the Gomad land, there must be a material before the court for having granted the same in favor of the plaintiff. And except relying upon the RTC extract and also the Darkhast register extract, no document of Sagwali chit or any grant certificate made in favor of the plaintiff is placed before the court. The it is also settled law when the suit is filed for the relief of declaration. The plaintiff has to establish his title. And also even appellate court also takes a note of the section 103 to 105 of 101 to 103 of Evidence Act. That burden is lies on the appellant to prove the same. And also both the courts, that is trial court as well as the first appellate court, having considered the material on record also, though the defendant relies upon the document exhibit D11 as sale deed, and the same also cannot be considered in respect of the claim is concerned as contended by the appellant that there must be a title deed of the vendor of the defendant also. And they also not disputes the fact that property is a Komal land. And when such material available on record, and also the trial court taken note of answer elicited from the mouth of PW1 also in paragraph number 11 with regard to the relationship between the parties. That is the name of his senior uncle Ajappa. And also he admits that as on the date of filing of the suit, the revenue records are standing in the name of the defendant, but he contends that he has filed an appeal before the Assistant Commissioner, Kolar. And taking into all this admission as well as documentary evidence placed before the court, trial court as well as the first appellate court comes to the conclusion that unless the plaintiff establishes his title in respect of the social property and based on only the exhibit 315, declaration cannot be granted. And when such finding is given based on the material, both oral and documentary evidence, and particularly the admission on the part of PW1 also. And also as on the date of filing of the suit, documents are also standing in the name of defendant, and no doubt both relies upon the mutation register extracts, and mutation register extracts are not the title deeds to declare them as absolute owners. And when the plaintiff fails to establish that he is the absolute owner of the social property, the question of granting the relief of declaration doesn't arise, and hence both trial court and appellate court have not committed any error in dismissing the suit and confirming the judgment and decree of the trial court, and hence I do not find any ground to admit and frame any substantive question of law to invoke section 100 of CPC. You know, the discussions made up, I pass the following order. Appeal is dismissed. 88 urgent alla?
88 and 89.
For the appellant and the respondents have settled the matter amicably. I'm filing a memo for withdrawal. My lord, the registry may be directed to pay the court fee, my lord.
Court fee?
Yes.
Told appellant counsel has filed memo stating that parties have amicably settled the matter, and hence may be permitted to withdraw the appeal, and hence permitted to withdraw. And registry is directed to refund the court fee in accordance with law.
Pledge.
Lord Mariappa.
90.
ಕಾಸ್ಟ್ ಕಟ್ಟಿದೀರಾ? ಅದರ್ ಸೈಡ್ ಆರ್ ಶಂಕರ್ ನಾರಾಯಣ್ ಭಟ್ ಇಬ್ರು ಇದೀರಲ್ಲ, will take up at 2:30. Remaining matters at 2:30.
One submission. For 2:30, special postal matters in before court number 18. After finishing that, I will.
ಮುಗಿಸ್ಕೊ ಬನ್ನಿ, ಅವ್ರು ಇದಾರಲ್ಲ, ಮುಗಿಸ್ಕೊ ಬನ್ನಿ ನೀವು. ಯಾರು ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ತೀರಿ?
We are intimated the respondent.
ಏನ್ ವಕಾಲತ್ ಹಾಕ್ತೀರಾ ನೀವು?
ನಾವು KN ಪುಟ್ಟೇಗೌಡ.
ಹಾ ಸರಿ.
We are giving NOC to the.
NOC ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಕೊಡ್ತಾ ಇದೀವಿ.
ಇನ್ನು ಕೊಟ್ಟಿಲ್ಲ.
We have informed him he is.
ಆಯ್ತು, ಅಡ್ಮಿಷನ್ ಬಿಟ್ವೀನ್ ದಿ ಅಪಲೆಂಟ್ ಅಂಡ್ ದಿ ಕೋರ್ಟ್. Let him convince the court for admission.
Next week.
ಏಕೆ? ಅವ್ರನ್ನ ತೋರ್ಸ್ಕೊಂಡು ನೀವು ಟೈಮ್ ಕೇಳ್ತಾ ಇದೀರಿ. ಬೆಳಗ್ಗೆಲ್ಲೂ ಕೂಡ ಅದೇ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರಿ. ಅವ್ರು ಹೇಳಿ ಬಿಡಿ, ಅವ್ರದ್ದೇನ್ ಇರಲ್ಲ ಪಾತ್ರ ಅಡ್ಮಿಷನ್ಗೆ. ಅಡ್ಮಿಷನ್ ಏನಿದ್ರು ಸುಮ್ನೆ ನಿಂತ್ಕೊಂಡ್ರೆ ಬಂದ್ ಕೇಳ್ತೀವಿ ಅಷ್ಟೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸೈಡ್ ನ. ದಟ್ ಈಸ್ ಇಂಟರ್ಸೆಪ್ಟ್ ಬಿಟ್ವೀನ್ ದಿ ಕೋರ್ಟ್ ಅಂಡ್ ದಿ ಅಪಲೆಂಟ್ ಅಷ್ಟೇ. ನೀವ್ ಹೇಳಿ ಅವ್ರದ್ದೇನ್ ಬೇಕಾ ಇಲ್ಲ. ನೆಸಿಟಿ ಇದ್ರೆ ಅವ್ರಿಗೆ ಅವಕಾಶ ಕೊಡೋಣ. ಮಂಗಳವಾರಕ್ಕೆಲ್ಲ ಟೈಮ್ ಇಲ್ಲ. ಇವತ್ತಿದೆ ನಾ ಓದ್ಕೊ ಬಂದಿದ್ದೀನಿ, ಅಸಿಸ್ಟ್ ಮಾಡಿ ಕೋರ್ಟ್ಗೆ ಅಷ್ಟೇ.
Lord, serial number 113, 113, my lord. It was settled for
ಹೇಳಿ 113
reporting of settlement antide. I have filed the NOC wakalat and I will also speak to the other side. My lord, weeks time may be granted and
ಯಾವಾಗ ಹಾಕಿದ್ರಿ ನೀವು ಒಕ್ಕಲತ್?
nan 3 days back, my
ಏನ್ ಹೆಸರೇನ್ ಹೇಳಿ?
Manjunath M. Hegde. It has been shown.
ಮಂಜುನಾಥ್ ಎಂ ಹೆಗ್ಡೆ.
Please.
ಇದೆಯಲ್ಲ ನಿಮ್ಮ ಹೆಸರು
Ide.
ಹಾ.
I am seeking, my lord, I will also
ಉಮೇಶ್
speak to
KS
the,
ಯಾರು ಇದಾರೇನ್ರಿ?
I will also speak to the other side and
ಹಾ.
try
Settlement
to, please. It was admitted, appeal is admitted.
ಆಯ್ತ್ರಿ, ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಗಿದೆಯಾ ಇಲ್ಲ?
ಇಲ್ಲ, ನಾನ್ ಮಾತಾಡಿಲ್ಲ, ನಾನ್ ಮಾಡ್ಬಿಟ್ಟೆ.
ಏನ್ ಆಗಿಲ್ವಾ ಸೆಟ್ಲ್ಮೆಂಟ್? ಮತ್ತೆ ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ
ಅಲ್ಲ,
ಹಾಕ್ಸ್ಕೊಂಡು
ಲಾಸ್ಟ್ ಟೈಮ್ ಇತ್ತು ಅದು.
ಹ್ಮ್.
NOC ವಕಾಲತ್ has been filed, therefore I will seek
ಹ್ಮ್.
weeks time, my lord, I will.
NOC ಒಕ್ಕಲತ್ ಬಂದ್ಮೇಲೆ ನೀವೆಲ್ಲಿ ಸೆಟ್ಲ್ ಮಾಡಿಸ್ತೀರಿ?
ಇಲ್ಲ,
ಹಾ.
ಇಲ್ಲ, sorry. I am sorry, my lord, I am
ಹಾ.
sorry, my lord, I could not.
ಹಾ.
ಅದು ಹೇಳಕ್ಕಾಗೋದಿಲ್ಲ.
ಆಯ್ತ್,
ಸೆಟ್ಲ್
ಮಾಡಿಸ್ತೀರಾ?
ಮಾಡ್ಕೊಂಡ್ರೆ ಪಾರ್ಟೀಸ್
ಮಾಡಿಸ್ತೀರಾ? ಆಯ್ತು.
ಮಾಡಿಸ್ತೀನಿ,
ಯಾವಾಗ
ಟ್ರೈ
ಹೇಳಿ?
ಮಾಡ್ತೀನಿ.
ಯಾವಾಗ ಬೇಕು ಹೇಳಿ? Both councils are present and submits that there is an element of settlement and report the settlement ಅಂತ ಹಾಕಿರ್ತೀನಿ. ಯಾವಾಗ?
Please.
25/6,
Please. Great.
May submit one thing, 107.
ಏನಪ್ಪ ಕೇಳಿ 107. ಹಾ?
ಮಧ್ಯಾಹ್ನ ಸ್ವಲ್ಪ inconvenience. 107.
ಅದರ್ ಸೈಡ್ ಇಂದ ಯಾರು ಬಂದಿಲ್ವಾ?
ಇಲ್ಲ, ಬಂದಿಲ್ಲ.
107 ಅಲ್ಲಿ ನೀವಿಲ್ವಲ್ಲ? ಯಾರ DC ಪ್ರಕಾಶ್ ಅಂತ ಇದೆ?
ನಮ್ಮ colleague ಅವ್ರು.
ಹಾ. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್ ಏನ್ರಿ ಇದು ಡಿಕ್ರಿ?
ಹೌದು, ಎರಡು ಕಡೆಯಲ್ಲಿ ಇಂಜೆಕ್ಷನ್.
ರಿಮೂವ್ ಅಬ್ಸ್ಟ್ರಕ್ಷನ್
ಹೌದು.
ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಪಾತ್ವೇ ಕನ್ಫರ್ಮ್ ಆಗಿದೆಯಲ್ಲ ಇನ್ನೇನು?
ಹೌದು, ಆಗಿದೆ. ಬಟ್ ಅದರಲ್ಲಿ ಡಿಕ್ಲರೇಷನ್ ಕೇಳಿಲ್ಲ ಅಂತ.
ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಯಾವಾಗ್ಲಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್.
Serial number 97.
29/7. ಹಾ ಹೇಳಿ. 97 ಹೇಳಿ ಏನಾಗ್ಬೇಕು? 97.
My lord,
ಹಾ?
for the respondent.
ಹಾ.
Little inconvenience in the afternoon. Next week.
ಡಿಕ್ರೀಡ್ ರಿಡಂಪ್ಷನ್ 3 months ಟೈಮ್ ಕೊಟ್ಟಿದೆ. ಇನ್ನೇನ್ ರಿವರ್ಸ್ ಇದೆ ಏನ್ ಮೇಡಮ್? ಆಯ್ತು, ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ತಾರಂತ. 95 ಹೇಳ್ರಿ ಏನು? ರಾಜೇಶ್ವರ PN ಹೇಳಿ.
ಸ್ವಲ್ಪ
ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಎಲ್ಲರಿಗೂ ಇರುತ್ತೆ. ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇಸ್ ನಾಟ್ ಎ ಗ್ರೌಂಡ್. ಫಸ್ಟ್ ಟೈಮ್ ಇಲ್ಲ, ಸೆಕೆಂಡ್ ಟೈಮ್ ಇಲ್ಲ, ಓದ್ಕೊ ಬಂದಿದೀವಿ ನಾವಲ್ವಾ? ಫಸ್ಟ್ ಟೈಮು, ಸೆಕೆಂಡ್ ಟೈಮು, ಫೈನಲ್ ಅಂತ ಇಲ್ಲ. ಅದಕ್ಕೆ ನೋಡಿ ವಾಲ್ ಪೋಸ್ಟ್ ಹಾಕಿದೀವಿ. ಫಸ್ಟ್ ಗೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಆರ್ ರಿಕ್ವೆಸ್ಟೆಡ್ ನಾಟ್ ಟು ಸೀಕ್ ಫಾರ್ ಎನಿ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ಸ್ ಅಂತ. ಹೌದಾ? How many times court has to read the papers? No ground. Next.
90 R2 died, man. No more.
90 ನೀವೇನ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದೀರಲ್ಲ?
R2 ಗೆ ನಾನು R1 and 2 ಗೆ ನಾನಿದ್ದೇನೆ.
ಹಾ, ಏನಾಗ್ಬೇಕು ಈಗ?
R2 is no more.
R2 is no more. ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್? 90.
ಹೌದು.
ಅದರ್ ಸೈಡ್ ಇದಾರೆ ಲೋಡ್ ಮರಿಯಪ್ಪ. 90 ಲೋಡ್ ಮರಿಯಪ್ಪ ಇದಾರ್ರಿ, ನೀವಲ್ಲ?
Sorry, 91.
ರಾಮ್ ಭಟ್ 91. ಹಾ, ಶಶಿಧರ.
ಹೌದು, ಅವ್ರು ಲಾಸ್ಟ್
ಶಶಿಧರ್ ಇದಾರಾ?
6 ತಿಂಗಳಾಯ್ತು ಅವ್ರದ್ದು.
R2 ರಿಪೋರ್ಟೆಡ್ ಡೆಡ್ ಅಂತ ಮತ್ತೆ ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ಅದು ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಬೇಕಲ್ಲ. ಅವ್ರು ಇರ್ಲಿ, ಅವ್ರ ಆಬ್ಸೆನ್ಸ್ ಇಲ್ಲ ಕೊಡೋದು. ನೀವ್ ಇರೋದ್ ಬೇಡ. ನೀವು ಗಮನ ತಂದಿದ್ದೀರಲ್ಲ,
Serial number
ಅವ್ರು
120.
ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ತಾರೆ.
Some serial number 112.
112 ಏನಾಗ್ಬೇಕ್ರಿ?
PF ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ yesterday. PF yesterday ಕೊಟ್ಟಿದ್ದಾಗಿದೆ.
PF ಇದೆಯಾ ಅದು? 112 PF ಇದೆಯಾ?
ಹೌದು ಸ್ವಾಮಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ನೋಟಿಸ್
ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಇದೆಯಲ್ರಿ?
ಅದೇ ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ
ಆರ್ಡರ್ ಶೀಟ್ ನೋಡೋಣ. ಏನಿಲ್ಲ, ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಇಟ್ಟಿದೆ.
Serial number 122, my lord.
ಏನಾಗ್ಬೇಕು ಹೇಳಿ?
Kindly it may have next
ಇಬ್ರು
week.
ಇದೀರಾ ಫೈನಲ್ ಇಯರಿಂಗ್?
ಹೌದು, final.
ಇಬ್ರು ಇದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ದೀನಿ.
ಮಾಡಿಬಿಟ್ಟು ಮಧ್ಯಾಹ್ನ ಹೇಳಿ.
ಇಲ್ಲ, ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಅವ್ರ ಇಂಟಿಮೇಟ್
ಮಾಡಿದ್ದೀನಿ
ಮಾಡಿದೀರಾ?
ಸ್ವಾಮಿ. ಸಿದ್ಮಲ್ಲಪ್ಪ.
ಸೀರಿಯಲ್ ನಂಬರ್
122, sir.
122. ನೀವ್ ಯಾರಿಗೆ ಅಪಲೆಂಟ್?
ನಾನೇ ಅಪ್ಲೈಂಟ್.
Appellant counsel 6 time and also counsel submits that already intimated counsel for respondent.
93.
Hence list this matter in the first week of August.
Kindly interim order may be extended. Interim order may be extended. Till date ಅಂತ ಇದೆ. Please, madam.
Entry matter ತಗೊಂಡ್ಮೇಲೆ ರೆಡಿ ಇರಬೇಕು. ಮತ್ತೆ
ಮಂಗಳವಾರಕ್ಕೆ ಹಾಕ್ತೀನಿ.
entry matter granted earlier is extended. ಹೇಳ್ರಿ ನಿಮ್ದು ಯಾವ್ದು?
93.
93 ಯಾರು ಹೇಳಿದ್ರಲ್ಲ ನೀವು?
ಮಂಗಳವಾರಕ್ಕೆ ಹಾಕ್ತೀನಿ.
Appellant counsel 6 time and counsel for the respondent also says that they are going to file, they are going to give NOC in the matter. And hence 2 weeks time granted. 2 weeks time granted. List the matter in the first week of August. ಇಷ್ಟನಾ? ಇವತ್ತು ನೀರೇ ಕುಡಿಲಿಲ್ವಾ?
ಕೋರ್ಟ್ ಆಫೀಸರ್
Ready.
ಇದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಲಿಸ್ಟ್?
Not free ಇದೆ.
ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಮಧ್ಯಾಹ್ನ?
ಪಾಸೋವರ್ ಇದೆ.
ಮೇಡಮ್ 117 ಏನಾದ್ರು ಅಡ್ಜಾರ್ನ್ಮೆಂಟ್ ಇದೆಯಾ?
ಕೋರ್ಟ್ ಆಫೀಸರ್ 118 ಏನಾದ್ರು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಆಗಿದೆಯಾ?
ಹಾ
118.
118 ಇದೆ.
ಹಾ ಸರಿ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು
ಮೇಡಮ್.
118 ಸರ್
118.
118 ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಆಗಸ್ಟ್.
ಹೌದಾ ಮೇಡಮ್? ಬೆಳಗ್ಗೆಯಿಂದ ಗೊತ್ತಾಗ್ಲಿ.
108 ನನಗೆ ಐಎ ಪುಟಪ್ ಆಗಿದೆ ಅನ್ಸುತ್ತೆ. ಐಎ 2 ಆಫ್ 24 ಫೈಲ್ ಆಗಿದೆ.
108 ಅಲ್ಲಿ ಯಾವ
ಐಎ 2 ಆಫ್ 24 ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ ಗೆ ಇನ್ನೊಂದು ಇದೆ.
ಪ್ರೊಡಕ್ಷನ್ ಅದಾಗಿಲ್ಲ.
ಅದಾಗಿಲ್ಲ, ಪುಟಪ್ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ.
ಎಷ್ಟು ಕೊಡ್ತೀನಿ
ಮೇಡಮ್ 101 ಅಡ್ಜಾನ್ ಆಗಿದೆಯಾ ಮೇಡಮ್?
ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಆಗಸ್ಟ್
101
101 ಇದೆ.
ಓಕೆ
ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ ಫಸ್ಟ್ ವೀಕ್. 103 ಇದೆ. ಇದೆ 10 ಪಾಸ್ ಓವರ್, 11 ಎಜೆ ಟೇಕ್ ನೋಟಿಸ್ ಅಂತ ಆಗಿದೆ. ಇದೆ 1 week to pay the PF.
ಕೋರ್ಟ್ ಆಫೀಸರ್ 111 111 ಅಡ್ಜರ್ನ್ ಆಗಿದೆಯಾ? 111
ಆಗಿಲ್ಲ.
ಇದೆಯಲ್ಲ?
ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಕ್ರೈಮ್ ಬ್ರಾಂಚ್ ಅದು ಎಜಿಎ ತಾನೇ ಬರುತ್ತೆ. ಕ್ರೈಮ್ ಬ್ರಾಂಚ್ ಬರ್ತಾರೆ ಎಜಿಎ. ಅದೇ ಸಿಬಿಬಿ ಬರುತ್ತೆ ಅಂತ ನನ್ನ ಡೌಟ್. ಬರಲ್ಲ ಉತ್ತರ ಏನ್ ಬೇಕು ಹೇಳಿ
ಮೇಡಮ್? 111 ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ?
ಯಾವುದು?
111
ಇಲ್ಲ
111
ಇಲ್ಲ.
ಆಯ್ತು ಮ್ಯಾಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಹೌದು. ಅದ್ಯಾರ ಬಂದ್ ಕೇಳಿದ್ರಲ್ವಾ, GB ಶರತ್ ಗೌಡ ಅಲ್ವಾ? ಆ ಬುಕ್ಕೇ ಇಲ್ಲಪ್ಪ, ಅಲ್ಲಿದೆ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಇದೆ ಬುಕ್ಕು. ಅದು ಇದದು ಬುಕ್ ಇದೆಯಾ? ಅದ್ರಲ್ಲಿ ಇದೆಯಾ ನಂಬರ್? ಅದ್ರಲ್ಲಿ ಇಲ್ಲ, ಅದಲ್ಲ. ಇನ್ನ 2 ಬುಕ್ ಇದೆ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಇದೆ. ಬೆಳಿಗ್ಗೆ ಫೈಲ್ಸ್ ಕಳಿಸಿದ್ದಾರೆ. ಕಳಿಸಿರೋ ಬುಕ್ ಇದೆ ಹೇಳಿ. This is 35 of 24. This is ಅದಕ್ಕೆ ಬೆಳಿಗ್ಗೆ ತಂದು ಕೊಟ್ಟಿದಾರಲ್ಲ ಹೋಗಿಲ್ಲ ಅಂದ್ರೆ ಕಳಿಸ್ತೀನಿ ಆಯ್ತಾ. ಹೋಗಿದೆ ಮೋಸ್ಟ್ಲಿ ಬೆಳಿಗ್ಗೆ ಎಲ್ಲ. ವೆರಿಫೈ ಇವಾಗ ಹಂಗೆ ಹೇಳ್ತಾರಪ್ಪ ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ ನಾನು ಮಾಡ್ಬೇಕು ಬನ್ನಿ 2 ಕಾಲ್ವಾ ಫೋನ್ ಮಾಡ್ತೀನಿ busy ನೇ ಇಲ್ಲ ಮೇಡಮ್ ಹೌದು ಮೇಡಮ್ ಮೇಡಮ್ ನೀವೇನು PN ರಾಜೇಶ್ವರ 65 ಅಲ್ಲಿ ಹೇಳಿ. ಕೇಳ್ದಂಗಿಲ್ವಲ್ಲ? ಇಲ್ಲ ಕೇಳಿ. ಕೇಳಿ ಯಾರು ಕೇಳಿ.
That I was ready for it. Thank you.
ಹೌದು.
What a document for. Document for. What a document.
ಸಾರಿ, ನೀವು ಸಿಕ್ಕದಲ್ಲ ಅಂತ ಕೇಳ್ತಾರೆ.
ಮೇಡಮ್ ಪಾಸ್ವರ್ಡ್ ಕಡಿತೀರಾ ಫಸ್ಟ್? ಮೇಲ್ಗಡೆ ಎಷ್ಟವೆ? ಮೇಲ್ ಎಷ್ಟಿದ್ದೇವೆ? ಅಲ್ಲ ನಂದು ಪಾಸ್ವರ್ಡ್ 18 ನಂದು ಸೀರಿಯಲ್ ನಂಬರ್ ನಡೆಯಂತವೋ ಏನೋ ಗೊತ್ತಿಲ್ಲ, ನಡೆಯಂತವೋ ಏನೋ ಗೊತ್ತಿಲ್ಲ. ಅಲ್ಲಿ ಕೋರ್ಟಲ್ಲಿ ಒಂದಲ್ಲಿ ಬೇರೆ ಪಾಟಾಡಿದೆ, ಅದಕ್ಕೆ ಇಲ್ಲ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳೋದು ಪಾಟಾಡಿದೆ ಒಂದು ಮುಗಿಸ್ಕೊಂಬತ್ತೀನಿ ಅಂತ ಫಸ್ಟ್ ಹೇಳ್ಬಿಟ್ರೆ ಹೇಳ್ಬೋದು.
ಮೇಡಮ್
ಕಲ್ಲಿದ್ಯಾ?
ಮೇಡಮ್
ಏನ್ ಬೇಕು ಸರ್?
ಕ್ವಶನ್ ತಗೊಂತಾರಲ್ಲ
ಮೆಮೋನಾ? ಮೇಡಮ್ ಇವಾಗ ಸರ್ ಇವಾಗ ಕೊಡಲ್ಲ, ಇವಾಗ ಇಸ್ಕೊಳ್ಳಲ್ಲ. ನಿನ್ನೆ ಯಾವ್ದೋ 8 ಕೊಟ್ಟಿದಾರಂತೆ. 867 ಅಂತ ಕೊಟ್ಟಿರೋದು. ಇನ್ನೊಂದು 70 ಏನೋ ಇತ್ತು, ಡೇಟ್ ಇತ್ತು ಬಂದಿಲ್ಲ. ಇದು ಆ ಕಡೆ ಇತ್ತು. ಡೇಟ್ ಕೊಟ್ಟಿರೋದು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ದೀಪ ಇದೊಂದು ನಾಳೆ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ಬೇಕಂತ ಹೇಳ್ಬೇಕು. ಇನ್ನೊಂದೆರಡು ಫೈಲ್ ಇಟ್ಟಿದ್ದೀನಿ. SN ಅಲ್ಲಿ ಇದನ್ನು ಅಲ್ಲಿ ಇಟ್ಟಿದ್ದೀನಿ SN ಅಂತ. ಸಾಹೇಬ್ರು ಬಂದ್ರೆ ಅದು ಕೊಟ್ಬಿಡಿ ಫೈಲು. ಅದು ಫೈಲ್ ಕೊಡಿ ದೀಪ, ಆ ಫೈಲ್.
Serial number 117. First week serial number 117. 117. ಹೇಳಿ ಏನಪ್ಪ? 2 weeks time. Final year. ಅದರ್ ಸೈಡ್ ಇದಾರ? ಅವ್ರಿಗೆ ಹೇಳಿ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ವಿ. ಸೀನಿಯರ್ ಕನ್ಸ್ 117. ನೀವ್ಯಾರಿಗಿದ್ದೀರಿ? ನೀವು ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್. R5 and R6 council 117. ಗುರುರಾಜ್ ಯಾರು ಅವ್ರಿಗೆ ಹೇಳಿದಿರಾ? Senior counsel for the applicant is also present. List this matter on. First week of August ಕೊಟ್ಬಿಡಿ.
ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಕೋಟಲ್ ಒಂದಲ್ಲಿ ಒಂದು ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟ್ರ್ ಇದೆ. ನಂದು 80 ಇದೆ, ಇನ್ನೂ ಒಂದು 6 ಇದೆ, ಮುಗಿಸ್ಕೊಂಡ್
ಬನ್ನಿ.
ಆಯ್ತಾಯ್ತು. ಅದಕ್ಕೋಸ್ಕರ
98. Paper 2 weeks time in this ಅದೇ ಕ್ರಾಸ್
98.
ಹೌದು ಸರ್, ಕ್ರಾಸ್
ಅಪೀಲ್ ಕ್ರಾಸ್ ಅಪೀಲ್ ಎರಡು ಇದೆ.
ಅದು ಕ್ರಾಸ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಅವರು ನನಗೆ ಲಿಮಿಟೇಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಮತ್ತೆ ಕ್ರಾಸ್ ಅಪೀಲ್ ಮೆಮೋಸ್ ಕೊಟ್ಟಿಲ್ಲ, ಕೇಳಿದ್ರು ಕೊಡ್ತಾರೆ.
ನೀವು
ನಾನು ಅಪಲೆಂಟ್ ಫಸ್ಟ್.
ನೀವು ಅಪಲೆಂಟ್ ಗೆ?
ಹೌದು ಸರ್.
ಅದರ್ ಸೈಡ್ ಯಾರು?
ಅದರ್ ಸೈಡ್ ಕ್ರಾಸ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಅವರು.
ಅವ್ರು ಏನ್ ಮಾಡ್ಬೇಕು? ನಿಮ್ಗೆ ಕೊಟ್ಟಿಲ್ವ ಕಾಪೀಸ್?
ಕೊಡ್ಲಿಲ್ಲ ಸರ್. ಮತ್ತೆ
ಏನ
ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡ್ಬೇಕು. 900 ಅಂತ
ಬೈರೇಗೌಡ ಇದಾರ?
936 days ಡಿಲೇ ಇದೆ ಕ್ರಾಸ್ ಅಪೀಲ್. ಟು ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಟು ದಿ
791 days ರೀ.
ಹೌದು ಸರ್.
ಮುರಳಿ ಬಾಬು ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತ ಇದೆಯಲ್ಲ ನಿಮ್ಗೆ?
ಅದು ಒಂದು ತರ್ಸಿ ಆಗ್ತಿದೆ ಸರ್.
ಅವ್ರು ಬರ್ಲಿ ನೋಡೋಣ, ಆಮೇಲೆ ನೋಡೋಣ, ಕೊಡೋಣ, ಕೊಡ್ಸೋಣ. ನಿಮ್ಗೆ ಏನೋ ಕೊಡ್ಬೇಕು, ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರಲ್ಲ, ಅದು ಕೊಡ್ಸೋಣ ಇರಿ. ಪಾಸ್ ಅವರಿಂದ ಬಂದ್ಬಿಡಿ.
ಪಾಸ್ಟರ್ ಮ್ಯಾಟರ್ ಸಿಲ್ವರ್ 5 ರಾಘವೇಂದ್ರ ಕಟ್ಟಿ
ಕಂಪ್ಲೈ ಮಾಡಿದ್ವಿ.
ಫೈಯಾ? ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್. ಏನ್ ಬೇಕಲ್ಲ? Office objection is complied. ಈಗೇನ್ ರಿಕಾಲ್ ಹಿಂಗೆ ಏನ್ ಕೊಡಿಯೋದು ನೋಡೋಣ. ಎಷ್ಟ್ ಸರಿ ಲಿಸ್ಟ್ ಆಗಿತ್ರಿ? ಇದೇನು ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಅಂತ ಮಾಡಿದ್ವಾ? The council submits that he has complied with office objections in view of direction given by this court to comply the same pending consideration of the IA and in view of compliance and also for the reasons stated in the accompanying application and affidavit, IA 1 of 2019 is allowed and order dated 8/11/2019 is recalled and restored the appeal. Post the matter for admission.
10.
Okay, apparently this matter. 2 days time may be granted. 2 days time may be granted, but to issue,
ಏನಕ್ಕೆ ಇದು?
to take steps to
ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಅಂತ ಇದು?
ಗವರ್ಮೆಂಟ್ ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು R3ಗೆ. ಇನ್ ಟೈಮ್ PF ಕೊಡ್ಬೇಕು.
2 days time.
Council 6, AGA 6, 2 days time and if we have paid, issue notice to R3.
26. 26 Shobit.
26 Shobit and Shetty. ಏನ್ರಿ ಇದು?
ಅದೇ ಡೆಫಿಸಿಟ್ ಕೋರ್ಟ್ ಫೀ ಅಂತ. ಡೆಫಿಸಿಟ್ ಕೋರ್ಟ್ ಫೀ ಅಂತ. Office objection is I have to pay.
ಹೌದು. Violation slip trial court ಹಾಕಿಲ್ವಾ? Trial court violation slip ಹಾಕಿಲ್ಲ.
Trial court ಅಲ್ಲಿ they have paid only 25 rupees.
25 rupees?
25 rupees.
Trial court ಅಲ್ಲ?
Yes. While filing the.
Oh, that there is an order in judicial side.
Yes, my lord.
ಹೌದಲ್ಲ?
Lordship.
ಅದೇ ಹೇಳಿದ್ರಲ್ಲ ಮೇಡಮ್.
There are 23, 24, 25, 26.
ಇದರಲ್ಲಿ ಫೈಂಡಿಂಗ್ ಇದೆಯಲ್ಲ ಮೇಡಮ್, that's what he brought to my notice. Court has directed to pay the amount of rupees 20,000 and order.
Yes, my lord. Page number 30, 31.
ಅಷ್ಟೇ. ಜುಡಿಷಿಯಲ್ ಸೈಡ್ ಡೈರೆಕ್ಷನ್ ಇದೆ, ಪೇ ದಿ ಕೋರ್ಟ್ ಫೀ ಆಫ್ ರೂಪೀಸ್ ಅಲ್ವಾ? ಯಾವ್ದು ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ?
Page number 30.
30
of the appeal.
court order.
ಹೌದು, appellate court order. Paragraph 24 and 25 and 26.
ಇದೆಯಲ್ಲ ಮೇಡಮ್, ಪ್ಯಾರಾಗ್ರಾಫ್ 25.
ಅದರಲ್ಲಿ suit of possession of the properties ordered in favor of the plaintiff.
The council submits that the appellate court decided with regard to the court fee is concerned at paragraph number 25 and 26.
ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
And accordingly, an amount of rupees 20,895 is paid. Even observation is made with regard to the non-payment of court fee before the trial court, and the same is also made good in terms of the order passed by the appellate court. And the challenge is by the defendant. And hence the amount of rupees 20,895 is paid.
Yes.
And hence office objection regarding court fee is overruled. Nishal madam, Hashel ididu?
Yes, my lord. For admission it.
Overruled. Post the matter for admission.
We end of this month, my lord.
21, end of this month. List this matter end of this month.
36.
ಅದೊಂದೇನು ಇದ್ದಿದ್ದು office objection?
ಬಾಕಿದೆಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ. Cost also paid.
36.
36 VB Shivkumar. ಆಯ್ತಾ ಮೇಡಮ್, ಕಟ್ಟಿದ್ರಾ?
Cost is being paid, my lords.
Cost, council submits that cost is paid. ಆಮೇಲೆ
We'll
complaints.
consider office objections, my lords. Kindly grant one short accommodation.
And again 6 time and hence on further cost of rupees 500, another 2 weeks time granted. If cost not, further cost not paid and not complied, appeal is dismissed without reference to the bench.
39. Vedukumar Vice.
39, ಹೇಳ್ರಿ ವೇದಕುಮಾರ್ ವೈಎಸ್ ಏನಿದು?
Cost paid, my lord.
Cost paid, complaints?
Complaints, my lord.
Complaints, same order madam. 5th time of further cost of rupees 500, 2 weeks time granted. If not paid and not complied, appeal is dismissed without reference to the bench.
80 ಅವರೇನೋ ಬರ್ತೀನಿ ಅಂತ. Next 80.
80 ಏನೋ ಹೋದ್ರಲ್ಲ ಅವ್ರ?
82.
80 again pass over. ಅಭಿನವ್ 80 ಇದಾರ? 80 ನಲ್ಲಿ ಇಲ್ಲಲ್ಲ? ಸರಿ ಆಯ್ತು. ಈಗ ಯಾವ್ದು next?
82.
82.
Sir, Anantakrishna.
Appellant. Lord, these two appeals are connected by different judgments, not by a common judgment.
Common
but
judgment
between the same common judgment alla actually. But ಯಾಕೆ ಕನೆಕ್ಟ್ ಆಗಿದೆ ಅಂದ್ರೆ between the same family members. ಹಾಗಾಗಿ same property Property is also same.
Same.
First appeal nalli, what we have challenged is dismissal of the suit which was filed by one of the brothers of the defendant for recovery of rent. And the honorable trial court, my lord, has dismissed the suit on the ground that the relationship between them is not as that of landlord and tenant, but as co-owners. And therefore, he is not a tenant.
So they are co-owners.
Co-owners ಅಂತ ಹೇಳಿ. ಆಮೇಲೆ so far as the second appeal is against the judgment.
That is also confirmed by the first appellate court?
Yes, my lord.
Concurrent
findings.
In first appeal?
First appeal.
What about in second appeal?
In second appeal, my lord, the honorable trial court has granted injunction in favor of the brother of the appellant. Though it is admitted fact that they are co-owners in respect of the same scheduled property. Permanent prohibitory injunction grant ಮಾಡಿದ್ದಾರೆ in favor of one co-owner against another co-owner. So that goes against the law settled so far as the property in respect of which all the brothers have
Right.
yes, my lord. So
They cannot maintain a suit for injunction for against the co-owner.
co-owner. So ಇಲ್ಲಿ the
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಾ? ಬಂದಿದೆ. ಟೇಲರ್ ಅವರು HR ಮುಗಿಸ್ಬೋದಲ್ಲ ಇಲ್ಲೇನೆ. ಅವ್ರಿದ್ರೆ ಅದರ್ ಸೈಡ್ ಇದ್ರೆ ಇಲ್ಲೇ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದು. Why we have to keep this matter 2014 ಒಂದು 2018
ಹೌದು ಹೌದು.
ಬಟ್ ಫಸ್ಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಹೆಂಗೆ ನಿಮ್ ಗ್ರೌಂಡ್ಸ್ ಏನಿದೆ?
ಗ್ರೌಂಡ್ಸ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ರಿಲೇಷನ್
the two grounds
ಪಾರ್ಟೀಸ್ ಆರ್ co-owners.
co-owners ಒಂದು ಹಂತ ತನಕ ಇದ್ರು ಸ್ವಾಮಿ ಅಷ್ಟೇ. ಏನಾಯ್ತು ಇಲ್ಲಿ ಅಂದ್ರೆ 1963 ಅಲ್ಲಿ there was a release deed executed and registered.
ಅವ್ರು ಬಂದ್ರೆ ಡಿಸ್ಕಸ್ ಮಾಡೋಣ.
ಆಗ್ಬೋದು ಸ್ವಾಮಿ.
ಪಾಸ್ ಓವರ್ ಆಗ್ಬೋದಲ್ಲ? ಪಾಸ್ ಓವರ್. HR ಅನಂತ ಕೃಷ್ಣ ಮೂರ್ತಿ ಇಲ್ಬೋದು. 83 KS ಹರೀಶ್ ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತಾ?
suit for partition declaration injunction.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಕನ್ಫರ್ಮ್ ಆಗಿದೆ.
ಇಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಕನ್ಫರ್ಮ್ ಆಗಿದೆ. ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್. ಏನ್ ರೀಸನ್ ಏನ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್?
But in spite of giving a finding, Lord, that partial partition is maintainable, Lord, at the instance of defend number 9, respond number 9, the first appellate court would still go ahead and say that suit would not be maintainable. Maintainability on the ground of partial partition, there is no issue framed. Defend number 9 is the only contesting defendant because no other persons have filed any written statement. But the suit, Lord, for the facts, Lord, for a moment, that plaintiff for the plaintiff.
What is his defense? Other properties are also there antana?
Other properties are also there anta.
Details ಕೊಟ್ಟಿದಾರಾ? Other properties are also there.
Not fully though, but not other parties. Other properties are already subject matter of partition earlier, much earlier. That is admitted position. Not there is no prejudice cost. Not as far as this suit is concerned. This defend number, contesting defend number 9, who is not a family member, contesting defend number 9 is concerned. Not that is the only property. That is all that there is.
But he is the purchaser?
He is the purchaser. From GPA is executed and thereafter he has purchased the property from by way of this GPA and sale deed executed.
Family property ತೋರ್ಸಕ್ಕೆ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾನೆ? Other family properties ಇದೆ ಅಂತ. You cannot seek for the relief of partition only in respect of property which was
yes
sold.
yes he has placed RTCs.
ಮತ್ತೆ
ಅಷ್ಟೇ ಬೇರೆ ಏನಿಲ್ಲ. May I request not to come to
name of family members.
ಇಲ್ಲ page 28 not first appellate court's order judgment para 19. It is also not.
You cannot restrict the prayer.
Yes.
Only in respect of the property.
But the other properties are already subject matter of earlier partition. That is the finding.
Partition ಆಗಿದೆಯಾ?
ಹೌದು there is finding.
Earlier partition only property which was sold.
Yes.
Is not the ಇದು
partition ಆಗೋಗಿದೆ. It is not subject matter of this suit. Partition ಮುಂಚೆನೆ it has taken place much earlier. I'll not may I take not to para 19 2000 ಅಲ್ಲೇ ಆಗೋಯ್ತು. para 19 at page 28. On the background of aforesaid rival submissions made by both parties on perusal of entire pleadings, oral and documentary evidence placed by both parties in respect of relation between the plaintiffs and defendants 1 to 4, though defendant number 9 purchaser in his written statement has denied the relationship of plaintiffs, but during the course of evidence he has not disputed relation between plaintiff and D1 to D8. It is also not disputed that the suit schedule properties are self-acquired properties of Karichikke Gowda, who is the father of plaintiffs and defendants, and he died intestate on 8/10/2002. Admittedly, during the lifetime of their father, there was no partition in their joint family property, when it is not disputed that the suit properties were self-acquired properties of the father of plaintiff and defendants, and their father died intestate, all the children of late Karichikoda succeeded the same. This is insofar as property 1 and 2 is concerned.
Two scheduled properties concerned.
Yes. Then Lord, next paragraph. But according to plaintiffs, though there was no partition in their joint family, the defendants 1 to 4 have alienated suit scheduled properties in favor of D9 in order to deprive the right. On the other hand, though defendants 1 to 8 are joint family members, appeared before trial court, but they have not filed the written statement and contested suit. The defendant 9, who is the purchaser, filed his written statement and contested suit, but his written statement he has not taken specific defense, as there was already a partition among joint family plaintiffs and defendants 1 to 8. But during the course of cross-examination of PW1, the learned counsel for D9 has suggested to the effect that as there was a partition in their joint family on 8/11/2004, and during the said partition, item number 1 had fallen to share of D4. But there is no pleadings by D9 to that effect. Since there is no pleading, no issue has been raised about the factum of partition. In spite of that, the learned trial judge has mainly placed reliance upon admission made by PW1 during the course of cross-examination, as there was partition on 8/11/2004, and wrongly come to the conclusion.
Whether he has admitted the earlier partition, PW1?
Yes, my lord.
Admitted?
Yes, my lord. That is what is recorded here in para 20 also. I'll read again. The learned trial judge has mainly placed reliance upon an admission made by PW1 during the course of cross-examination, as there was partition on 8/11/2004, and wrongly come to the conclusion that as there was already a partition in the joint family of plaintiffs and defendants, the plaintiffs cannot maintain the suit for partition. When there is no specific pleading, any amount of oral evidence about factum of partition cannot be considered. Moreover, there is no further pleadings or evidence whether the plaintiffs were also parties to the said partition, whether any other joint family properties were allotted to the share of the plaintiffs or not. In the absence of these specific pleadings, oral and documentary evidence solely based on stray suggestion to PW1, it cannot come to the conclusion that there was already a partition in their joint family. Hence, the so-called admission made by PW1 is nothing which cannot be.
Nothing but a stray sentence.
Yes. But learned trial judge wrongly considered this stray sentence as an admission. Therefore, finding on this point is contrary to law, and the same is not sustainable under law. So, my lord, on this point, the finding of the trial court is set aside. But nevertheless, my lord, the learned appellate court would hold that the suit is. I'll read further, my lord. However, if it is considered entire pleadings, oral and documentary evidence placed by plaintiff as rightly submitted by the learned counsel for defendants, the plaintiffs have not approached the court with clean hands. The 9th defendant in his amended written statement has taken a specific plea that though there are several properties available to joint family plaintiffs, defendants 1 to 8, but the plaintiffs have not included. Accordingly, the suit for partition only in respect of alienated property itself is not maintainable. No doubt, as submitted by learned counsel for plaintiffs, no issue has been raised on this point also by the learned trial judge. It appears that this defense was inserted by the defendant in his written statement after filing written statement by way of amendment. Accordingly, it appears that by oversight, no issue has been raised on this particular defense. But in his written statement, para 11A, this defendant 9 has specifically explained what are the properties available to the joint family of plaintiffs and defendants 1 to 8. In spite of that, the plaintiffs have not included those properties. Initially, these plaintiffs had filed the suit only in respect of item number 1, which was alienated in favor of D9. After filing written statement, the plaintiffs have also got amended the plain schedule and added item number 2. Though an issue on this point was not raised, but both the parties have understood the pleadings and adduced the evidence on this specific plea also. Moreover, in addition to his oral evidence, the D9 has also produced RTC extracts exhibit D3, 5, 12, and 22. Even during the course of cross-examination of PW1, when a suggestion was made to that effect, but PW1 has pleaded ignorance about all these properties available to their joint family. Under these circumstances, the trial judge has relied upon the ruling of a judgment in so and so that the suit for partial partition is not maintainable. It is not the case of plaintiffs that they are not aware about the remaining properties available to their joint family. When D9 himself furnished the particulars of the properties available to their joint family, there was no impediment for the plaintiffs to include all those properties seeking partition. In spite of that, the reasons best known to the plaintiff, they have not included all joint family properties seeking partition. Knowingly and intentionally, when all the joint family properties were not included, suit itself is not maintainable for partial partition. Initially, the plaintiffs had filed the suit only in respect of item number 1, which was alienated by the defendants 1 to 4 in favor of D9. On subsequent date, though the plaintiffs have added item number 2 by way of amendment, but not included all the joint family properties. The plaintiffs have also denied the particulars of properties furnished by defendant number 9 are not belonging to their joint family. It is also a well settled principle.
Yes, counsel, what is the error in the order?
That is what is not. when there is a denial in relation to, my lord, all the properties being belonging to joint family, the entire joint family, my lord, and there is no issue, my lord, what could I have, my lord, pleaded or led as evidence is the question. My lord, that question, there is no issue framed by the learned judge of the trial court. My lord, only, my lord, one pleading, one stray sentence, I would say, in the additional written statement, that too, not in the original written statement, that there are other properties. Lord, and there is no positive evidence led by D9.
No, counsel, documents are produced and referred, the exhibit D series also.
Yes, my lord, but they are
It is
not.
not a say sentence.
Lord, that is what. Lord, kindly see, my lord, the further
Exhibits are also marked by the defendant number 9.
Kindly see, my lord, further.
Why you have not included property D3, D5, D12,
They are not with the family anymore. They are not with the family anymore.
But you have not suggested to the witness.
Lord, that
You have not denied the same.
but in the evidence that is suggested, my lord, that is what is there. In the evidence, that is why, my lord, there are two contrary findings, one of the trial court, one of the.
He has pleaded ignorance, not a PW1. That's what the court observes. Even during the course of cross-examination of PW1, when suggestion was made to that effect regarding documents, exhibit D3, D5, D12, and 22, he pleaded ignorance about all these properties available to the joint family.
Pleadings,
that no such
blood
property
evidence,
available to the
evidence of
family.
PW1, blood exhibit D2, D3 is marked in the course of blood witness evidence of DW1. It could not have been not pleaded ignorance by the plaintiff in PW1. PW1 pleaded ignorance, and it could not have been pleaded by way of ignorance when the document is not at mark.
Mark agidilri, exhibit D3, D5,
marked in the course of examination of DW1. But ಅದಕ್ಕೆ ಮುಂಚೆ
ಚೀಫ್ ಅಲ್ಲ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ತಂದು ಹಾಕಿದ್ಮೇಲೆ ಇಂತ ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ನಿಮ್ಗೆ ಇದೆ ಅಂತಂದ್ರೆ ನೀವು ಕ್ಲಾಸ್ ಅಲ್ಲಿ ಕೇಳ್ಬೇಕಲ್ಲ.
This finding that PW1 pleaded ignorance could not have been correct. PW1
ಏನ್ ಹೇಳಿದಾರೆ ರಿಪ್ಲೈ ನೀವು?
ರಿಪ್ಲೈ PW1 there is no reply.
ಆಯ್ತ್ರಿ, ಕ್ರಾಸ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದಿರಿ ಅಂತ ಕೇಳಿದೆ ನಾನು.
I'll DW1 cross. DW1 deposition.
ಏನಾರು ಆನ್ಸರ್ ಎಲಿಸಿಟೇಟ್ ಮಾಡಿಸ್ಕೊಂಡಿದೀರಾ? ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಮ್ ಫ್ಯಾಮಿಲಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದಲ್ಲ, ಈ ಆಸ್ತಿ ನಮ್ದೇ ಅಲ್ಲ ಅಂತ ಏನಾದ್ರು ಆನ್ಸರ್ ಇದೆಯಾ?
DW1.
When he comes with pleading and also places the document before the court, because you all have joined together and not filed any written statement also, others, it shows that it is a collusive suit only to.
But that finding is not there.
Executed by D1, D4.
Yes, my lord. My lord is right. If that finding was there that this is a collusive suit, I don't have a case. But there's no such finding also, no such case set up also.
Documents produce ಮಾಡಿದ್ಮೇಲೆ ಏನಿದೆ ರೀ, ನೀವೇನ್ ಮಾಡ್ಬೇಕು ಅದನ್ನ? ಕ್ಲಾಸ್ ಅಲ್ಲಿ ಕೇಳ್ಬೇಕು. These properties are not belongs to our family ಅಂತ ಕೇಳಿ ಆನ್ಸರ್ ಎಲಿಸಿಟ್ ಮಾಡಿಸಿದೀರಾ?
I'll just.
He comes with documents.
But may I submit now with respect to DW1's deposition.
Even trial court judgment allo nodi, you have admitted 18 to test the veracity of DW1, the counsel appearing for the plaintiffs has cross-examined him in brief. In the cross-examination, DW has admitted that social properties are the ancestral properties of defendant number 4. It is also admitted that plaintiffs are the older sister of the defendant number 4. Therefore, there is no necessity to discuss with much on so and so. Anta madidare. Ellide ನಿಮ್ಮ admission, so. And he relies upon some documents saying that these are the properties are belongs to the family.
But with respect to DW1's deposition, I'll submit. And I'll handicap with DW1's deposition. Lord, may I just request for a short pass, or I'll see if it is available online and make it. DW deposition.
Then pass over madಬೇಕಾ?
If it is available online, I'll just
no check mad.
90. Lord Mariappa.
Better paper appellant, my lord.
This counsel ಹೇಳಿ.
The respondent number 1 and 2, the plaintiff has filed the suit for declaration and permanent injunction in respect of the 2 items, my lord. Only in respect of the item number 2 concern this appellant is regarding item number I have no grievance, my lord. Before the court below, the suit is dismissed, man. However, in the court below, I am not myself the defendant. This defendant, there's appellant is placed ex parte and that's not contested, my lord. Thereafter, in the appeal, my lord, I filed the wakalat and also filed the application order 41 rules 27 and also filed the written argument, my lord. That my application 4127 application not at all looked into and not at all passed any order. And in that absent, my lord, the lower appellate court, my lord, the honorable.
Record ಅಲ್ಲಿ ಇದೆಯಾ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್
ಇದೆ ಸ್ವಾಮಿ ಐಎ ನಂಬರ್ 3 ಇದೆ ಸ್ವಾಮಿ ಇದೆ
ಐಎ ನಂಬರ್ 3
ಇದೆ ಐಎ ನಂಬರ್ 2 ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಐಎ ನಂಬರ್ 3 ಹಾಗೆ ಇದೆ ಸ್ವಾಮಿ have the
Order 41 rule 27 consider ಮಾಡಿದಾರಾ ಇಲ್ಲ?
Well, I'm not getting any reference in the judgment, my lord, but what is required is, and the application, in the application, what he has submitted is 2 sale deeds, the acquisition of property by him and another sale deed executed by, only because of that.
Whatever it may be, counsel, when the application is filed under order 41 rule 27 seeking
Records may be called for.
court to produce the documents.
Yeah.
Additional documents.
That's why I filed the application
take
here,
a
my lord.
decision on that. Whether those documents are.
I am not
looked into, my lord.
ಗೊತ್ತಿಲ್ವಾ?
Records call for money.
ಮಾಡ್ಬೇಕು ಅಷ್ಟೇನೆ. ಅಯ್ಯೇ ಇದ್ರೆ ನೀವು ಕಾಪಿ ಏನಾರು ಹಾಕಿದಿರ ಆರ್ಡರ್ ಶೀಟ್ ಕಾಪಿ?
Order sheet copy ಇದೆ ಸ್ವಾಮಿ ಸಾರಿ my lord because of some little other work
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನಾರು ರೆಫರೆನ್ಸ್ ಇದ್ರೆ ಆರ್ಡರ್ 41
ಇದೆ ಸ್ವಾಮಿ ನನ್ನ ಹತ್ರ ಇದೆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಇದೆ
41 rule 27 ಹಾಕಿದಿರಿ ಅಂತ
ಇದೆ ಸ್ವಾಮಿ
ಇದೆಯಾ?
ಇದೆ ಸ್ವಾಮಿ ನನ್ನ ಹತ್ರ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಆರ್ಡರ್ ಶೀಟ್ ಇದೆ
ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮತ್ತೆ ನೋಡೋಣ ನೋಡಿ ನೀವು ಅಷ್ಟೊಳಗೆ ವೆರಿಫೈ ಮಾಡಿ ಹಾಕಿದಾರಾ ಇಲ್ಲ ಅಂತ. Then if it is not considered, then remand.
No, I mean, one submission on that issue, that documents produced by him is that 2 sale deeds and a revenue RTC. That 2, because of that sale has taken place, they were implemented as a parties to the proceedings, and they were placed ex parte also. They have not contested the issue. And a real issue is whether I have got a title to the property prior to the acquisition of property by them. And the court held I have got a title and therefore suit is decreed. The sale is immaterial to that extent, my lord. Because they purchased a property from the other defense 1 and 2 who contested the suit. Not if it is going to really affect.
Call for records, reversal ಇದೆ, call for records. This matter in the second week of August. Node, we'll see.
What's up?
91.
ಇವ್ರೇನೋ ಒಂದು ಹೇಳಿ ಇದ್ರಲ್ಲಿ counsel for R2 brought to notice of this court, R2 is no more, and hence appellant counsel is directed to bring the LRs of R2 within 2 weeks. This matter on 29/7.
92, Umesh BN.
Umesh BN. Venkatesh.
Yes, there is one more
Dismissed,
connected matter.
reversed.
There is one more connected matter arising out of the same.
ಯಾವ್ದದು?
1759 of 2018.
59
2018.
59.
1759.
The appellant counsel submits that the RSA 1759 of 18 is also arising out of the same judgment, and hence list the same along with this appeal. In the end of August, in the end of July.
93, 94 adjourn, 95, Rajeshwara PM.
ಅಲ್ಲ ಮೈ ಸೀನಿಯರ್ ಸ್ವಲ್ಪ ವೈರಲ್ ಫೀವರ್ ಆಯ್ತು ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕೊಳಕ್ ಹೇಳಿದ್ರು. ಸಾರಿ ಮರ ಇದು ಕೂತ್ಕೊಂಡು ಓದ್ತಾ ಇದ್ರು ಅವ್ರು ಜ್ವರ ಜಾಸ್ತಿ ಆಯ್ತು ಹಾಗಾಗಿ ರಾಜೇಶ್ವರ್.
ನೀವು ಬರ್ಸಿದ್ರ ಜ್ವರ ಅಂದೆ?
ಅಲ್ಲ ಹಾಗಾಗಿ ಒಂದು 3 days ಮೇಲೆ.
Appellant counsel 6 time list this matter in the first week of August.
Please.
96, Sudhindra BS.
Is plaintiff's second appeal, your lordship. And the appellant is challenge the modification of the order passed by the appellate court in RA number 2015 dated.
Why they have amended it? Why modified it?
Initially in partitions in OS number kindly perused at page number 74, your lordship.
Reason for modification and
Also
1150th share ಕೊಟ್ಟಿದ್ರು.
1150 share ಅದನ್ನ RA ನಲ್ಲಿ
A schedule property ಗೆ in item 1 to 5 in B schedule ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು. ಆಮೇಲೆ ಅದನ್ನ RA ನಲ್ಲಿ 9/32 ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಅದನ್ನೇ
RA ನಲ್ಲಿ
9/32 ಮಾಡಿದ್ದಾರೆ.
32 ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
ದಟ್ ಇಸ್ ಸೇಮ್ ಅದು ಲಿಮಿಟೆಡ್ ಇದು ಮಾತ್ರ ಚೇಂಜ್ ಮಾಡ್ತಾರೆ.
ರೀಸನ್ ಫಾರ್ ಮಾಡಿಫಿಕೇಶನ್ ಅಂತ ಕೇಳ್ತಾ ಇದೆ.
ಹಾ ಅದು ಸ್ವಾಮಿ.
According to you, apportionment passed by the trial court is correct? 1158 share correct?
Totally 50 acres your lordship. ಅದರಲ್ಲಿ 11 acres per member ಅಂತ ಇದು ಮಾಡಿ ಅಲಾಟ್ಮೆಂಟ್ ಆಗಿರೋದು.
Acres ಎಷ್ಟಾರಲ್ಲಿ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
Totally 5 members your lordship.
Appeal filed by defendants?
Yes your lordship.
1158 share ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿರೋದು ಸರಿ ಇಲ್ಲ ಅಲ್ವಾ?
ಅದು ಸರಿ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಸರಿ ಇಲ್ಲ. ಆ ಥರ ಮಾಡ್ಲಿಕ್ಕೂ ಬರೋದಿಲ್ಲ. ಅದನ್ನು ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಅದನ್ನು ಮಾಡಿ
ಯಾರ ಮಕ್ಕಳವರು?
ಮೋಟೇಗೌಡ.
ಅವ್ನಿಗೆ ಎಷ್ಟು ಜನ ಮಕ್ಕಳಿದ್ರು?
Totally 4 childrens.
Then why this arrival of 1158 share and 9/32?
1150 and the calculation totally 50 acres
Property and nature of the property.
agricultural land, coffee play ಇದು ಎಲ್ಲ ಇದೆ ಸ್ವಾಮಿ.
Ancestral property na ಅಥವಾ self acquired?
Ancestral property of the ಮೋಟೇಗೌಡ, late ಮೋಟೇಗೌಡ.
ಮೋಟೇಗೌಡ ಇಲ್ಲ ಇದಾರೆ. ಮೋಟೇಗೌಡ 4 ಜನ ಮಕ್ಕಳು.
ಹೌದು ಸ್ವಾಮಿ. ಅದ್ರಲ್ಲಿ ಇಬ್ರು ಹೆಂಡ್ತಿದಿರು.
ಇಬ್ರು ಹೆಂಡ್ರ?
ಫಸ್ಟ್ ವೈಫ್ ಇಸ್ ಯಶೋದಮ್ಮ, ಸೆಕೆಂಡ್
ಯಶೋದಮ್ಮ.
ಧರ್ಮಾವತಮ್ಮ ಇಸ್ ಸೆಕೆಂಡ್ ವೈಫ್.
ಯಾರು?
ಧರ್ಮಾವತಮ್ಮ. The defendant number 2, the respondent number 2 in this case.
The issue notice. Only issue is only with regard to the
Yes, your lordship.
apportionment.
House.
And call for records. ಇದಾರ ನೋಟಿಸ್ ಇರ್ಬೇಕಲ್ಲ, ಆಲ್ರೆಡಿ ಇದಾರೆ ಅನ್ಸುತ್ತಲ್ಲ
ಸ್ವಾಮಿ. ನೋಟಿಸ್ ಆಗಿದೆ,
ಸರ್ವ್ ಆಗಿದೆ. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಹಾಕೋಕಾಗಾರೆ ಅಲ್ವಾ?
ಆಮೇಲೆ ಅದರಲ್ಲಿ
ಇಬ್ರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿದೆ. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಅಷ್ಟೇ
ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಅವರು RSA ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಅವ್ರದೊಂದು RSA
2105 of 16. 2105 of 2016. ಹೌದು ಸ್ವಾಮಿ. ಬಟ್ ಇದುವರೆಗೂ ಅವ್ರು ಯಾವ್ದ್ರಲ್ಲೂ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
The appellant counsel submits that another RSA 2105 of 16 is also pending arising out of the same judgment.
ಹೌದು ಸ್ವಾಮಿ.
ಮತ್ ನೀವ್ ಯಾಕೆ 19 ಅಲ್ಲಿ ಹಾಕಿದ್ರಿ? ಡಿಲೇ ಇರ್ಲಿಲ್ವಾ?
ಡಿಲೇ ಕಂಡೋನ್ ಆಯ್ತು.
ಆಗಿದೆಯಾ?
ಡಿಲೇ ಕಂಡೋನ್ ಆಯ್ತು ಡ್ಯೂರಿಂಗ್ ಕೋವಿಡ್ ಪೀರಿಯಡ್.
Registry is directed to put up the same along with this appeal. Seniority ನಮಗೆ ಬರುತ್ತೇನಲ್ಲ 16 ಗೂ.
97.
Much obliged.
ಹರಿಪ್ರಸಾದ್ ಎಂಬಿ. ಶ್ರೀನಿವಾಸ್ ಜಿ.
Redemption suit 3 months reversed.
Only one submission. I have applied for the certified copies. Depositions of PW and DW and I have not issued. In week's time, my lad, without fail, next time I'll make my submission. Like even exhibit P1 also not visible. I have read the document. Yesterday I have read the document. P1, exhibit P1 not able to read, my lad.
2019 matter.
Recently, in the month of January, I have filed. I'm sorry.
Respondent counsel 6 times. Finally, 2 weeks time granted.
Please.
This matter in the end of July.
Please. Great.
98.
ಇದೆಯಾ? ಇನ್ನೂ ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ? ಯಾರೇನ ಕೇಳ್ತಾ ಇದ್ರಲ್ಲ ಅವಾಗೇನ?
Back to appear for
the copies. Now I received the copies from
Copies?
ಅದೇ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್.
Cross objections.
ಹೌದು.
ಇವಾಗ ಕೊಟ್ರಾ?
ಕೊಟ್ರಿ
ಅವಾಗೆ ಕೊಟ್ಟಿ.
ಅಲ್ಲ ಈಗ ಜಸ್ಟ್ ಕೊಟ್ಟಿ.
Copy malad anyway malad.
Earlier
He complained malad, he has not yet received the copy, therefore malad we gave one more copy.
ಕ್ರಾಪ್ ಕಾಪಿನ ಯಾವ್ದು ಕೊಟ್ರಾ? ಕ್ರಾಪ್ದು.
Malad for 2 weeks time to malad file
Counsel appearing for the appellant to submit that now he has received the copy of crop 2 of 22 on 6 time and hence this
2 weeks.
matter in the first.
May I make one submission malad?
ಹೇಳಿ.
Other day malad they misled the court and obtained an interim order malad. Now they made a submission that malad they are constructing a couchshed in the item number 3 of the property malad. But actually malad is the commercial purpose they are putting up the construction. Malad kindly see malad that
sold ಮಾಡಿದ್ರು.
and also malad during the month of March they have sold one more property malad. And the matter was pending.
This is wrong submission. Photographs produced by the malad, the respondents here and malad, they belongs to some other malad, the village map of the property. Malad I have produced malad,
ಇಸ್ಕೊಳ್ಳಿ ಮೇಡಮ್ ಅವ್ರದ್ದು.
not belongs to the suitable property.
Couchshed.
81/1 concession ಆಗ್ತದೆ. Item number 6. This is not my property. This is not property. Malad, where I have putting the
Page number 18 malad, there are already a couchshed, existing couchshed.
Page number 16.
Kindly turn to page 16 malad. Now the present, my lord, where he is putting up construction in item number 3 of the suitable property. Six.
ಅಲ್ಲ ಮಾಡಿದಾರಲ್ಲ ಅವ್ರೇನೋ ಇವನ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ರು
ಅಲ್ಲ, ಹೌದು.
ಟೈಮ್ ಏನೇ ಈಕ್ವಿಟಿ ಅಂತ ಹೇಳ್ದಂಗೆ
ಹೇಳಿದಾರೆ. But also, my lord, kindly see, my lord, that passage he has put to the doors. My lord, even it is difficult to move, my lord, even for a person. How could they, my lord, the cattle can pass on, my lord? Kindly see, my lord. Is it only for commercial purpose, my lord, they are putting up this?
Last schedule.
Not I'll concept the approach by the party and not take instructions. Not this is not wrong. The false document.
ಈ ಡೋರ್ ಯಾವ ದನಗಳು ಹೋಗ್ತವೆ?
ಅದೇನ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಅಲ್ಲ
Commercial purpose, my lord, they are putting up.
ನಾನು ಕಳಿಸಿ ನೋಡಿದೆ ಸ್ವಾಮಿ, ಕಳಿಸಿದೆ.
ಯಾವ್ದಾದ್ರು
ಮೊನ್ನೆ ಲಾಸ್ಟ್ ಸೆಕೆಂಡ್
ಯಾವ್ದಾದ್ರು ಸ್ಲಿಮ್ ಫಿಟ್ ದನ ಇದ್ರೆ ಹೋಗ್ಬೋದು.
ಅದೇನ ನಮಗೆ ಸ್ವಾಮಿ ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕಳಿಸಿ ಕೇಳಿದೆ ಸ್ವಾಮಿ. ನಾಟ್ ಬಿಲಾಂಗ್ಸ್ ಟು ದಿ appellant in the RSA. Some other village the photograph.
ಅಲ್ಲ ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಪಕ್ಕನೆ ಕೌಶೆಡ್ ಇದೆ.
ಅಲ್ಲ
ಇದು ಬಿಟ್ಟು ಈಗ ಎಗೇನ್ ಇದನ್ನ ಕೌಶೆಡ್ ಅಂತ ಕಟ್ತಾ ಇದಾರೆ. ಇದು ಮನುಷ್ಯರು ಓಡಾಡೋಕ್ ಆಗೋದಿಲ್ಲ ಆ ಜಾಗದಲ್ಲಿ. ಇನ್ ದನ ಹೇಗೋ ಓಡುತ್ತೆ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ.
ಅದಿವನ್ 2 ಫೀಟ್ ಇಲ್ಲ ಡೋರ್.
ಅದೇನ ನಮಗೆ ಅಲ್ಲ ಇದು ಫಾಲ್ಸ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಮೇಲೆ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಫೋಟೋಗ್ರಾಫ್.
The council appearing for the
kindly tell the page number 1, my lord. It is a sale deed, my lord, executed by him on 4/3/24.
ಮನೆ ಮಾರಾಟ ಮಾಡಿದಿರಲ್ರಿ?
ಮೊನ್ನೆ ಮಾರಾಟ ಮಾಡಿದಾರೆ.
ಅಲ್ಲ ಅದೇನ ಗೊತ್ತಿಲ್ಲ. ಇದು ಯಾವ್ದು ಅಲ್ಲ ಕಾಪೀಸ್ ನಮಗೆ ಸರ್ವೆ ಮಾಡಿಲ್ಲ. ಕಾಪೀಸ್ ಸರ್ವೆ ಮಾಡಿಲ್ಲ.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡಿ.
Let him not sell the at least alienate the properties, my lord.
The council appearing for the respondent produced memo along with some documents putting the sale deed dated 4/3/24 and also photographs and RTC contending that during the pendency of this RSA, a property is sold and also the photograph contending that the construction is not for cowshed as submitted in the earlier date of hearing.
ಅಲ್ಲ ಇದು ಬಗ್ಗೆ ನಾನು ಕೇಳ್ತೀನಿ ಸರ್. ಅವ್ರು ಏನದು ಇದು this is not the documents not belongs to the scheduled property, not belongs to some other village properties.
ಆಯ್ತು ಹೇಳಿ ಅದೇನಿದೆ ಅಂತ.
ನಾನು I'll file objection for producing the photographs.
Seeks time to verify and submit regarding these documents and hence this matter next week ಅಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡಿ. We'll see.
ಅಲ್ಲ let him not alienate this, my lord.
Further alienate ಮಾಡ್ಬೇಡಿ.
ನಾವೇನ್ ಮಾಡಿ ನನಗೆ ಇಲ್ಲಿ ಕನ್ಸರ್ಟ್
ಸೇಲ್ ಡೀಡ್ ಇದೆಯಲ್ಲ
ಅದ್ ನೋಡ್ತೇವೆ ಈಗ ಪ್ರಾಪರ್ಟೀಸ್ concurrently held with respect to the suicidal properties, they have no right at all. Not only the appellate court.
ಮೆರಿಟ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಡಿಸೈಡ್ ಮಾಡೋಣ.
ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡ್ತೀನಿ
ನೆಕ್ಸ್ಟ್ ಟೈಮ್. ಆಯ್ತು ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಮಧ್ಯದಲ್ಲಿ ಕೊಡಿ. 19th
ಅಲ್ಲ 19th ಬೇಡಿ 18th ಆದ್ರೆ
18th ಆಗ್ಬೋದಾ?
ಆಯ್ತು. Till then entry matter may
18/7.
Till then entry matter may kindly be extended.
Let him not sell the property.
Not only with respect to item number 7.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಏನಂತ.
Item number 7 ಮಾತ್ರ ಮಲಾಡ್ ಡಿಗ್ರಿ ಮಲಾಡ್ ಅಪ್ಲೈ
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಏನು ಇಲ್ವಲ್ರಿ ಇಲ್ಲಿ?
ಅಲ್ಲ ಅವ್ರಿಗೆ ಇದೆ ಸ್ಟೇ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. Item number 7 ಅನ್ನ it was decreed in the first appellate court. Item number 7 ಏನೋ ಪಾರ್ಟಿಷನ್ ಕೊಟ್ಟರು ನಮಗೂ ಅದ್ರಲ್ಲಿ ಅದನ್ನ ಸ್ಟೇ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ.
ಸ್ಟೇ ಇದಾಗಿರೋದು ಆಗಿರೋದು
ಡಿಗ್ರಿ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಮೇಲೆ ಓನ್ಲಿ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ಐಟಮ್ ನಂಬರ್ 7 ಸ್ಟೇಟ್ ಬೈ ದಿ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್.
ಎಂಟ್ರಿ ಆರ್ಡರ್ ಗ್ರಾಂಟೆಡ್ is extended till next date of hearing 18th ವರೆಗೆ.
134 ಮಾಡಿದ್ದಾರೆ ಈಗ ಪ್ರಾಪರ್ಟಿ ಐಟಮ್ ನಂಬರ್ 134.
ಅಲ್ಲ ನಾನು
ಪೂರ್ವನ ಮಾರಾಟ
ಹೌದು ಲಾಸ್ಟ್ ಟೈಮ್ ಹಾಕಿದೆ.
ಇಲ್ಲ
ಲಾಸ್ಟ್ ಟೈಮ್ ಹಾಕಿದೆ ಡಾಕ್ಯುಮೆಂಟ್.
ಇದು ಮಾಡ್ತೀನಿ ನಾನು ಕೇಳಿ ನೋಡಿ.
ಆಯ್ತು 18/7 ಇಬ್ರು ರೆಡಿ ಆಗಿ ಬನ್ನಿ. ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ.
ಅವ್ರಿಗೆ ರೈಟ್ ಇಲ್ಲ 1977 ಮೈ ಫಾದರ್
ಇದೆಯಾ ಇಲ್ವಾ ಡಿಸೈಡ್ ಮಾಡೋಣ ಅವತ್ತು.
ಅಲ್ಲ ಕಾಪೀಸ್
ಬೇರೆ ಜನ ಕೊಡ್ತೀವಿ ಕೊಡ್ರಿ.
ಒಕ್ಕಲತ್ ಯಾರು ಹಾಕಿ
ಬೇರೆ ಕೊಡ್ತೀವಿ ಕೊಡಿ ನಮ್ಮ ಆಫೀಸ್
ಕಾಬಲ್ ನೀವು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಹಾಕ್ಬೇಕು.
ಅದನ್ನ ತರಿಸ್ಕೊತಾ ಆಗ್ತೀನಿ.
And also council is directed to file wakalat without fail before the next date of hearing in RSA crop 2 of 22.
At least let him not alienate the property.
ಏನ್ ಆಗಲ್ರಿ ನಮ್ಮ ವಾರದಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ.
Please
99
28 ಅರ್ಜೆಂಟ್ 99 ಅಮರೇಶ್ ಅಂಗಡಿ
buyer ready.
1/4 share in 1/4 share ಮತ್ತೆ 1/5 put of 1/4.
Plaintiff appeal, my lord. Decreed by the trial,
Certified.
decreed by the trial court, confirmed by the trial court. Both of concurrent held it is joint payment property, partition effected. Whereas the appeal, like one single item number 4 is not effected partition. Remaining items are partitioned by the trial court, except item number 4, my lord.
Except item number
4,
4 ಗೆ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ ಅಷ್ಟೇ. ಉಳಿದೆಲ್ಲ ಕೊಟ್ಟಿದೆ.
ಇದನ್ನೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. Dismissed in respect of 4.
ಅಷ್ಟೇ.
ಈಗ now your grievance is in respect of item number 4 only. Then what is the reasoning given by the trial court as well as the first appellate court?
ಅವರು ಏನಾಗಿದ್ರು item number 4 ಅಲ್ಲಿ the first respond here in my lord. He has filed the suit for the declaration. ಅಲ್ಲಿ ಡಿಕ್ರಿ ಆಗಿಬಿಡ್ತೀನಿ.
ಅವ್ರಿಗೆ ಡಿಕ್ರಿ ಆಗಿದೆ. ಮತ್ತೆ
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀವಿ.
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಮಾಡ್ಕೋಬೇಕು. ಅಲ್ಲಿ if you succeeds you would get the relief.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿ ಇಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ ಹೈಕೋರ್ಟ್.
ಆಯ್ತು.
That is also pending before this honorable court. RFA.
ಅದು ಏನು RSA ನಾ?
RFA. RSA
ನಂಬರ್ ಕೊಡಿ.
468 madam. 436.
436 of
2021.
436 of 2021 ನಾ?
Yes, please.
Same 2021.
Yeah.
ಅದ್ರಲ್ಲಿ ಏನಾಗುತ್ತೆ ರಿಸಲ್ಟ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ದಿಸ್ ಅಷ್ಟೇ. ಎರಡು ಡಿಸ್ಪೋಸಲ್ ಒಟ್ಟಿಗೆ ಮಾಡಬಹುದು.
ಇದು one more request my lord. It's a family matter. It may refer to mediation center. ಏನೋ ಸೆಟ್ಲ್ ಆಗ್ಬೋದು.
ಏನ್ರಿ ನಾಡಿದ್ದು ಲೋಕ ಅದಾಲತ್ಗೆ ಹೋಗಿ ಐಟಮ್ ನಂಬರ್ 4 ಗೆ ಏನೋ ಇದೆ ಅಂತಲ್ಲ. ಅವ್ರಿಗೆ ಡಿಕ್ಲರೇಷನ್ ಸಿಕ್ಕಿದೆ ಅಂತ ಅವರಲ್ಲಿ ಬಿಡ್ತಾರೆ ಕಾಂಪ್ರಮೈಸ್ ಗೆ.
ಅದೇ ಇಲ್ಲಿ ಸೂಟ್ ಅದನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆಲ್ಲ.
It is self-acquired property of 13 dependent. He have no any issues. He sold his lifetime to the 14th dependent.
Oh, that is self-acquired property.
Self-acquired property.
Item number 4.
Yes.
That is the finding.
Finding is
chances ಇದೆಯಾ?
ಕೇಳ್ತೀನಿ ಸರ್ ನಾನು.
ಕೇಳ್ತೀರಿ.
ಡೇಟ್ ಕೊಡಿ.
ನೋಡಿ. The counsel appearing for the appellant would submit that another connected RSA 436 of 2021 is also pending in respect of the item number 4 of the property, and in this appeal also the issue is only in respect of item number 4 of the property, and hence list the same along with this RSA, and in the meanwhile parties are directed to examine any chances of settlement. This matter ಎಷ್ಟೊಂದು ವಾರ? 18th
sir. After 22 months. 18th will not be.
ಆಯ್ತು 24th.
24/7.
100.
Varun Papireddy.
Hearing for the
BK Chandrasekhar.
I appeal for the appellant's counsel. Lord, this appeal is by the plaintiffs.
For the respondents 4 and 6.
Suit is for partition and allotment of 1/8 share to each of the plaintiffs in the suit schedule properties. The trial court dismissed the suit, appellate court has confirmed it. Lord, the subject matter of the suit consists of 14 items of landed properties. Landed properties. Landed properties and one house.
Landed properties.
Yes. One house property and fixed deposit of 10 lakhs kept in the name of the second defendant.
Second defendant.
Second defendant, the wife of the Karta.
Wife of the Karta.
Karta. Lord, so far as
But these landed properties are stands in whose name?
Lord, it is in the name of the Karta, that is the eldest son of Chelvegowda. Chelvegowda had 6 sons and
G3 is the produced.
yes, my lord, records are also received.
G3 is
Exhibit
also there.
P1, exhibit
These are the properties are belongs to Chelvegowda?
Lord, yes, only, Lord, 9 properties belonging to the Chelvegowda. Chelvegowda. The remaining properties were acquired in the name of the Karta, the eldest son of Chelvegowda, out of the joint family nucleus. The family had 17 acres of land. That was 17 acres of land was acquired by the government also.
All entire properties.
17 acres. Apart from 17 acres, the suit properties are also there.
Also the joint families.
Yes, 17 acres, that is not the subject matter of the suit.
Yes.
Lord, the main defense pleaded by the defendants. Lord, defendants 2 and 3. First defendant is the bank.
First defendant is
the bank. Bank. 10 lakhs of rupees has been deposited in that bank. Therefore, bank has been
made as party.
second defendant is the wife, and third defendant is the son of the
Second
Karta,
defendant.
Karta, eldest son of Cheluvegowda. Lord, they have not filed the return statement. Defendants 4, 5, and 6 have jointly filed the return statement.
Who are all 4, 5, 6?
Lord, defendant 4 is the son of the Karta Tataya, and 5 and 6 are the sons of another brother, Narayanappa.
Another brother of?
Another, that is second brother of Cheluvegowda. Second brother of Cheluvegowda.
Cheluvegowda.
Defendant 7.
But who is the plaintiff actually?
Plaintiffs are, my lord, 4 sons and 2 daughters of Cheluvegowda.
Oh, that is Tayamma, Ramachandraya, Narayana Swami.
Tatappa, my lord. It is not Thayamma. It is
Tatappana.
not. Yes.
Tatappana.
Yes, my lord.
Tayamma alla.
No. Tatappa, he was the eldest son of Cheluvegowda. He was the Karta of the family. After the death of the Cheluvegowda, Lord, the eldest son took over the management of the family. That has been admitted by the defendant DW1 and DW2 also. The main defense pleaded in the written
Suit
statement.
is filed by the Ramachandraya.
Ramachandraya.
Second son.
Yes, my lord. And 3 other brothers and 2 sisters.
Plaintiff number 1. Vijay Lakshmi is plaintiff number 2.
Yes.
Srinivasa is plaintiff number 3.
3.
Manjula
Manjula is another daughter. She is
P4.
plaintiff number 4. Ramesh is the son.
Ramesh P5.
Appaji Gowda.
Appaji Gowda.
4
P6.
sons and 2 daughters.
Oh, this is a suit against the
My lord, the
manager.
wife and children.
Saubhagyamma is the wife of
Yes, my lord.
first eldest son.
Eldest son. Tataya.
Lakshmana.
Lord, Lakshmana is also the son of Tataya.
Tataya.
This.
Oh, this is the
Lord,
Sasidhar
second
also
defendant
Tatappa.
and third defendant had not filed the return statement. Lord, defendant number 4 is the son of Tataya, the eldest son.
2 to 4 are children of this Tataya.
Yes, my lord. 5 and 6.
Wife and 2 sons.
Wife and, yes. 7 is the daughter.
Jayamma yaru?
Jayamma is the wife of Narayanappa. He was the second son of Cheluvegowda.
Second son?
Second son of Cheluvegowda.
There Cheluvegowda the ಹೆಸರು ತೋರಿಸೇ ಇಲ್ವಲ್ಲ ಮಕ್ಕಳನ್ನ.
Cheluvegowda was the propositus. He was the father. He had 6 sons and 2 daughters, including this Tataya and Narayanappa.
Oh, second, the Narayanappa.
Narayanappa.
Narayanappa is the third son.
Second son, my lord.
ಅಲ್ಲ ರೀ ತಾತಯ್ಯ
Yes, my lord. Third son.
ರಾಮಚಂದ್ರಯ್ಯ.
Yes. Third son.
ಮೂರನೇವನು ನಾರಾಯಣ.
Yes, my lord.
ಅವನ ಹೆಂಡತಿ ಯಾಕೆ?
Correct.
ಅಲ್ವಾ?
Yes.
ವೈಫ್ D5.
Yes.
ಕಾಂತರಾಜು ಅವನ ಆಕೆ ಮಗ.
Kantaraju is the son of Narayanappa.
ಆ ಬ್ರಾಂಚ್. ರೂಪಾ ಯಾರ ಕೆಂಪೇಗೌಡ ಅಂತಿದ್ರಲ್ಲ ಅವ್ರು ಯಾರು? ರೂಪಾ D5.
Lord, this Rupa
ಮತ್ತೆ 5 ಅಂತ ತೋರಿಸಿದ್ರು.
she is the daughter of Tatappa. That is the
daughter.
Daughter.
Oh,
And she has taken a gift deed in respect of 2 items of property. Lord,
now what is the reason for
issues.
dismissal of your suit?
Lord, material evidence adduced by the plaintiffs were ignored, and they have come to the conclusion that there was a oral partition about 25 years earlier to the filing of the suit. That was the main plea taken by the defendants. But there is no evidence at all to prove that there was oral partition among the sons of the some sons.
Whether parties have acted upon in terms of the oral partition?
Yes, there was no oral partition at all. But my lord, according to them, oral partition had taken place 25 years earlier. That means to say about 89 or 90, during 90 or 89, oral partition had taken place. Lord, Tataya died in the year 2010, eldest son. In the year 1996-97, Lord, the kathas were made in the name of eldest son on the statements made by other brothers. I have produced the documents. There is no dispute regarding the correctness of the revenue entries.
In the year
96, 97.
96, 97.
97. Lord, exhibit P8
Hmm.
is the mutation register extract,
Copy of MR extract.
MR extract. There it has been clearly written, 5 sons, 5 brothers have made a statement before the revenue authorities for changing the revenue entries in the name of
In the name
eldest
of
son,
the eldest
Tataya.
son.
Tataya.
Hmm.
That has been done. Lord, even in respect of other properties, Lord, mutation has been effected based on inheritance, not on partition.
Inheritance.
Inheritance.
In whose name?
In the name of eldest son, Karta.
Only eldest son.
Yes.
All properties are stands in the name
Yes,
of
yes,
eldest
ma'am.
son
Yes,
only.
ma'am.
Then what is the material to comes to a conclusion that already there was a partition?
Partition, except interested testimony, oral testimony of DW1 and DW2, there is no other material to show that there was earlier oral partition. Oral partition.
Then first appellate court, why court has already confirmed
First
the
appellate
judgment?
court at page number 35, paragraph 30, my lord. Kindly see.
Paragraph number?
Paragraph 30.
30.
30.
Ah.
It is most pertinent at this juncture to discuss the fact of dispute among the parties hereto. According to defendants, oral partition had already taken place in the joint family. It is their further say that in the said oral partition, plaintiffs 1 and 5 took cash amount in lieu of partition of land fallen to their share, and therefore item numbers 1 and 2 were retained by late Tataya alias Tatappa. It is also the case of the defendants that by virtue of oral partition, members of the family have been living separately by enjoying the portions of their respective shares. Shares itself were not given. These assertions of the defendants did gain support from the admitted facts of the plaintiff 1 has been residing separately in Bangalore. Blood plaintiff 1 is a government servant, was a government servant, he is now retired. He had acquired a house property in Bangalore. He has been residing separately. Therefore, just because he has been separately living, they say that a partition had taken place. Working in the police department from the year 1980 till the year 2011. It is also admitted case PW1, that is the plaintiff 1, that he had owning and possessing the property at exhibit D1, and that according to PW1, the said property is a self-acquired property. It is also admitted PW1 that defendant 6, Appaji Gowda, is also living separately. Not in the trial court, only at the time of arguments, a plea was taken, raised, that properties which are standing in the name of the plaintiff 1 and Appaji Gowda, plaintiff number 6, were not included. It is not their case that properties which are standing in the name of the first plaintiff and sixth plaintiff are the joint family properties. It is not their case. But based on that plea, in the written statement, they did not say that suit is for partial partition. But trial court took the contention that it is a well-settled principle of law that a suit for partial partition is not maintainable.
What is this document, exhibit D12, D13, D14?
They are all RTC extracts which are standing in the name of the Karta Tataya.
First defendant.
Yes, my lord, based on inheritance only. I have, Lord, kindly see the records are received. I will refer to the revenue documents also.
Yes, counsel, what do you say?
Yes, my lord.
Regarding oral partition, what is the material evidence?
Yes,
in
my
the
lord.
fact of-
After the partition, number of properties were purchased even in the name of the plaintiffs. For that, the trial court has discussed that para 19 of the judgment, my lord. After recording the finding at para 18, that there was already a partition, it further says at para 19 of the judgment, my lord. There are number of properties standing, which are, the submission made by the other side is not correct. The documents are produced before the trial court and marked as exhibits D2 to D6. May I read it, please? Para 19.
Yes.
The plaintiff in his cross-examination has admitted that he has sold the property which is shown in Exhibit D1. Exhibit D1 is the document pertaining to a site in property number 299, and it was confronted to PW1 during his cross-examination. PW1 has admitted that he alone had sold the property shown in Exhibit D1, and none of his brothers were parties to the sale deed. PW1 has also admitted that about 30 acres of property were standing in the name of his father, but he has not included all those properties, and also that he does not know the survey numbers of those properties. PW1 in his further cross-examination, though had admitted that he has sold the property shown in Exhibit D1. Subsequently, in his further cross-examination, he has stated that he is residing in the properties shown in Exhibit D1, which has not been included in the suit schedule. PW1 in his cross-examination has admitted that the sixth plaintiff has got several properties which has not been included in this suit. PW1 has also admitted that the defendant numbers 3 to 6 are cultivating the properties at Virapura village by growing ragi crops in the said properties, the fruits of which they themselves are enjoying. The defendants have also produced exhibits D13 and 14, that is RTC extracts, pertaining to survey number 22 measuring 30 guntas and survey number 32 measuring 1 acre, which is standing in the name of plaintiff number 6, and the exhibit D16 pertaining to survey number 60/1 measuring 38 guntas standing in the name of the second defendant, Saubhagyamma, wife of Tate. The RTC shows that the properties shown, they are not included in the suit schedule properties. The defendants have also produced exhibit D19 to exhibit D21 issued by the BBMP Bangalore to show that the plaintiff Ramchandra has got sites at Bangalore for which he is paying taxes. But those properties are not included in the suit schedule. Even exhibit D24 to 26, the taxpayer receipts goes to show that the properties in the name of defendant number 7, which was gifted by Tate in favor of defendant number 7, as per gift deed dated 26/5/2010. Exhibit D23 is also not included in the suit schedule. Even the house shown in the photographs at exhibit D27 to 30 and the building shown in exhibit D31 and 32 belonging to the plaintiffs are not included in the suit schedule. PW1 in his cross-examination has admitted that those properties belong to them. It is recorded at para 21. It is clearly recorded at the last, but commencing from the last second line. Last but second line. The plaintiffs have chosen to file the suit against selected items of.
What are the family properties are given to these persons?
Please.
Family properties.
These are the other properties, the survey numbers at the properties situated at Virapura village, and all those properties are the family properties. And those documents have been produced before the court below, which has been concurred by the appellate court also. The clear findings have been recorded by both the courts below. And it is the concurrent finding with regard to the factum of partition which has taken place in the family. And number of properties which are available and standing in the name of the plaintiffs have been purposefully not included, and they have chosen to include the properties of the defendants only.
Lord, in the written statement, they have not pleaded that there are properties belonging to the giant family which are not included. There is no issue also. Kindly see the issues, my lord. Issues at page number 59 of the trial court. First issue is ದಾವಾ ಸೊತ್ತುಗಳು ಒಟ್ಟು ಕುಟುಂಬದ ಅವಿಭಾಜ್ಯದ ಸೊತ್ತುಗಳು ಎಂದು ವಾದ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ವಾದಿಯವರು ರುಜುವಾತುಪಡಿಸುವರೇ. This burden is on the plaintiffs.
Yes.
Second issue is ಪ್ರತಿವಾದ ಪತ್ರದ ಖಂಡಿಕೆ 12ರಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ಈಗಾಗಲೇ 25 ವರ್ಷದ ಹಿಂದೆಯೇ ವಾದಿ 1, 3, 5, 6 ಮತ್ತು ತಟ್ಟಪ್ಪನವರ ನಡುವೆ ವಿಭಾಗ ಆಗಿದೆ ಎಂದು ಪ್ರತಿವಾದಿ 4ರಿಂದ 6ರವರು ರುಜುವಾತುಪಡಿಸುವರೇ. In support of this, Lord, there is no acceptable or legal evidence to prove it. Therefore, the finding given on issue number 2 is perverse. except the interested testimony, oral evidence.
Then why you have not included all these properties? If these properties are not the family
Lord,
properties,
first plaintiff and sixth plaintiff are employed.
maybe employees, whether they have purchased all these properties by their own
Yes, my lord. They had
self-gain.
independent income.
ಎಲ್ಲಿದೆ ದಾಖಲೆಯಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಿ? ಸೇಲ್ ಡೀಡ್ಸ್ ಇದೆಯಾ?
Lord, sale deed, they have, dependent themselves have produced.
ಯಾವ್ದ್ರದ್ದು?
Regarding the property.
ಈ ಪ್ರಾಪರ್ಟೀಸ್ ಅಲ್ಲ, those properties which have not been included in the suit.
Yes, my lord.
All these properties are exclusive properties of the plaintiff ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ?
Lord, they must show that those properties which are in the standing in the name of the plaintiffs are the joint family properties and they are not included. Therefore,
according to them, that those properties are given to you in the
no, my lord,
oral partition.
no, it is not so. It was not the joint family property earlier, or it was standing in the name of Tataya or Chelvegowda. That is not the case. What they have shown are the properties which have been acquired by the plaintiff 1 and the plaintiff 6, because plaintiff 6 was in the bank employee, first plaintiff was in government.
ಅದಕ್ಕೆ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ, these are the exclusive properties. ನೀವು ಆನ್ಸರ್ ಮಾಡಿದಿರಿ, ಇವೆಲ್ಲ ಸೇರ್ಸಿಲ್ಲ ಈ ಪ್ರಾಪರ್ಟೀಸ್ ಎಲ್ಲ ಅಂತ ನೀವು ಅಡ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದೀರಿ.
ಹೌದು.
Have you placed any document that these are the properties are acquired by us ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನಾದ್ರು ಕೊಟ್ಟಿದ್ದೀರೋ ದಾಖಲೆ?
In the cross examination.
ಅಡ್ಮಿಷನ್ ನೋಡಿ, ಅಡ್ಮಿಷನ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ ಅದು.
ಅಲ್ಲ, they have said that they are their own properties.
Evidence PW1. Is it your case that all these properties are acquired out of your self gaining?
Yes, my lord. Yes, my lord. That is my case.
ಇದರಲ್ಲಿ ಯಾವ್ದು ಪ್ರಾಪರ್ಟೀಸ್ ಏನ್ ನೀವು ಅಡ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟೀಸ್ ಸೇರಿದ್ದು ಹೌದಾ ಅಲ್ಲ?
ಅಲ್ಲ, ಅದು ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟೀಸ್ ಅಂತ, ಇಟ್ ಈಸ್ ನಾಟ್ ದ ಕೇಸ್ ಆಫ್ ದಿ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಆಲ್ಸೋ. And they are entitled for a share in those properties. They have not stated so. What they say is they are standing in your name, they have not been included.
ಡಾಕ್ಯುಮೆಂಟ್ ಕನ್ಫರ್ಮ್ ಮಾಡಿದಾಗ ನೀವು PW1 ಏನ ಇವರು ನಿಮ್ಮ ಪ್ಲೇಂಟಿಫ್ ನಂಬರ್ 1?
Yes, plaintiff number 1.
ಗೆ ಒಂದು ದಾಖಲೆಯನ್ನು ತೋರಿಸಿದಾಗ ಅದರಲ್ಲಿ ಕಾಣುವ BC ರಾಮಚಂದ್ರ ನಾನೇ ಎಂದು ಒಪ್ಪಿದ್ದಾರೆ. ಹಾಗೂ ಸದರಿ ದಾಖಲೆಯಲ್ಲಿ ಕಾಣುವ ಆಸ್ತಿಯನ್ನು 2010ನೇ ಇಸ್ವಿಯಲ್ಲಿ ಮಾರಾಟ ಮಾಡಿರುವುದಾಗಿ ತಿಳಿಸಿದ್ದಾರೆ. ಅದನ್ನು ನಿಶಾನೆ ಡಿ ಎಂದು ಗುರುತಿಸಿದೆ. ನಿಶಾನೆ ಡಿ 1ರಲ್ಲಿ ಕಂಡ ಆಸ್ತಿಯನ್ನು ನಾನೊಬ್ಬನೇ ಮಾರಾಟ ಮಾಡಿರುತ್ತೇನೆ. ನನ್ನ ಸಹೋದರರು ಮಾರಾಟದಲ್ಲಿ ಭಾಗಿಯಾಗಿರುವುದಿಲ್ಲ. ನನ್ನ ತಂದೆ ಹೆಸರಿನಲ್ಲಿ ಆಗಿರುವುದಿಲ್ಲ. ನನ್ನ ತಂದೆ ಹೆಸರಿನಲ್ಲಿ ಸುಮಾರು 30 ಎಕರೆ ಜಮೀನು ಇತ್ತು. ಯಾವ ಸರ್ವೆ ನಂಬರ್ಗಳಲ್ಲಿ ಎಷ್ಟು ಜಮೀನುಗಳನ್ನು ಇತ್ತು ಎಂದು ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ನನ್ನ ಇತರೆ ಸಹೋದರರು ಈ ಎಕ್ಸಿಬಿಟ್ D1 ಪ್ರಾಪರ್ಟಿ ಇದೆಯಲ್ಲ, ನೀವು ಮಾರಾಟ ಮಾಡಿದಿರಲ್ಲ, ನಿಮ್ಗೆ ಹೇಗ್ ಬಂತ ಆ ಪ್ರಾಪರ್ಟಿ?
Lord, that is in Bangalore, house property, my lord. That was purchased by plaintiff 1 and it is his self-acquired property, therefore it was not included.
ಅಲ್ಲ, ಅದಕ್ಕೇನೆ ಕೇಳ್ತಾ ಇದೀನಿ, ಏನ್ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ ಅದಕ್ಕೆ ನಿಮ್ ಸೆಲ್ಫ್ ಅಕ್ವೈರ್ಡ್ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಅಂತ. ಅವ್ರು ಸ್ಪೆಸಿಫಿಕ್ ಕ್ವಶನ್ಸ್ ಕೇಳ್ತಾರೆ, ನೀವು ಒಬ್ಬರೇ ಸೇಲ್ ಮಾಡಿದ್ರಿ, ನಿಮ್ ಬ್ರದರ್ಸ್ ಯಾರು ಸೇರಿಲ್ಲ ಅಂತ.
Correct. It was acquired by him only and sold by him.
him ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ ನಾನು.
But exhibit D1 is the document to show that it was acquired in the name of the
sold by you.
Yes.
ಸೇಲ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ನಿಮಗೆ ಹೇಗ್ ಬಂತ್ರಿ ಆ ಪ್ರಾಪರ್ಟಿ?
He is a government servant, he has an independent source of income, therefore he
ಕೊಂಡ್ಕೊಂಡಿದ್ದ ದಾಖಲೆ ಇದೆಯಾ ಅಂತ ಕೇಳಿದೆ. Is it your case that that property belongs to the family? ಏನ್ರಿ ಅವ್ರಿಗೆ ಅಲಾಟ್ ಆಗಿತ್ತು ಪ್ರಾಪರ್ಟಿ ಅಂತನಾ? ಈ ಪ್ರಾಪರ್ಟಿ ಎಕ್ಸಿಬಿಟ್ D1 ಪ್ರಾಪರ್ಟಿ ಇನ್ ಎ ಓರಲ್ ಪಾರ್ಟಿಷನ್.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಪ್ಯಾರಾ 22 ರಲ್ಲಿ ಪಾರ್ಷಿಯಲ್ ಪಾರ್ಟಿಷನ್ ಬಗ್ಗೆ ಹೇಳಿರೋದವ್ರು. ನಮ್ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡು ಪಾರ್ಷಿಯಲ್ ಪಾರ್ಟಿಷನ್ ಇದು ಮಾಡಿದ್ದಾರೆ, ಮಾಡಿಲ್ಲ. ಪ್ಯಾರಾ 22.
But kindly see the written statement whether they have raised a plea that there was properties which are belonging to the joint family and it are standing in the name of the plaintiffs and they have not even included. No plea has been raised. And it is not their case also, suit is for partial partition. Plea was also there, not there. At the time of arguments, that plea was raised. This on the same point, the trial court gives a finding that suit for partial partition is not maintained. Unless issue is raised, not finding is given. Basically, there is no plea. Secondly, there is no issue. And there is no evidence.
Para 12 of the return statement ಅಲ್ಲಿ clear ಆಗಿದೆ sir. Para 12 of the return statement ಅಲ್ಲಿ properties are allotted to the share of the plaintiffs and the properties that are being enjoyed. It is not the
ಈ ಎಕ್ಸಿಬಿಟ್ D1 ಪ್ರಾಪರ್ಟಿ ನಿಮಗ್ ಸೇರಿತ್ತು ಅಂತ ತೋರ್ಸಕ್ ಏನ್ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ ಹಿಂದೆ? ನೀವೇ ಕೊಂಡ್ಕೊಂಡಿದ್ದು ಅಂತ.
ಅಲ್ಲ ಅವರೇ ಹೇಳ್ತಾರಲ್ಲ, ಇಟ್ ಈಸ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ದೆಮ್.
ಅವ್ರು ಹೇಳಿಲ್ವಲ್ಲ, ನೀವು ಮಾರಾಟ ಮಾಡಿದಿರಿ, ನೀವು ಒಬ್ಬರೇನೆ ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ ಆಗಿ, ಅವ್ರು ಯಾರು ಬೇರೆಯವ್ರು ಸೇರಿಲ್ಲ, ಅವ್ರ ಬ್ರದರ್ಸ್ ಅಂತ ಆನ್ಸರ್ ಎಲಿಸಿಟ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ ಅವರು.
ಹೌದೌದು.
ಅವಾಗ ನೀವೇನ್ ಮಾಡ್ಬೇಕು, ನಿಮ್ದೇ ಇದು ಸೆಲ್ಫ್ ಅಕ್ವರ್ಡ್ ಪ್ರಾಪರ್ಟಿ, ಐ ಸೋಲ್ಡ್ ಇಟ್ ಅಂತ ತೋರ್ಸಕ್ ಏನ್ ದಾಖಲೆ ಕೊಟ್ರಿ?
No, it was purchased in his name, therefore it was sold by him only.
ಏನಿದೆ ಅಂತ ಕೇಳ್ದ ಅವನ ಹೆಸರಲ್ಲಿ ಕೊಂಡ್ಕೊಂಡಿದ್ಕೆ ಸೇಲ್ ಡೀಡ್ ಹಾಕಿದೀರಾ?
Lord, exhibit P1 is the sale deed. D1 is the sale deed to purchase for having purchased in the name of.
ಅದು ಸೇಲ್ ಮಾಡಿದ ಪ್ರಾಪರ್ಟಿ
ಅಲ್ಲ. ಸೇಲ್ ಮಾಡಿದ ಅಲ್ಲ. ದಟ್ exhibit D1 is this.
ಬಗ್ಗೆ ಕೇಳ್ತಾರಲ್ರಿ ಅದರಲ್ಲಿ.
Exhibit D1
ಕೇಳ್ತಾ ಇದೀನಿ.
ಅಲ್ಲ, ಅವರು ಆಮೇಲೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ನಾನು ಸೇಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. It is true that the property was acquired under exhibit D1 belongs to me ಅಂತ.
ಹಾಗಂತಿಲ್ಲ ನೋಡ್ರಿ, ಸದರಿ ದಾಖಲೆಯಲ್ಲಿ ಕಾಣುವ ಆಸ್ತಿಯನ್ನು 2010ನೇ ಇಸ್ವಿಯಲ್ಲಿ ಮಾರಾಟ ಮಾಡುವುದಾಗಿ ತಿಳಿಸಿದ್ದಾರೆ. ಅದನ್ನು ನಿಶಾನೆ ಡಿ ಎಂದು ಗುರುತಿಸಿರುತ್ತದೆ ಅಂತಿದೆ. A sale deed executed by your client, not having acquired the property by you.
Lord, if the other side says.
One second, exhibit D1. Exhibit D1 is only ECL and really. Only ಖಾತಾ ಇದೆ. VC ರಾಮಚಂದ್ರಯ್ಯ. D2 ಇರ್ಬೇಕು ನೋಡಿ, ಸೇಲ್ ಡೀಡ್. ಅಪ್ಪಾಜಿಗೌಡ BC ಕಾಡಯ್ಯ ಅಂತಿದೆ.
ಅಪ್ಪಾಜಿಗೌಡ plaintiff number 6.
ಹೆಸರೇನು?
Plaintiff number 6. ರಾಮಚಂದ್ರಯ್ಯ is the first plaintiff. Appajigoda is the 6th plaintiff. He was the bank employee.
He had purchased the property.
Yes.
Exhibit D2.
Lord, if they contended that properties which were acquired.
ಎಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಪಾರ್ಟಿಷನ್ ಆಯ್ತು ಅಂದ್ರಲ್ಲ, ನೀವ್ ಯಾವ್ಯಾವ ಪ್ರಾಪರ್ಟಿ ಅವ್ರಿಗೆ ಅಲಾಟ್ ಆಗಿದೆ, ಆ ಪ್ರಾಪರ್ಟಿ ದಾಖಲೆ ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಿ?
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಬಿಟ್ಟು ಅದರಲ್ಲಿ they have admitted.
ಸರಿ, ನಿಮ್ ಆಸ್ತಿ ಟೋಟಲ್ ಸರ್ವೆ ಕೊಡಂಗ್ ಆಸ್ತಿ ಇತ್ತು, ಹೌದಲ್ಲ? ನಿಮ್ ಪ್ರಕಾರ ಓರಲ್ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ ಅಂತ ಯಾವ್ಯಾವ ಪ್ರಾಪರ್ಟಿ ಅವರಿಗೆ ನಿಮ್ಮ ಪ್ರಕಾರ ಪಾರ್ಟಿಷನ್ ಆಗಿದ್ರೆ ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥದ್ದು
ಎಲಿಸಿಟ್ ಮಾಡಿಸಿದಾರಲ್ಲ, ವೀರಾಪುರ ಪ್ರಾಪರ್ಟೀಸ್ ಹೇಳಿಸಿದ್ದಾರೆ. ವೀರಾಪುರದಲ್ಲಿದ್ದ ಪ್ರಾಪರ್ಟೀಸ್ ಎಲ್ಲ ನಮಗ್ ಬಂದಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಯಾರು ಹೇಳಿದ್ದಾರೆ?
ಅವರು PW1.
ಎಲ್ಲಿದ್ದಾರೆ?
ನೋ ಅದರ್ ವಿಟ್ನೆಸ್ ಹ್ಯಾಸ್ ಬಿನ್ ಎಕ್ಸಾಮಿನ್ಡ್.
ಎಲ್ಲಿದೆ ರೀ ಕ್ರಾಸ್ ಅಲ್ಲಿ ಅಡ್ಮಿಷನ್? ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ನಮಗ್ ಬಂದಿದೆ ವೀರಾಪುರದ್ದು ಅಂತ.
ವೀರಾಪುರದ ಜಡ್ಜ್ಮೆಂಟ್ ಜಸ್ಟ್ ನೌ ಐ ರೆಡ್ ಇಟ್.
ಇದೆಲ್ಲ ಅವ್ರು ಕೊಂಡ್ಕೊಂಡ್ರೆ ಆಸ್ತಿ. ಎಕ್ಸಿಬಿಟ್ D2 D3 ಎಲ್ಲ ನಿಮ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟೀಸ್ ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ ದಾಖಲೆ ಇದೆ? ಯಾವ್ದು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ ಅಡ್ಮಿಷನ್? ಆರನೇ ವಾರ್ಡಿಗೆ ಅಡತಮಾರ್ನಹಳ್ಳಿಯಲ್ಲಿ ಮನೆ ಇದೆ, ಸದರಿ ಮನೆಯಲ್ಲಿ ಈ ದಾವೆಯನ್ನು ಸೇರಿಸಿಲ್ಲ. ಅವರು ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ ಯಾವ ಆಸ್ತಿ ಕೊಟ್ಟಿದೆ ಅನ್ನಕ್ಕೆ ಎಲ್ಲಿದೆ ಅಡ್ಮಿಷನ್? ಎಲ್ಲೂ ಇಲ್ವಲ್ಲ?
Details ಕೊಟ್ಟಿಲ್ಲ because but it is clearly admitted by the plaintiffs
ಏನಂತ?
that there are number of other properties
other
belonging to
property-
the family and those properties have not been included. And
ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟೀಸ್ ಯಾವ್ದು ಇದೆ ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿಲ್ಲ ಅಂತ ಯಾವ್ದಿದೆ ರೀ? ಯಾವ್ದು ಇಲ್ಲ.
ಓದಿದ್ವಿ.
ಎಲ್ಲಿದೆ? ವೀರಾಪುರದ ಪ್ರಾಪರ್ಟಿ ಪಿತರಾದಿತ ಆಸ್ತಿಯಲ್ಲಿ ನನಗೂ ಬಂದಿದೆ ಅನ್ನಕ್ಕೆ ಎಲ್ಲಿದೆ ಅಡ್ಮಿಷನ್? ಎಲ್ಲ ಅಡ್ಮಿಷನ್ ಎಲ್ಲ ತಾತಾಯ ಕೊಂಡ್ಕೊಂಡ್ರ ಬಗ್ಗೆ ಮಾತ್ರ ಇಲ್ಲಿದೆ.
ಅಲ್ಲ ಇಲ್ಲಿ D2 to 6 are the sale deed.
ಓವರಾಲ್ ಪಾರ್ಟಿಷನ್ ಗೆ ಎವಿಡೆನ್ಸಿಂಗ್ ದಿ ಮೆಟೀರಿಯಲ್ ಏನಿದೆ ಅಂತ ಕೇಳಿ ಆನ್ಸರಿಂಗ್.
ಅಲ್ಲ ಓವರಾಲ್ ಪಾರ್ಟಿಷನ್ ಗೆ ಅಷ್ಟು ಕ್ಲಿಯರ್ ಆಗಿ ಇಂತಿಂತ ಪ್ರಾಪರ್ಟೀಸ್ ಅಂತ ಕೊಟ್ಟಿಲ್ಲ.
ಹೌದ್ರಿ,
But still number of other properties are available to the family
ಆಸ್ತಿನದ್ ಬೇಕಲ್ಲ
and they are cultivating it ಅಂತ ಇದೆ.
Maybe have suggested that whatever the properties they have earned, those properties are not included.
Despite the specific stand taken that the other plaintiffs are also enjoying their respective properties, they have not been examined.
To the respondent, the main contention of the counsel appearing for the appellant that both the trial court as well as the first appellant comes to the conclusion that already there was a oral partition and the question of granting share doesn't arise. The counsel also vehemently contend that no piece of evidence is placed before the court with regard to the property allotted in favor of the plaintiffs out of the family properties. The counsel also vehemently contend that it is not in dispute that family was having large number of properties and none of the material is placed before the court that properties are allotted in favor of the appellant plaintiffs. The counsel appearing for the respondent would submit that there is an admission with regard to the inclusion of the properties and counsel and also on verification of document exhibit D1, D2, D3 with regard to the same, an answer is elicited and all those properties are stands in the name of the plaintiffs only and doesn't disclose that all properties are the family properties. And when such being the case, the matter requires reconsideration. Admit the following substantive question of law arises for the consideration of this court, whether the courts below have committed an error in coming to the conclusion that already there was a oral partition in the absence of any documentary evidence proving the factum of oral partition and parties have acted upon. Next one, whether both the courts below have committed an error in not considering the material on record and whether the finding of both the courts that already there was a partition is against the material on record, whether it amounts to perversity in coming to such a conclusion.
Not IA1 is to prevent the defense. IA1 have filed
ಏನ್ ಮಾಡಿದಿರಿ?
not to alienate the suit properties. And IA2 is not to disperse the fixed deposit. IA2, IA1 is order 39.
ಎರಡೇ ಹಾಕಿದಿರಾ?
ಎರಡೇ ಹಾಕಿದೆ.
1/21.
Yes.
And 2/21.
Yes.
Third, the appellant counsel on IA 1/21 and IA 1/21 is said not to disperse the amount which is in FD alla?
Yes.
FD. And in view of admitting the second appeal, it is appropriate to restrain the respondents in dispersing the amount which is in FD. Next, IA number 2, not to alienate.
From alienating the suit schedule properties.
Heard on IA number 2/21 and this court having perused the material after hearing both the counsels found that the matter requires reconsideration and both the courts also given consideration that there was already a partition but prima facie not discloses any document of properties which were allotted in favor of the appellant's plaintiffs. And when such being the case, if these properties are sold, it will leads to the multiplicity of proceedings and hence directed not to alienate the same till the disposal of this second appeal. Paper book bekala partition. Suit is for the relief of partition and hence filing of paper book is dispensed. List the matter in the third week of August for final hearing.
101, Pramoda, Chaitanya.
I am appearing for the respondent in this matter. There is a delay of 343 days, my lord. And We are filing the objections, my lord.
Other side idara. Chaitanya SG.
My lord, I am appearing through VC.
You are going to file objections?
Yes, my lord. My junior colleague has handed over the objection.
Yes, counsel. ಹೇಳಿ.
My lord, the suit is for specific performance. Agreement was entered in the year 2004, my lord.
Counsel, now regarding delay is concerned, let him convince the court and then you can make submission.
Yes, my lord. Yes, my lord.
With regard to my lord, the suit has been, the RA has been dismissed, my lord, which come to our knowledge. When the notice was served on us, in the execution petition, my lord, that is the reason that has been assigned. Prior to that, my lord, intimation was not given by the, intimation was not given by the council regarding the disposal of the case. So that, my lord, when the execution notice has come, my lord, I came to know that and
Whether
immediately
you appeared in the trial court or not?
trial court we have appeared.
You have engaged the counsel.
Engaged the council and also in the appeal also.
Have you filed the written statement?
Yes, filed the return
Contested
statement,
the
my lord.
matter?
Yes, my lord. Defendant number 4 has filed the return statement and matter is also contested.
Contested the matter.
Contested the matter.
Then,
my lord, after that, my lord, RA has been preferred when the decree was made out, my lord.
yes.
And after the filing of the RA, Your lordship, I came to know that the result of the RA when the execution summons was served on me, when the plaintiff has filed, my lord.
Till that time, what you are
Till
doing?
that time, my lord, it is the fact that, my lord, according to the instruction of the
RA
party, my
judgment
lord,
was passed
it was
on
not
what
instructed,
date?
my lord.
RA judgment on what date?
RA judgment was on, my lord.
15th day of February
Yes, madam.
2019.
That is the RA judgment on, my lord, 19th February 2019, my lord. And I had applied for the certified copy in the year, in the month of January, my lord. I had obtained in the April. So immediately after
Appeal filed in the month of
my lord, April, my lord. It was obtained in the January and April we have filed the appeal, my lord.
April 21.
21, my lord.
Almost 2 years.
January we have obtained the copy, my lord.
After
And
2
I
years.
have narrated 340 days delay, my lord, not 2 years.
But that is exclusion of the COVID period.
Yes, my lord. That is
Otherwise 2 years.
yes, my correct. That is the, my lord. And after that, when the decree, when the summons was come in the execution case, my lord, Lord, she kindly see my application.
Execution ಅಲ್ಲಿ ಯಾವಾಗ ಸರ್ವಾಗಿದ್ದು ನಿಮಗೆ?
Served, my lord.
Served on us during the month of July
2020, my lord, and filed by the respondent. In fact, the
then
judgment passed against us was
why
not.
you kept quiet till to
Further,
April
my lord.
21?
In fact, the judgment passed against us was not informed by my counsel also.
ಆಯ್ತ್ರಿ execution file ಆಯ್ತು. Execution ಅಲ್ಲಿ you came to know about the same in the month
And
of
later
July 2020 itself.
And 9/12/2020, I filed for a certified copy and obtained same on 11/12/2020, my lord. In April 21, I have filed the appeal, my lord.
ನಿಮ್ಗೆ execution ಅಲ್ಲಿ notice ಸರ್ವಾಗಿದ್ದೆ ಯಾವಾಗ್ರಿ?
That is July 2020, my
20.
20, my.
Then why you have not applied the copy till the December 2020?
That is my lord.
And the same was obtained on 11/12/20 also. And appeal is filed in the month of April.
By seeing the case, my lord, if the matter relates to the immovable property, my lord, the question is that the imposing cost, it may be allowed, my lord, and I'll submit on the merits itself, my
July
lord.
20 ನಲ್ಲೇ ಗೊತ್ತಾದ್ರೂ ಯಾಕೆ ಮತ್ತೆ ಈಗ now you are making an allegation against the earlier advocate who represented in the appeal.
I withdraw those allegations.
He did not communicate, but having come to know about the execution filed in the year 2020 itself, and notice was served on you in the 2020 in the month of July.
That particular.
What is the explanation?
Some delay has taken place, my lord.
Yen property and head
Property with regard to 19 guntas of land, my
19
lord.
guntas of land.
19 guntas of land.
Irodu.
My lord, suit for specific performance. The advance amount, my lord. The total consideration of the agreement, my lord, 75,000.
19 guntas ke.
19 guntas.
Property ಇರೋದು ಎಲ್ಲಿ?
In Mandya, my lord.
ಮಂಡ್ಯದಲ್ಲಿ ಎಲ್ಲಿ?
Chick Mandya.
ಚಿಕ್ಕ ಮಂಡ್ಯ.
Yes, my lord.
Wherein, my lord,
Agreement in which year?
my lord, agreement is of the year 2004.
2004.
Yes, my lord.
Ah.
And the suit has been filed in the year 2008.
Hmm.
The property situated at Gopalpura village, Kaspapalli, Mandya Taluk, it is near to Chikmandia, my lord.
Hmm.
Here in this matter, my lord, the agreement was taken place, Exhibit P1, my lord, the document, the LCR has come, my lord.
Hmm.
In that, my lord, a 2 years time has been fixed.
2 years?
Time has been fixed, my lord.
Ah.
Within the 2 years, they will have to come and execute the sale deed in favor of the plaintiff. The contention taken by the defendants before the trial court that the agreement was executed only for the security of loan and not for selling the property, my lord. And the trial court has decreed the
What
suit
is the nature of the property? Is it a dry land or a wetland?
wetland, my lord, agriculture land.
Wetland.
Wetland, my lord.
Ah.
He is only defendant number 4.
Hmm.
It has come to him, she is enjoying the same, she is unmarried daughter, my lord. My humble submission is that, my lord, in order to prove the very question of the transaction which was taken, the purpose for the transaction which was taken for the loan purpose, my lord, for that agreement was made out. In order to establish the same, your lordship, the very conduct of the party is, my lord. Lordship, kindly see, the agreement of sale is on 15/4/2004, my lord, and the legal notice sent on 17/9/2008. That is after 4 years, my lord. I am not on the limit point of the limitation, my lord.
How much the sale consider or how much earnest money was paid?
65,000 has been filed, my lord.
Already paid. Only balance is 10,000.
10,000, my lord.
Ah, then
10,000, my lord. That is the very conduct, my lord. With regard to that, there is no condition in the agreement, certain act to be done by the plaintiff for obtaining the kata and other
what
things,
is
my
going
lord.
to pay repayment only at the time of registration? Only they have to pay an amount of rupees 10,000.
10,000. My humble submission is that, my lord, in the evidence, my lord, the PW2, in the evidence, I may be permitted to cross-examination of portion of the PW2.
The evidence in Matra.
ಇದೆ. Records ಬಂದಿದೆ.
Records?
ಬಂದಿದೆ ಸ್ವಾಮಿ. Call for records ಆಗಿತ್ತು last time.
First you convince with
that is just, my lord. In the limitation, the witness says, my lord, ಈ ಕೇಸ್ನ ಏನಕ್ಕೆ ಹಾಕಿದ್ದೀರಿ ಅಂತ ಕೇಳಿದ್ರೆ it is for the loan transaction, ಹಣದ ವ್ಯವಹಾರಕ್ಕಾಗಿ ಕೇಸ್ ಹಾಕಿದೆ ಅಂತ. This is the admission, my lord, I may be permitted. ಈ ದಾವೆಯನ್ನು ಯಾರ ವಿರುದ್ಧ ಏನು ಪರಿಹಾರ ಕೇಳಿ ದಾವೆ ಹೂಡುತ್ತಾರೆ ಎಂಬ ಪ್ರಶ್ನೆಗೆ ಸಾಕ್ಷಿ ಹಣದ ವಿಚಾರಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ದಾವೆ ಹೂಡಿರುತ್ತಾರೆ. ಆದರೆ ಯಾರ ವಿರುದ್ಧ ಹೂಡಿರುತ್ತಾರೆ ಗೊತ್ತಿಲ್ಲ. ಕ್ರಯದ ವ್ಯವಹಾರದ ಮಾತುಕತೆ ನಾನು ಹೋಗಿರಲಿಲ್ಲ, ಹಾಗಾಗಿ ಈ ಬಗ್ಗೆ ನನಗೆ ವಿಷಯ ಗೊತ್ತಿಲ್ಲ. ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ದಾಖಲೆ ಬರೆದಾಗ ಮಾತ್ರ ಹೋಗಿದ್ದೇನಂತಾರೆ. ದಾವಾಜಮಿ ಸಂಬಂಧ ನಾನು ಖುದ್ದಾಗಿ ಯಾವುದೋ ದಾಖಲೆ ಪತ್ರಗಳನ್ನು ನೋಡಿಲ್ಲ. ದಾವಾಜಮಿ ಮಾರ್ಗ ಬೆಲೆ ನಿಖರವಾಗಿ ಎಷ್ಟು ಗೊತ್ತಿಲ್ಲ. ಈ ದಾವೆ ನೇತ್ರಾಪತಿ ಯಾರೆಂದು ಗೊತ್ತಿಲ್ಲ. Witness.
What about PW1?
PW1 says, my lord, regarding the execution of the document, he says, your lordship, in I may be permitted to read in middle portion, ಪತ್ರ ಬರೆಯುವಂತಹ ಸಂದರ್ಭದಲ್ಲಿ ಆಟೋನಲ್ಲಿ ಬಂದಂತಹ ಪ್ರತಿವಾದಿಗಳು ಅದೇ ಆಟೋದಲ್ಲಿ ಕುಳಿತಿದ್ದರು. RTO ಆಫೀಸ್ ಬಳಿ ಇರುವಂತಹ ಕೊಠಡಿಯಲ್ಲಿ ಪತ್ರ ಬರೆಯಲಾಯಿತು. ಕೃಷ್ಣಸ್ವಾಮಿಯವರು ಕಚೇರಿ ಮೊದಲ ಮಳೆಯಲ್ಲಿದೆ. ಆಟೋ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಕಚೇರಿ ಬಳಿ ಹೆಸರಾಯಿತು. ಕೃಷ್ಣಸ್ವಾಮಿಯವರು ಕಚೇರಿಯಿಂದ ಆಟೋ ಸ್ಥಳದಿಂದ 608 ಅಡಿ ಆಗುತ್ತದೆ ಎಂದರೆ ನಿಜ. ಪತ್ರ ಬರೆಯುವಾಗ ಆಸ್ತಿಗೆ ಸಂಬಂಧತೆ RTC ಮಾತ್ರ ಒಂದು ಕೃಷ್ಣಸ್ವಾಮಿ ಬಳಿ ಇತ್ತು. ನಿಶಾನೆ P1 ಕಾಗದ ಬರೆಯಪುರ ದಾವಾಸ ಸಂಬಂಧ ಕೇವಲ RTC ಒಂದನ್ನು ನೋಡಿದ್ದೆ, ಬೇರೆ ಯಾವುದೇ ದಾಖಲೆ ನೋಡಿಲ್ಲ. ನಾನು ನೋಡಿದಂತಹ RTC ಯಾವ ವರ್ಷದ್ದು ಎಂದು ನೋಡಿದೆ ಎಂದರೆ ಮರೆತಿದ್ದೇನೆ. RTC ಮೊದಲನೇ ಪ್ರತಿವಾದಿಸಿದ್ದು RTC ಬಿಟ್ಟು ದಾವಾಸ ಸಂಬಂಧಿ ಬೇರೆ ಯಾವ ದಾಖಲೆ ನೋಡಿಲ್ಲ. It is at the instance of the plaintiff, it has been made out the entire recitals of the agreement, my lord, and the defendants were not in that particular place where the agreement was prepared. And further says that, my lord, in the certain markings in the agreement, my lord, ಸಾಮಾನ್ಯವಾಗಿ ಪತ್ರ ಬರಹಗಾರರ ಸಮಕ್ಷವೇ ಪಕ್ಷಗಾರರು ಸಹಿ ಮಾಡೋದಲ್ಲಿ ಯಾರು ಎಲ್ಲಿ ಸಹಿ ಮಾಡೋಕೆ ಗುರುತು ಹಾಕಿಕೊಂಡಿದೆ ಎಂದರೆ ಸರಿ. ಪತ್ರವನ್ನು PS ಕೃಷ್ಣಸ್ವಾಮಿ ಎಂದು ಬರೆದಿರ್ತಾರೆ. Some marking is there, and their marking is has been shown to put a signature wherein the defendants was not there. This is the admission, my lord. My humble submission is that, my lord, the very conduct of the plaintiffs, my lord, waited for 4 years, my lord, at least would have done something with regard to towards the ready and willingness, my lord. My humble
Ready
submission.
and willingness, what is there? Only payable is only 10,000 balance.
That
at the
is
time
my,
of-
that is,
At
that
the
is,
time of
that is,
registration, not before
it is,
that.
it is, that is why, my lord. It is not necessary to wait for such a long period for 4 years, my lord.
It is only a ground.
That is, if there is a condition in the agreement, my lord, if
Hmm.
there is a condition in the agreement that certain document and name of the defendants are be obtained in the kata and other things, my lord, he has waited for that, and for that he has waited and filed the suit, my lord. There is no such conditions. It has to be made out within the 2 years, my lord. My humble submission further, my lord, the comparative hardship.
Documents ಒದಗಿಸಬೇಕಾಗಿರೋದು ಯಾರು?
ಅಲ್ಲ ಅದೆಲ್ಲ ಆಗೋಗಿದೆ.
ತಾನೇ?
ಅಲ್ಲ, it has been, when the agreement was made out, the standing in our name, my lord. And also, in this regard, my lord, the comparative hardship, my lord, the question I would like to submit to your lordship is, the defendant number 4 is the unmarried daughter. The plaintiff and the defendants are the relatives, my lord. It has been admitted. And she is an unmarried daughter, my lord. Still she is not married. And this property was given to her, my lord. And for the meager amount of 75,000, my lord, the consideration amount, my lord. And even the PW2 says that as on the date of the agreement, the 1 gunta was 15,000.
Call for records, no one will see. Then what is your admission will say.
Yes, ma'am.
Call for records. Then I will decide with regard to the limitation.
102,
And list this matter in the second week.
102, P. Ramesh.
102.
In this case. Kindly have this matter next week, my lord. Kindly have this matter next week.
Why?
My senior is engaged in court
Senior is
number 7, my
engaged
lord. 7 ಅಲ್ಲಿ special bench ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗಿದೆ ಸರ್.
Just after summer vacation.
Special bench ಅಲ್ಲಿ.
So appellant counsel seeks time. List this matter in the second week of August.
Much obliged.
103,
Respondents.
Plaintiff second appeal. Suit for partition and separate possession. My lord. Plaintiff, my lord, claiming to be, my lord, the original prepositor one Muniappa. He had 2 wives, my lord, first wife Chikka Hanumakka and second wife Narasamma. Plaintiff is the daughter through first wife Chikka Hanumakka. And the defendants, my lord, they are the children through second wife Narasamma. In the written statement, my lord, the defendant denied the paternity of the plaintiff with Muniappa. And they denied, my lord, Muniappa married Chikka Hanumakka, and out of the said marriage, Muniamma was born. Trial court, my lord, the findings, my lord, the PW2 and PW3 has been examined. In order to establish, my lord, the marriage of the Muniappa with Chikka Hanumakka, they are the elders of the villagers. And during their cross-examination, my lord, they have deposed that, my lord, the Muniappa Chikka Hanumakkan ಮದುವೆ ಆಗಿದಾರೋ ಇಲ್ವೋ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. Since, my lord, they are the adjacent landowners of the scheduled properties. Based on their statement, my lord, the trial court, my lord, since the paternity itself has been denied, and the plaintiff, my lord, they failed to establish the relationship with, she is the daughter born through Muniappa. The trial court dismissed the suit. And the said findings has been confirmed, my lord, the judgment and decree has been confirmed by the first appellate court. Both the court, my lord, having.
Why you have examined the PW2 and 3?
My lord, in absence of the documentary evidence, my lord, she is illiterate. Except, my lord, genealogical tree, my lord, she has not produced any other documents.
Also the admission given by PW2 and 3.
Yes, PW2 and 3, having not taken into consider the, my lord, the other evidence and relevant facts of the examination.
What is other evidence?
My lord, they are the, my lord, they are categorically deposed.
Only joint family property in ತೋರ್ಸಕ್ಕಾರ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ ನೋಡೋಣ PW3 ನೋಡಿ issue number 3 ಗೆ 2 and 3.
ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಒಂದು ಲ್ಯಾಂಡ್ ಆಮೇಲೆ ಒಂದು ಮನೆ ಅಷ್ಟೇ ಇರೋದು. ಮೈ ಲಾರ್ಡ್, ದಿ ಫಾದರ್, ಮೈ ಲಾರ್ಡ್, ಮುನಿಯಪ್ಪ ಡೈಡ್ ಇನ್ ದ ಇಯರ್ 1985. 1985. ಪೌತಿ ಖಾತೆ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಹೆಸರುಗಾಗಿದೆ. ಬಟ್ ದಿ ಫೈಂಡಿಂಗ್ಸ್ ರೆಕಾರ್ಡೆಡ್ ಬೈ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಸ್ ದಟ್, ಮೈ ಲಾರ್ಡ್, ದಿ ಪಾರ್ಟಿಷನ್ ಹ್ಯಾಡ್ ಟೇಕನ್ ಪ್ಲೇಸ್ ಬಿಟ್ವೀನ್ ದಿ ಚಿಲ್ಡ್ರನ್ ಆಫ್ ಮುನಿಯಪ್ಪ. No such, my lord, Parikat has been, my lord, forthcoming before the trial court. They have not produced any documents.
Where is that finding?
My lord, yes.
MR.
MR.
It is not in dispute that social properties originally belongs to Muniappa. ಅಂದ್ರೆ ಮುನಿಯಪ್ಪನಿಗೆ ಸೇರಿದ್ದ ಆಸ್ತಿ.
ಮುನಿಯಪ್ಪನಿಗೆ ಸೇರಿದ್ದು.
ಮುನಿಯಪ್ಪನ ಸೇರಿದ್ರೆ ಅದಂಗ ಆಸ್ತಿ
ಅಲ್ಲ,
ancestral
he
property.
died, my lord, he
ಆಯ್ತ್ರಿ ಡೈಡ್ ಆದ್ರೂ ancestral property ಹೆಂಗ್ರಿ ಆಗುತ್ತೆ ಅದು?
ancestral, my lord, it is not the absolute property of Muniappa. He acquired, my lord, it is the ancestral property of the Muniappa.
ಎಲ್ಲಿದೆ ಅದಕ್ಕೆ ಅದನ್ನೇ ಕೇಳ್ತಾರೆ.
ಅದ್ರ ಬಗ್ಗೆ ಫೈಂಡಿಂಗ್ಸ್ ಏನೂ ಇಲ್ಲ.
ಮತ್ತೆ
The
ಅದೇ
findings,
ಬೇಕಾಗಿರೋದಲ್ಲ.
findings as such has been,
First you have to prove that is an ancestral property.
my lord, the trial court, my
ಏನ್
lord,
ದಾಖಲೆ
having not,
ಕೊಟ್ಟಿದ್ದೀರಿ?
trial court having not gone through this aspect in detail. Since paternity has not been established, my lord, the trial court.
ನೋಡ್ರಿ ಬರ್ತಿದ್ದಾರೆ ಸುಮ್ಮನೆ ಏನು ಹೇಳ್ತೀರ ನೀವು. It is pertinent to note that here it is not in dispute that suit schedule properties originally belongs to ಮುನಿಯಪ್ಪ ಅಂತಿದೆ.
ಇಲ್ಲಿ
ಮುನಿಯಪ್ಪನ್ಗೆ ಅದು ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ ಪ್ರಾಪರ್ಟಿ ಆಗ್ತದೆ. ancestral property ನ ಕೇಳಿದೆ. This is what ink page number 62 ನಲ್ಲಿ ಇದೆ ನೋಡಿ.
Ink page number 61 in the, my lord, para 12 onwards.
ಆಯ್ತು.
The PW1 has deposes that the defendants and herself has constituted the Hindu undivided joint family, and the suit schedule property are their ancestral properties. The defendant and herself has been in joint possession and enjoyment of the suit schedule property. Per contra, DW1 has deposed that after the death of their father, DW1 and himself has inherited the suit schedule properties on 21/7/1985.
ಹೌದು.
The defendant number 2 and herself has got divided the property. They have been in possession and enjoyment of their respective properties. DW2 also deposes in consonance with evidence of DW1. It is pertinent to note here that it is not in dispute that suit schedule property originally belonged to Muniappa. It is, DW1 has produced the certified copy of MR 10 of 8889.
ಅದು ಆಮೇಲೆ ಅವ್ರು ಡಿವೈಡ್ ಮಾಡ್ಕೊಂಡ್ರೆ
ಡಿವೈಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದು IHC ಖಾತೆ ಅದು.
ancestral ಅಂತ ತೋರ್ಸಕ್ ಏನಿದೆ? That's the reason court answered the issue number 3. You have not proved that it is an ancestral property ಅಂತ. Property belongs to the ಮುನಿಯಪ್ಪ ಅಂತಿದೆ ಅಷ್ಟೇ. ಮುನಿಯಪ್ಪ they have succeeded. ನೀವು ಇವನ್ ಮದುವೆಗೂ ಕೂಡ ಆಗಿದ್ಕೂ ಏನು ದಾಖಲೆಯನ್ನು ಕೊಟ್ಟಿಲ್ಲ. You had witness examine
He is aged about, my lord, the section 50 of the Evidence Act, my lord, in absence of the documentary evidence, my lord, the evidence of the, my lord, the witness has to be looked into.
ಹೌದ್ರಿ, ವಿಟ್ನೆಸ್ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಅವ್ರು ಏನ್ ಹೇಳಿದಾರೆ ಆನ್ಸರು? ಮದುವೆ ಆಗಿದ್ದು ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಿದಾರೆ.
ಅದೊಂದು
That is
ಸ್ಟೇಟ್ಮೆಂಟ್.
not their case that they have attended the marriage also.
My lord, the defendant themselves has attended the marriages, and they, for which, my lord, the photographs are also produced.
ಎಲ್ಲಿದೆ ಫೋಟೋಗ್ರಾಫ್? The exhibit P6 to P9 are the
P6 to
photographs
P9,
show
ಹೌದು.
that the defendants have attended the marriage of the sons of the plaintiff.
ಹೌದು.
Sons of the map, ಹೌದು.
Plaintiff, ಅಲ್ಲ,
ಹಾ.
plaintiff aged about 80 years, my lord.
ಹಾ?
Plaintiff herself, my lord, aged about 80 years.
ಈಗ plaintiff ಮಕ್ಕಳು ಕೇಸ್ ಹಾಕಿಲ್ವಾ? ಸನ್ಸ್
ಇಲ್ಲ.
ಮತ್ತೆ ಯಾಕೆ?
ಅಲ್ಲ, it is the
ಕ್ಲೈಮ್ ಮಾಡಿದ್ರೆ she is the wife of the ಮುನಿಯಪ್ಪ.
ಅಲ್ಲ, she is the daughter of Muniappa through first
ಯಾರು?
wife, Muniamma.
ಮುನಿಯಮ್ಮ is the
Daughter of one Muniappa through first wife.
ಆಯ್ತು. ಇದು ನೀವು ಫೋಟೋಗ್ರಾಫ್ಸ್ ಹಾಕಿರೋದು ಆಕೆ ಮಕ್ಕಳ ಮದುವೆ
ಆಕೆ ಮುನಿಯಮ್ಮನ್
ಬಂದಿದ್ರು ಅಂತ
ಹೌದು
ಅಷ್ಟೇ.
ಹೌದು.
ಹಾ, ಮತ್ತೆ ಈ ಪ್ಲೇಂಟಿಫ್ ನ ತಾಯಿ
Plaintiff mother, in order, yes,
ಚಿಕ್ಕವನ ಮಕ್ಕ ಇವ್ರ ಮದುವೆ ಆಗಿತ್ತು ಅಂತ ತೋರ್ಸಕ್ ಏನಿದೆ ದಾಖಲೆ? ಹೋಗ್ಲಿ, ಈಕೆಗೆ ಏನಾದ್ರು ದಾಖಲೆ ಇದೆಯಾ?
80 years back, my lord, they have not.
ಆಯ್ತ್ರಿ, ಏನಾದ್ರು ಸ್ಕೂಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಥವಾ ಅದರ ಏನಾದ್ರು ಇದೆಯಾ?
ಇಲ್ಲ, ಅದೇನು ಕೊಟ್ಟಿಲ್ಲ.
ಪ್ರೂವ್ ಮಾಡಕ್
My
ಏನಿದೆ?
lord, in order, genealogy has been produced, genealogy tree, my lord, has been produced, the issue by the one,
ಮಾಡ್ಕೋಬಹುದು. ಯಾರ ಮಕ್ಳು ಯಾರಿಗೆ ಯಾರ ಮಕ್ಳು ಅಂತ ಹೇಳ್ಬೋದು.
ಪ್ರಿಪೇರ್ ಮಾಡಿದ್ರು.
ಏನಿದೆ ದಾಖಲೆ ಏನಿದೆ? Plaintiff that Chikkanmappa is the wife of Muniappa due to their wedlock.
may I request, my lord, the records of the,
any material.
ಅಲ್ಲ, records of the trial court kindly call for, my lord.
ಏನಕ್ಕೆ ಕಾಲ್ ಫಾರ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ, ನೀವು ಇಲ್ಲಿ ತೋರಿಸಿ.
My lord, the evidence of the PW2 and PW3, my lord, it is the relevant witness, my lord. The
evidence is very clear.
ಮದುವೆ ಆಗಿಲ್ಲ ಅನ್ನೋದೊಂದು ಬಿಟ್ರೆ ಬೇರೆ
ಇನ್ನೇನ್ ಬೇಕು?
so far
ಬೇರೆ
as the other
ಮದುವೆ
facts-
ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ ಮಕ್ಕಳು ಅವರಿಂದೆಲ್ಲ ಆಯ್ತು ಅನ್ನೋದಕ್ಕೆ ಏನು ಹೇಳಕ್ಕಾಗುತ್ತಾ? ಹೋಗ್ಲಿ, ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ ನೋಡಿ. Next.
Para 14 ಅಲ್ಲಿ, in the affidavits and wakalat of the appellant made thumb impression and record shows that since September 2022, appellants being an illiterate conducting litigations, hence have inferred that irrespective of the truthfulness in the question tendered by the delay, ಇದು delay ಮೇಲೆ
Adding only the delay, Swami. Delay ಆಗಿತ್ತು.
ಅಪೀಲ್ ಫೈಲ್ ಮಾಡೋದ್ರಲ್ಲಿ ಡಿಲೇ ಆಗಿತ್ತು. ಈ ಫೈಂಡಿಂಗ್ ಏನ್ ಓದ್ತಾ ದಟ್ಸ್ ರಿಗಾರ್ಡಿಂಗ್ ಓನ್ಲಿ ಡಿಲೇ. ಅದ್ರಲ್ಲಿ ಮೆರಿಟ್ ಬಗ್ಗೆ ಏನ್ ಹೇಳಿಲ್ಲ. ಡಿಲೇಗೆ ನಾವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿರ್ಲಿಲ್ಲ, ಅದರಿಂದ ಅದು ಅಲೋ ಆಗಿತ್ತು.
Especially the oral evidence of PW 2 and 3 and the contents of the genealogy marked as Exhibit P1, the requested to allow the appeal, holding that the plaintiff is the sister of defendants and allot 1/3 share.
ಏನ್ ಇಲ್ರಿ, nothing. Heard this matter is listed for admission. I heard the counsel appearing with the appellant and also the counsel for the respondent. The factual matters of case of the plaintiff before the trial court while seeking the relief of partition. It is contended that
I may be permitted to take leave.
she is the daughter of late Muniappa.
With your lordship and permission.
Through his first wife.
Permitted to take leave. I may permitted to take.
My colleague. His first wife, Srimati Chikka Hanumakka. And also it is her claim that defendants are the members of Hindu joint family along with her. And also it is the contention that suitable properties are the ancestral and joint family properties, and hence he is entitled for partition and separate possession. The defendants have denied the very relationship between the plaintiff and defendant, and also contend that property exclusively belonged to the Muniappa, and after the death of Muniappa, they inherited the property and not placed any material to show that property is ancestral properties. The trial court, having considered the material on record, comes to the conclusion that no dispute with regard to the fact that property belongs to the Muniappa. And in order to prove the fact that property is an ancestral property of the plaintiff and defendants, no material is placed before the court. And even with regard to the proving of the fact that she is the daughter of the said Muniappa, though examined PW 2 and 3, and they claimed that two wives to said Muniappa, that is Chikka Hanumakka and Narsamma, categorically admitted in the cross examination that they are not aware of the marriage between Muniappa and Chikka Hanumakka. And similarly, PW3 also stated that he is also not aware of the marriage between the Muniappa and Chikka Hanumakka. And taking into note of this admission, the trial court comes to the conclusion that relationship has not been established, and also comes to the conclusion that property is not an ancestral property, and dismiss the suit. Being agreed by the said judgment and decree, an appeal is filed in RA number 267 of 2020. And first appellate court also, having considered the grounds urging the appeal memo, framed the point for consideration whether the appellant made out sufficient ground to whether the appellant made out sufficient ground to interfere in the impugned judgment and decree. And first appellate court, having taken note of the material on record, particularly while answering the point number 2, taken note of the material placed before the court, and no document is placed before the court to establish the relationship between the Muniappa and Chikka Hanumakka. And only relied upon the evidence of PW 2 and 3, and PW 2 and 3 also not insofar the confidence of the court that they were aware of the marriage of between both of them. And when such material is found, only genealogical tree is also produced, and the same will not prove the factum of relationship between the parties unless documents are produced. Only exhibit P6 to 9 are produced to show that defendants have participated in the marriage of the sons of the plaintiff. But in order to prove the relationship between the Muniappa and Chikka Hanumakka, no document is placed. Apart from that, properties are also the exclusively belongs to the Muniappa. And when such being the case, I do not find any error committed by the trial court and first appellate court and both first appellate court and trial court having considered the material on record, particularly admission on the part of PW 2 and 3, comes to the conclusion that relationship has not been explained, a relationship has not been established, as well as property belongs to the joint family is also not established, the same, and hence dismiss the suit. The counsel appearing for the appellant in this argument, he vehemently contend that both the courts failed to take note of the oral evidence produced before the trial court, and also failed to note that the social properties are the joint family properties of the plaintiff and defendant. And exhibit P 1 to 14 are relied upon by the plaintiff, and those documents are not considered in a proper perspective, and hence counsel prays that this court to admit and frame substantive question of law, whether the trial court and first appellate court is justified in coming to the conclusion that the plaintiff is not the daughter of Chikka Hanumappa and Muniappa, in spite of PW 2 and 3 have been examined before the court. The counsel appearing to the respondent would vehemently contend that both the trial court as well as the first appellate court having considered the material, that too, the burden is on the plaintiff to prove the relationship and no material is placed, and even examination of PW 2 and 3 also not helpful to the evidence plaintiff to establish that she is the daughter of Muniappa and Chikkanmakka, and hence no grounds are made out to admit and frame substantive question of law. Having heard the appellant counsel and also the counsel appearing to the respondent, it is a specific case of the plaintiff that she is the daughter of Chikkanmakka and Muniappa through the, and he said Chikkanmakka is the first wife of the said Muniappa, and in order to prove the factum of she is the daughter of both of them, no material is placed before the court except examining the PW 2 and 3, and PW 2 and 3 also categorically have stated that they were not aware of the marriage between the Chikkanmakka and Muniappa. And when such evidence is placed before the court, both the courts have not committed any error in coming to the conclusion that relationship has not been established. With regard to the properties, also a joint family property is concerned, no document is placed and the property belongs to the Muniappa, and after the death of Muniappa, defendants inherited the property, and in order to prove that the property is an ancestral property, also no such document is placed, and hence trial court and the appellate court also comes to the conclusion that the plaintiffs are not established that inherited properties are the ancestral properties of the plaintiff and defendant. And when such material is considered by the trial court and also the first appellate court, I do not find any error committed by both the courts with regard to the material on record, and no perversity is found, and hence no ground is made out to admit and frame substantive question of law. In view of the discussions made up by Possible and God, second appeal is dismissed.
104 actual 105.
Millards, I appear for the appellant, Millards. Millards, I'm filing the exhibit P series marked by the plaintiff, Millards. This is suit the plaintiff second appeal, Millards. Suit for possession based on title, Millards. Suit schedule property is a plot bearing site number 120, Millards, allotted by Muda in favor of the defendant, Millards. Subsequent to allotment of the site by the Mysore Urban Development Authority in favor of defendant, possession was handed over to defendant, Millards. The defendant executed a registered sale deed dated 18/7/2003, Millards, which is marked as exhibit P9, Millards. Accordingly, a consideration of 93,000 was received and the possession was handed over to the plaintiff, Millards. As per exhibit P9, para number 13, the same recitals are admitted, Millards. Now, both the courts below, Millards, without considering the registered sale deed, as per exhibit P9, without taking into consideration section 91 and 92 of Indian Evidence Act, give a contrary finding that the defendant has not proved her title, hence her execution cannot be contended. Para 19 may kindly be seen, Millards. internal page 54.
Hmm.
Internal page 54, para 19, my lords.
Yes.
Thus from overall, my lords have it.
Yes, yes.
Thus from overall consideration of the materials placed before this court, it appears that plaintiff failed to establish that the defendant possessed title with respect to the suit schedule property, and hence the execution of sale deed at exhibit P9 becomes invalid. Well, subsequent to execution of sale deed, in the year 2005, the defendant also, in order to grab the property, for the reason that the plaintiff is not a localite and is a resident of Kolar district, she files even a complaint also, my lords. That complaint under 407, 420, and that B report comes to be filed, which is at exhibit P8, my lords.
Is it your case that they have dispossessed you?
Please, my lords, the suit is for possession based on title, my lords.
Possession. When the sale deed was executed in favor of you, possession was delivered to you.
Please, my lords, please, my lords.
Then while seeking the relief of the possession, is there any pleading that you have been dispossessed?
Please, my lords, please, my lords.
Very same vendors have encroached your property.
Please, my lords, please, my lords. Exhibit P9, my lords. My lords, and also both the trial court, my lords, and the first appellate court, paras might be seen, my lords. They come to a conclusion, they support my case, my lords. But then at the end, in the last two paragraphs, they go against me, my lords. First appellate court also, the order internal page 31, my lords.
Yes.
Please, my lords. Internal page 31, my lords. All my contention are accepted by the first appellate court, my lords. My lords may see para 19 even in the RA 165 2021, my lords. Para 31. Here it is, may I read, my lord? Here it is very important to note that the present suit was filed before the trial court on 3/8/2012. The sale deed is marked as exhibit P9, which is dated 18/7/2003. The exhibit P1 to P are in the name of the plaintiff. Exhibit P1 is a Uttara Patra issued by Muda in the name of plaintiff. That is after the execution of the sale deed, my lords. He has been paying Kandayam in respect of the suit schedule property. It is pertinent to note that exhibit P4, P5 are encumbrance certificate. They reveal that site number has been executed by Secretary Muda Mysore in favor of Putta Chikkamma, my lords. Defendant later, as per exhibit P5, the defendant Putta Chikkamma had executed a sale deed in favor of the plaintiff. That is said, these documents are issued by the sub-registrar Mysore North. Exhibit T10 is the transfer certificate of Tahsildar Muda so and so. These documents clearly reveal that as per sale deed dated 18/7/2003 executed, the revenue documents have been changed in the name of the plaintiff. Further, the plaintiff has been paying Kandanam in respect of the suit schedule property. But the contention of the defendant is that she had not at all executed the said sale deed in favor of the plaintiff, my lords. In the cross-examination, she has denied the thumb impression on exhibit P9. Further, she has also denied the photo affixed on the sale deed is of her. Plus, section 91 and 92, when a registered document, she cannot go contrary to the recitals, my lords. Further, she has also denied know who had given information to file affidavit in lieu. She has admitted that the shoot schedule property was allotted to her and the Muda had handed over the possession of the same to herself. My lords, it is not even the case of the defendant that she has not been conveyed the property. That the trial court goes one step ahead and says that since the defendant did not have the title, she could not have executed the sale deed, my lords. My lords, next para number 20, as rightly argued.
Is it your case that property is allotted by Muda in favor of you?
No, my lords, it's not allotted in favor of me. It is allotted in favor of defendant in the year 1987, my lords. She is the absolute owner of the property. Being the absolute owner of the property, she executed a sale deed in my favor. Now, my lords, both the first appellate court and the trial court, they say that the defendant has not proved her title as being the owner of the property, my lords. Now, in para number 20, my lords, in the regular appeal, as rightly argued by the learned counsel for the appellant, even though she has denied her signature on the sale deed, in a written statement, she has taken the contention that that Mysuru ನಗರವಿದ ಮಂಜೂರಾದ ದಾವೆ ಸ್ವತ್ತಿನ ನಿವೇಶವನ್ನು ವೈದ್ಯ ವ್ಯಕ್ತಿಗಳಾದ ವಾದಿ ಮತ್ತು ಮೋಸದ ಅಹಮದ್ ಮರಿಸಿದ್ದಯ್ಯ. This particular complaint a B report comes to be filed, my lords, on this complaint. Thus, now the first appellate court goes on to hold that, thus the defendant had admitted the execution of the sale deed in the written statement. My lords, once there is admission.
But even first appellate court comes to the conclusion that the very title of the defendant is defective.
Please,
No.
my lords, on the ground that, my lords, on the ground, my lords may come to para number 22, my lords.
Muda has not issued the same in favor of the defendant, but still the
Please,
plaintiff obtains
please,
the
now,
statement of the
please,
defendant.
my lords. My lords, now exhibit P4 may kindly be perused.
What is that document, exhibit D4?
P4, my lords. The defendant have not produced one single document, my lords. Exhibit P4, my lords. I have given a, my lords, my colleague is handing over the
Yes.
exhibit P series, my lords.
Yes, hand it over.
Please, my lords, please. My lords may straight away come to.
What is the document
Exhibit P.
issued by Muda in favor of you? In favor of your vendor?
My lords, that is at exhibit P6, my lords. Exhibit P8, my lords.
Secretary Muda Mysore.
Please, my lords. Exhibit P8. Put a Chikkama, that is the Khata certificate. And also there is a lease cum sale agreement, my lords, which is shown in exhibit P4.
Lease cum?
18. Exhibit P4, my lords. Internal, I have marked page number, my lords, 5. Page number 5, my lords. In 1991 itself, the Muda has allotted this particular site to defendant.
Exhibit P4 is only an encumbrance certificate.
Please, my lords, in the encumbrance certificate.
Where is the lease cum sale agreement in favor of you, your vendor?
Please, my lords, that I have produced, my lords. It was not produced before the honorable.
No such document is produced.
No, my lords, that even an issue to that extent was not framed, my lords, that whether the defendant, even the Muda has, the defendant is not the owner. No such issue was framed, my lords.
My
lords, there is Khata also. Exhibit P8 is the Khata.
Anyhow, call for records, issue notice.
Please. My lords, now they should not further alienate, my lords. Any which way, I have filed IA number 2 for stay of the, because my whole.
2 of 24 for temporary injunction, and both the courts comes to the conclusion that plaintiff has not established the title as well as possession. However, there is a recital, there is a sale deed executed by the vendor of the appellant, and also produce the documents, and having considered these documents, it is appropriate to grant the temporary injunction restraining the defendant from alienating the property, and if it is alienated, it will lead to multiplicity of proceedings, and hence TI granted till next state of hearing.
I'm grateful, my lords. Obliged.
106.
Yes, Prakash.
My lord, I am for that. It is the defense appeal. Suit is for injunction, my lord. It is an agricultural land.
Yes.
The trial court has rejected the plaint, my lord, by invoking Order 7 Rule 11D, my lord. Since the tenancy is involved in the matter, when the suit was filed, the tenancy matter was pending before the land tribunal, my lord, Sagar. During pendency of the appeal, it was granted in my favor, my lord, in favor of the defendants. That has been challenged before this honorable court in writ petition. That matter is pending. However, the plaintiff assailed the same of rejection by filing a regular appeal 10047 of 2022. That has been allowed and matter has been remanded back to for trial, my lord. Therefore, I come before this honorable court.
Issue notice.
The position of law is very clear, my lord.
Issue notice only Order 7 Rule 11. Whatever the material is placed before the trial court, you place it before the court. No need to call for records.
My lord, I starting interim order.
Interim ಏನು ಕೇಳಿದಿರಿ?
Stay of the.
ಏನು stay ಮಾಡಬೇಕು?
Stay of the proceedings. ಅದು impugn judgment ಏನಿದೆ? It has been allowed.
ರಿವರ್ಸ್ ಮಾಡಿದಾರಲ್ಲ ಈಗ. ಆಯ್ತು. Heard on IA number 1 of 23.
ಹೌದು. ರಿಲೀಸ್ ಆಗಿತ್ತು. It was rejected. The proceedings in it. Yes. Karnataka Land Reform 133 is very clear, my lord. The suit is barred when a tenancy matter is pending before the appropriate forum.
Heard on A number 1/23 and trial court allowed the IA filed under Order 7 Rule 11D of CPC, and the same has been reversed
11D.
by the first appellate court. And counsel would submit that in view of reversing of the judgment of the trial orders passed by the trial court, there is a chances of continuing of the proceedings before the trial court, and hence and this court has issued notice against the respondent, and hence it is appropriate to stay the order passed by the first appellate court in the next date of hearing.
Oh, please.
107 adjourned, 108 KV Narasimhan.
My lord, I appear, my lord, in 108.
Yes,
Lord,
counsel.
yesterday I have filed an application, my lord, for production of additional evidence
Hmm.
for production of the sale deed.
Yes.
My lord, that is not, my lord, put up. Earlier, the one, my lord, has been put up.
ತಂದ್ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ ತಂದ್ಕೊಟ್ಟಿದ್ದಾರೆ.
ಒಂದ್ ಸ್ವಲ್ಪ ಒಂಚೂರು ಮಿಸ್ಟೇಕ್ ಏನಾಗಿದೆ, ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ನನ್ನ ಹತ್ರ ಉಳಿದ್ಬಿಟ್ಟಿದೆ, ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಅಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಐ ವಿಲ್ ಓನ್ಲಿ, ಮೈ ಲಾರ್ಡ್,
ಏನ್ ಟೈಮ್
ಪ್ಲೀಸ್
ಬೇಕೇನ್ರಿ?
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್
Appellant counsel seeks time. This matter in the second week of August.
ಪ್ಲೀಸ್.
109.
Appellant by me. The conflicting judgment. The suit for partition in separate possession filed by the respondent 1 to 3 in respect of the suitable property, contending that the suitable property is the ancestral property of the plaintiff, and sought for declaration the revenue entry stood in the name of the appellant is null and void, and the sale was executed by the one Mariam Muniamma, who is the none other than the sister of the plaintiff, is null and void. The case of the plaintiff, to establish the rights, she has not even produced a single document to show that the property, suitable property is the ancestral properties. On page 11 of the judgment of the trial court may kindly be seen, Lord. Page 15, Lord. Ink page 75. Judgment page 13. Paragraph 15. The plaintiff's pleadings have categorically stated the suitable property is their ancestral property. The plaintiff have got marked the exhibit P4, P6, RTC extract pertaining to the survey number 93, 97 and 119 respectively. But the plaintiff have not got the marked the RTC extract pertaining to the suitable properties. Though the plaintiff have stated suitable property is the ancestral property, but they have not produced any revenue document to show that the said property was the standing in the name of the father of the Chiksiddaya, Javregoda alias Javregoda, or grandfather or great grandfather of the.
Issue notice, call for records.
They filed the FDP, Lord. FDP is pending. FDP number
PP ಬರೀ ಇದು
13/24 is.
ಇನಿಷಿಯಲ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ?
ಇಲ್ಲ, notice has been issued.
ನೋಟಿಸ್ ಮಾತ್ರ
ಅಲ್ಲ, ಅದನ್ನ ಸ್ಟೇ ಮಾಡ್ಬಿಟ್ಟಿಲ್ಲ ಅಂತಂದ್ರೆ they are trying to dispose.
Nothing
No,
will
Lord,
happen.
they're trying to dispose it in the land in question in view of the.
Matter in the first week of August.
In the meanwhile, the kindly redact. Allah, status quo may be continued because. Allah, status quo in the respect of the possession is concerned because I am in the possession. They are trying to dispose it in land.
FDP ಇದ್ರೆ FDP ನಾಳೆನೆ ಡಿಸೈಡ್ ಆಗಲ್ಲ. ಹೋಗ್ ಬರ್ಲಿ ನೋಟಿಸ್. ಆರ್ಡರ್ ಮಾಡಿದೀನಿ, ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಮಾಡಿದೀನಿ. ನೆಕ್ಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನೋಡೋಣ. ಮೆರಿಟ್ ಇದ್ರೆ ಕನ್ಸಿಡರ್ ಮಾಡೋಣ.
Please.
110.
Place for 1 week time.
Why counsel? Why you want time?
Not ready. Next week.
Concurrent finding, dismissed to confirmed. Why you want time? First time anodi madam? 24 matter alla? Right, appellant counsel seeks time, list this matter in second week of August.
111.
Divergent finding, Your Lordship.
Appellant is the sixth defendant in the original suit, Your Lordship. This case,
Earlier it was dismissed.
allowed, sorry, dismissed, sorry, Your Lordship, sorry, Your Lordship. It was allowed.
For respondent.
Your Lordship, in this case, Your Lordship, in this case, the case of the plaintiff is that their father is a foster son of one Mr. Venkataramaya, and he had purchased one property on 15/11/1950, Your Lordship. Then later, the children of Venkataramaya had sold the property in one property to this defendant on 17/6/1983. And with respect to fourth defendant on 15/10/1986, and to fifth defendant on 19/11/1986, Your Lordship. In this case, the fourth and fifth defendant have already formed the sites. It is converted to non-agriculture, formed the sites. And in this property, already one petrol bunk is running. And the National Highway Authority has acquired some portion of the land. Now the present petition is running a brick factory. Now in 2014 to 2007, after 24 years, they file a case that they are the co-owners. They are seeking partition and declaration that these sale deeds are not binding on in them, Your Lordship. But subsequently, they have sold the
Deeds are executed by whom?
By may I request Your Lordship to the Vamsharuksha, which is at page number 116, Your Lordship. Your Lordship, the Venkataramaya was the original owner, and the Munitayamma idaralla. Ikkada said, our makkadu they have executed the sale deed, Your Lordship. They have executed the sale deed in favor of first, fourth, fifth, and sixth defendant, and they subsequently have sold the properties, Your Lordship. And the Honorable Trial Court had held that they are unable to prove that they are the foster son of Chikkaramappa. Sorry, may I request again to this. The defendants herein, the plaintiffs herein are Chikkaramappa antidaralla, our maklu. They are the plaintiffs, Your Lordship. They are the plaintiff. The Honorable Trial Court may request Your Lordship to page number 84. The Honorable Trial Court had held that they did not prove they are the foster son of that late Chikkaramaya. And may I request Your Lordship to page 84, Your Lordship. In this regard, last line, Your Lordship. In this regard, the plaintiffs could have examined those contemporaries of the father Chikkaramappa to show that when was Chikkaramappa fostered son by Venkataramaya and at what age. Section 50 of the Indian Evidence makes it clear that how the family relation is also a fact of fostering has to be proved. Now I skip that, Your Lordship. Fifth line. Moreover, this limited evidence of Pidal cannot show that his father was fostered. And Kannadallide, Nishani P Nanu Heli Baresilla, Nishani P ಬಗ್ಗೆ ನನಗೆ ಏನು ಗೊತ್ತಿಲ್ಲ. Nishani P2 is the family tree. Your Lordship, they have produced only 4 documents. That 3 documents is pertaining to sale deed of 1950. Your Lordship, exhibits nodre tavu.
And why the first appellate court?
First appellate court has held it. First appellate court had held that reversing the judgment that they are the co-owners. They are the fast ಇಲ್ಲಿ ವಂಶವೃಕ್ಷದಲ್ಲಿ ಬರುತ್ತಲ್ಲ. They are foster son. They are co-owners of the property, and they are to be parties to the sale. That's what the Honorable Appellate Court, First Appellate Court held, Your Lordship. May I request, Your Lordship? Page number 38.
Call for records. Record ಬಂದಿಲ್ಲ ಮೇಡಮ್?
ಬಂದಿಲ್ಲ ಇವತ್ತು.
Call for records.
Your Lordship, entry model, Your Lordship.
Entry ಮಾಡ್ರಿ ಏನ್ ಕೇಳಿದ್ರಿ?
To stay the Appellate Court judgment, Your Lordship.
ಏನಾರ ನೀವು FDP ಏನಾರ ಹಾಕಿದೀರಾ?
ಇಲ್ಲ, ಏನು ಹಾಕಿಲ್ಲ.
ಹಾಕಿಲ್ಲಲ್ಲ?
ಏನು ಹಾಕಿಲ್ಲ.
Your Lordship,
ಹಾಕಿಲ್ಲ ಅಂತ್ರಿ ಅವ್ರು FDP ನೇ
ಹಾಕಿಲ್ಲ.
ಸ್ಟೇ ಏನ್ ಮಾಡ್ಬೇಕು? List this matter in the 3rd week of August.
Much obliged.
112. Nishit Hegde.
Non-furnishing of PF corporation.
Appear for appellant.
Appear
for appellant. PF ಕೊಟ್ಟಿರಲಿಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಡಿಸ್ಮಿಸ್ ಇಟ್ಟಿದ್ರು.
The appellant is absent. 1 week time is granted to pay PF to issue notice.
PF ಕೊಟ್ಟಾಗಿದೆ ಸ್ವಾಮಿ ನಿನ್ನೆ. PF ಕೊಟ್ಟಾಗಿದೆ ಸ್ವಾಮಿ ನಿನ್ನೆ.
ಯಾವಾಗ?
ನಿನ್ನೆ ಕೊಟ್ಟಾಗಿದೆ. ನಿನ್ನೆ yesterday.
ನಿನ್ನೆ ಕೊಟ್ರಾ?
ಹಾ.
Counsel submits that he has paid the PF yesterday, and hence issue notice against the respondent.
113 absent, 114. Excellent, sir.
I am appearing for appellant, small lordship, in
Yes, counsel.
114.1, 114, lordship.
14.
ಅದರಲ್ಲಿ
MC Basuraj. You are MC Basuraj.
114 and of 2001 to .12.
First appeal ಯಾರ್ದ್ರಿ?
First appeal is ours, H&M Prasad.
425 man.
ನೀವು ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲ? ಗಿರೀಶ್ ರಾಜ ಯಾರು ಇನ್ವಾಲ್ವ್?
I am the colleague of H&M Prasad.
Those appeals are wrongly clubbed.
Wrongly clubbed.
Matter is RSA 5 of 2020. Instead of RSA 19 of 5 of 19 has been
ಡೀಲ್ ಅಂಕ ಇರೋದು ಹಂಗ
ಅದ 5 of 2020 ಆಗಬೇಕು.
5 of 2020 ಲಿಂಕ್ ಆಗ್ಬೇಕಿತ್ತು, ಅದು 5 of 19 ಲಿಂಕ್ ಆಗಿರೋದೆಲ್ಲ
RSA 5 of 2020.
ಈಗ ಒಟ್ಟಿಗೆ 3 ಇದೆ.
ಇಲ್ಲ 3 ಇದೆ, 3ರಲ್ಲಿ ಒಂದು ಮಾತ್ರ 425 is correct. ಕರೆಕ್ಟ್. ಇವೆರಡು ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟವಲ್ಲ, ಸಂಬಂಧಪಟ್ಟಿದ್ದಲ್ಲ. ಇನ್ನೊಂದು RSA 5 of 2020 ಅಂತ ಇದೆ, ಅದು ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಇದಕ್ಕೆ 425 ಗೆ.
ಹೌದಾ? 14.5 ಓ ಅಲ್ಲಿವರೆಗೂ ಇದೆಯಾ?
ಅದು
ಇದು ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ,
ಮಿಸ್ಟೇಕ್ ಆಗಿ ಲಿಂಕ್ ಇದಾಗಿದೆ ಸರ್, ಕ್ಲಬ್ ಆಗಿದೆ.
5 of 19 ಆಗಿದೆ.
ಕೇಳಿ
ಈಗ 0.1 ಇಂದ
RSA 425 ಗೆ 2013 ಇದೆಯಲ್ಲ, ಅದು ಕನೆಕ್ಟ್
5 of 20 ಕ್ಲಬ್ ಆಗ್ಬೇಕು.
5 of 19 ರೀ.
ಇಲ್ಲ ಇದು ಅದು ರಾಂಗ್ ಆಗಿ ಇದಾಗಿದೆ, ಅದು 5 of 20 ಆಗ್ಬೇಕು.
5 of 20 ಆಗ್ಬೇಕು.
ಪ್ಲೀಸ್ ಬರೋ, ಪ್ಲೀಸ್.
ಅದೊಂದೇನಾ?
ಹೌದು, ಅದು ಸೇಮ್ ಪಾರ್ಟೀಸ್.
ಈ 6 of 19
ಅದು ಯಾವುದು ಸಂಬಂಧಪಟ್ಟಿದ್ದಲ್ಲ
ಸ್ವಾಮಿ.
ಇನ್ನು ಉಳಿದವ ಯಾವ್ದು ಸಂಬಂಧಪಟ್ಟಿದ್ದಲ್ಲ.
ಇದು ಯಾವ್ದು ಸಂಬಂಧಪಟ್ಟಿಲ್ಲ. ಇದ್ರ ಜೊತೆಗೆ ಲಿಸ್ಟ್ ಆಗಬೇಕಾದ್ರೆ ಓನ್ಲಿ 5 of 20.
5 of 2020.
ಪ್ಲೀಸ್ ಮಾಡಿ.
The office is directed to D-Link. RSA 2338 of 2018 from this RSA 425 of 2013, and the registry is directed to connect RSA 5 of 2020 with RSA number 425 of 13. ಹೌದಾ?
Please madam, please.
List the matter for final hearing.
And one more submission. This RSA 420
D-Link ಆಗ್ತದೆ ಇವೆಲ್ಲ ಮೋಸ್ಟ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಇರ್ಬೇಕು. 100 and 100 and 100.2 ಇವೆಲ್ಲ ಇದು ಕನೆಕ್ಟೆಡ್ ಇರುತ್ತೆ ಮೇಡಮ್. ಅವೆಲ್ಲ ಕನೆಕ್ಟ್ ಆಗಿದೆ. ಬೇರೆದೆಲ್ಲ ಇದೆಯಲ್ಲ ಮೇಡಮ್, ಇವೆಲ್ಲ D-Link ಆಗ್ತದೆ. List the matter in the second week of August.
And one more submission.
ಹೇಳಿ.
This 425 RSA 425 of 2013. This appellant is no more. I think they have not brought the LRs on record.
H&M Prasad advocate are.
ಸ್ವಾಮಿ ಇವತ್ತು ಇಂಟಿಮೇಷನ್ ಕೊಟ್ಟಿದ್ದೀವಿ. I may be permitted to 1 week
to bring the second appeal is filed by the LRs in the year 2020. But 425 they have not in the LRs.
Brought the LRs.
Brought the LRs.
1 week time accommodation.
2020 13 ಹೆಂಗ್ರಿ ಇದು? ಫಸ್ಟ್ ಅಪೀಲ್ 2013
ಅಲ್ಲ, ಒಂದು ಇದು ಸೂಟ್ ಫಾರ್ ಇಂಜಂಕ್ಷನ್ 425 of 2013 is filed by me for bare injunction.
ಆಯ್ತು. ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇನ್ RSA 425 of 2013 submits that it is learned that first appellant is no more. ಹೌದಾ? And hence appellant counsel is directed to bring the LRs of appellant within 2 weeks.
Already in record in 5 of 22.
ಇರ್ಲಿ, ಅದು ಆಮೇಲೆ ನೋಡೋಣ. ಅದಕ್ಕೆ ಸರಿ.
115 IAPF for the appellant.
ಬರ್ಲೇ ಅಲ್ವಾ ಈ MC ಬಸವರಾಜು ಈ ಕೇಸ್ನವ್ರು ಬರ್ಲೇ ಅಲ್ವಾ?
For the respondent, but
YKN Sharma, Vaishali Hegde.
For the respondent.
In fact, I have given the copy to the other side. Last time ಸಿಕ್ಕಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು, ಕೊಟ್ಟಿದ್ದೀನಿ.
ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ as per ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಏನು ಆರ್ಡರ್ ಇದೆ ನೋಡಿ.
ಅಮೆಂಡ್ಮೆಂಟ್
ಮಾಡಿಲ್ಲ ಅಂತ 12/6 ಅಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ, ಅದು ಅಮೆಂಡ್ ಮಾಡಿಲ್ಲ ಅಂತ.
ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿರ್ಬೇಕಲ್ಲ, ಕಾಪಿನೂ ಕೊಟ್ಟೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಅವರಿಗೆ.
Appellant counsel is given another 1 week time to amend the cost title in terms of the order dated 12/6/24. List this matter in the second week of August. Great.
160 Udika Ishwar.
VP Gokul for R1. ಏನು ಇಂಜನ್ ಡಿಕ್ಲರೇಷನ್?
ಹೌದು.
ಎಷ್ಟೊತ್ತಾಗ್ತದೆ?
1 hour ಬೇಕು. 1 hour ಬೇಕು. 1 hour ಬೇಕಾದ್ರೆ.
1 hour ಬೇಕಾ? Because
I have been in possession the power of attorney holder of the claim.
Time list this matter in second week.
117 and 118.
18 adjourn ಆಗಿದೆ.
119.
Non-filing of Wakalat by Madhusudan Rao.
I appear for the respondents, my lord. I have filed the wakalat on 11/6, my lord. I'll just check once again, my lord. 11/6, I have filed wakalat. I'll have to get it checked once again, my lord. As per my knowledge, I have got the presentation form.
That he has filed wakalat for R1C and D on 11/6 and hence. Only filed wakalat on behalf of R1A, B and E matra ide.
And ಅವ್ರಿಗೆ ಬೇರೆಯವರಿಗೆ ನಾನು ಹಾಕಿದ್ದೀನಿ ವಕಾಲತ್ತು.
ಹಾಕಿದಿರಾ and hence registry is put up the same. ಇವರು ಇದಾರ ಯಾರು appellant counsel ಇದಾರ?
Applying for the appellant, my lord.
Appellant for want of time list this matter in the second week of.
The short point is involved, my lord. Question is whether
So we have to look.
order 2 rule 2 would apply or not, that's all.
First week ಆಗ್ಬೋದಾ?
ಆಗ್ಬೋದು ಸ್ವಾಮಿ.
My lord, second week, my lord. First week, some inconvenience, my lord.
ಆಯ್ತು.
Before that.
Second week.
20.
Sir, I am appearing for appellant, my lord. I am ready.
Respondent, my lord. Senior is not keeping.
My lord, defendant's appeal, my lord.
Appellant counsel ready, respondent counsel not ready. For want of time, list this matter in second week.
Date my individual, my lord.
Second week ಕೊಟ್ಟಿದ್ದೀನಿ. In case ನಂದೇ ರೋಸ್ಟರ್ ಕಂಟಿನ್ಯೂ ಆದ್ರೆ ಬಂದ್ ಮೆನ್ಷನ್ ಮಾಡಿ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ಕೊಡಿ.
ಆಗ್ಬೋದು.
121 ಗೋಪಾಲಕೃಷ್ಣ ಮೂರ್ತಿ.
This matter I am for the
appellant. ಇಬ್ರು ಇದೀರಾ?
I'm appear for appellants in connected matter.
Connected ಅಲ್ಲ ಇದಾರಲ್ಲ both counsels are present for want of time list this matter on second week. Please.
22 adjourn 123 ಅಮಿತಿಯ ಮಂಡಗಿ R ವಿಜಯ್ ಕುಮಾರ್.
ಇವ್ರು ಬೆಳಗ್ಗೆ ಏನು ಟೈಮ್ ಕೇಳಿದ್ರೆ ಮಂಡಗಿಗೆ ಹೇಳ್ತೀನಿ ಅಂತ ಏನು ಅಂದ್ರು ತಗೊಳ್ಳಿ. Respondent counsel seeks time and list this matter on in the second week of August. Passover ಇದೆಯಾ? ಯಾವುದು?
serial number 80.
80. ಸೀನಿಯರ್ ಇನ್ನು ಮುಗ್ದಿಲ್ವಾ?
ಒಂದ್ರಲ್ಲಿ ಅಲ್ಲೂ ರೀಚ್ ಆಯ್ತು ಅಂತ. ಒಂದ್ರಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಡೀತಾ ಇದೆ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಲ್ಲ ಇದಾರಾ? ಆಯ್ತು, ಯಾವತ್ ಬೇಕು ಹೇಳಿ.
ಟುಮಾರೋ
ಇಲ್ಲ, ನಮ್ದಾಗ್ಲೇ ಲಿಸ್ಟ್ ಆಗೋಯ್ತು. ಮಂಡೇನ ಟ್ಯೂಸ್ಡೇ ಆಗ್ಬೋದಾ?
16th.
For want of time, list this matter on 16th.
ಎಂಟ್ರಿ ಮಾಡಿದೆ ಸರ್, ಎಂಟ್ರಿ
granted, earlier is extended.
82.
ಇದೇನ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ವಲ್ಲ, ಅದರ್ ಸೈಡ್ ಬಂದ್ರ? ಅನಂತ ಕೃಷ್ಣಮೂರ್ತಿ.
In the morning I was there, in the afternoon when the court I was like.
afternoon ಇರ್ಲಿಲ್ಲ,
ಸ್ವಲ್ಪ ಲೇಟ್ ಆಯ್ತು.
ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ ಅಂತ ಅನ್ಕೊಂಡ್ವಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಆಗ್ಬೋದು.
ತಗೊಳ್ಳಿ, ಫಾರ್ want of time list this matter next week ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್.
18/7.
18/7.
22 ಆಗ್ಬೋದು. 22.
22nd ಆಯ್ತು. 22nd. 83 ಒಂದಿದೆಯಾ?
Depositions are not available online, not in the e-courts website. Your lordship, lord, if it is not difficult, call for records, ನಾನು ಇಲ್ಲೇ ನೋಡ್ಬಿಟ್ಟು ಇಲ್ಲೇ make submission. If it is
ಎಲ್ಲ ಸರ್ವ್ ಆಗಿದೆ ಅಲ್ಲ ಇದರಲ್ಲಿ?
ಅಲ್ಲ, ಸರ್ವ್ ಆಗಿದೆ. Everybody, they have remained, they have not appeared yet.
ಆಯ್ತು, ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್.
Great.
List in the second week.
But some date.
Second week ಕೊಟ್ಟಿದ್ದೀನಿ. Second week. Great. ಮುಗೀತಾ ಮೇಡಮ್? ಇವತ್ತೇನು ಡಿಸ್ಪೋಸಲ್ ಇಲ್ವಾ? Two hours ರಿಪೇರಿ ಕೆಲಸ, 12 hours.
1, 2, 3 ಅಂದ್ರೆ ಲಾಸ್ಟ್ ಮ್ಯಾಟ್ರು ಇದು ಸೆಕೆಂಡ್ ವೀಕ್ ಆಪೋಸಿಟ್.
ಅದೊಂದು ಭಯ ಇದೆ.
ನೀವು ಈ ತರ ಹೇಳ್ತೀರಾ, ಕೆಲವರು ಅಫಿಷಿಯಲ್ ಹೇಳ್ತಾರೆ ಎಲ್ಲ
ಕೆಲಸಲು ಒಂದೊಂದ್ಸಲ ಮಿಸ್ಟೇಕ್ ಆಗ್ತದೆ, ತಪ್ಪು ತಿಳ್ಕೊಳ್ಬಾರ್ದು ಅಂತ. ಎಲ್ಲರೂ ಪಾರ್ಟ್ ಅಂಡ್ ಪಾರ್ಸಲ್ ಅಲ್ಲ, ನಾವು ನೀವೆಲ್ಲರೂ ಪಾರ್ಟ್ ಅಂಡ್ ಪಾರ್ಸಲ್ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ. ಯಾವ್ದ ಕೋರ್ಟ್ ಫೀ ಬಗ್ಗೆ ಇರ್ತಾರೆ 26. ಅದೇ ಅವ್ರನ್ನ ಕರೆಸಿದ್ರು, ನಮ್ಮನ್ನು ತಪ್ಪು
ನಂಬರ್ ಬಂದಿದ್ದಾರೆ ಏನಕ್ಕೆ ಪೋಸ್ಟ್ ಆಗಿದೆ ಅಂತಾನೆ ಇಲ್ಲ INS ಅದೇನೇ ಇಲ್ಲ ಏನು ಕಳಿಸಿ ಬೇಗ ಏನ್ ಅನ್ಕೊಂಡಿದ್ದಾರೆ ಒಂದು ಲಾಸ್ಟ್ ಅಂಶ ಅದು ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಅಂತ ಹೇಳಿದ್ರೆ ಲಾಸ್ಟ್ 123 ಅದೇ ವಿಜಯ್ ಕುಮಾರ್ ಅವರೇನೋ ಬೆಳಿಗ್ಗೆ ಕೇಳಿದ್ರು ಅವರು ನಿಮ್ಗೆ ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಆಗಸ್ಟ್ ಅವ್ರು ಬೆಳಿಗ್ಗೆ 10:30 ಮಾಡಿದ್ರು ನಿಮ್ಗೆ ಹೇಳಿಲ್ಲ ಅಂತ ಅಂದ್ರು ಹೇಳ್ಬಿಟ್ಟು ಬನ್ನಿ ಅಂದ್ರು ಇವಾಗ ರೀಚ್ ಆಯ್ತಲ್ವಾ